all of them in. Okay. Commissioners, those who are not in their places yet, let's all take our places. We need to gallop this morning. Good morning, good morning. Yeah. Morning, 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 morning. Where's the minister? I'm told the minister is 5 minutes away, but there are still empty Thank you. The minister has arrived now. Secretariat, you can call in the candidate. Good morning, Mr. Dodson.
Good morning, Chief Justice. Good morning, Commissioners.
How are you this morning?
I'm well, thank you. And how are you, Chief Justice?
We are all right. I'm responding on behalf of everybody. Thank you very much. Let me begin by welcoming you to this interview and thank you for making yourself available for this interview and making yourself available as a candidate for a position in the Constitutional Court.
You're welcome.
I think that I must also mention that I thank you particularly that despite the fact that you have been before this body quite a few times, you continue to be prepared to avail yourself and come and be a candidate and come for interviews. I appreciate that very much.
You're welcome, Chief Justice.
Because you have been before this body quite a few times, and most of the commissioners have interviewed you before, although there might be one or two who haven't. The way I'll run this interview will be on the basis that most of the commissioners know you. They've read your CV a few times even before this interview, and they are quite familiar with your career, with how your career has progressed for you to be where you are. So I will work on that basis. However, I must immediately say that when I say that none of the commissioners who might not have interviewed you before must feel that they are not entitled to know you fully. So they are still entitled to know you fully as well. So I will leave room for that. Thank you very much. I'm not going to explain some of the rules that I sometimes explain because you know them, because you have been here before. I'm not going to go through your academic qualifications. They are in the questionnaire. We know them. I will then indicate that after university, you did articles and you got admitted as an attorney. Is that correct?
Yes, that's correct, Chief Justice.
And after 94, you were appointed as a judge in the Land Claims Court for a term of 5 years, which you served fully. Is that correct?
Correct, Chief Justice.
And during that time, as a judge of the Land Claims Court, you produced numerous judgments which got reported. Is that correct?
Indeed, there's a list attached to my CV.
There is a list in the CV, yes. And actually, you have also written extensively, if I recall correctly, in terms of academic articles. Is that
Reasonably
correct?
extensively.
Reasonably extensively, yes. No, thank you. And after you had finished your term as a judge of the Land Claims Court, you then went to do pupillage and were admitted as an advocate. Is that correct?
Indeed, Chief Justice.
And that was in the early 2000s when you got admitted as an advocate. Is that right?
Correct, Chief Justice.
And you got conferred with silk status about 10 years ago. Is that right?
I think it's 13 years ago
About
now.
13 years ago. So you have been silk for 13 years.
Yes.
And during your time as counsel, you have done a lot of matters which involve constitutional law, administrative law, land claims matters, and commercial matters. Is that right?
Yes.
Have
On
I
a quick-
left out something, another branch of law?
I couldn't hear the last question, Chief Justice.
Have I left out another branch of law in which you practice?
I've done a fair amount of labor law.
A fair amount of labor law. Did you also act in labor law, or was it in the competition appeal court?
No, I acted, I think, for 2 weeks in the labor court.
Oh, okay. Yes. And you have acted in the High Court a number of times. Is that right?
Indeed, Chief Justice.
Have you produced any judgments during your acting stints?
Yes, I have. And
Yes.
there is a list of the reported ones. The list is one short. That LW judgment, which I included in the pack,
Yes.
has also been reported.
Yes. So although you may not be a judge now, you were a judge for 5 years and you produced judgments that were reported. And during your acting stints as a judge or an acting judge of the High Court, you have produced judgments, some of which have been reported.
Indeed.
Yes. Now, previously, we included your name, if I recall correctly, at some stage among the names that we sent to the president for consideration so that he could pick one of 4. Is that correct?
That's correct. I think it was in 2022, Chief Justice.
Yes. So obviously, this body would have concluded that you were suitable to be appointed to the Constitutional Court for it to include you in that list. That's at least how you understand the legal position to be.
That is how I understand it, Chief Justice.
Yes. Since then, one of the things that has happened is that you have been given an opportunity to act in the Constitutional Court. Is that correct?
Indeed.
We'll talk about that just now. Is there anything that has happened to your knowledge since then up to now that could negatively affect your suitability?
No, Chief Justice.
Yes. Now, you got an opportunity to act in the Constitutional Court in the 4th term last year. Is that correct?
Indeed, Chief Justice. And again, the first term this year.
And again during the first term. Thank you very much. I'm just reminded that there is some objection that we will deal with in due course. I think that's in relation to the question whether anything has happened since then which may negatively affect your suitability. That issue will be raised and you'll get a chance to deal with it. When you got the opportunity to act, you acted in the 4th term last year and in the 1st term this year in the Constitutional Court. Is that right?
Yes.
Please share with the Commission what your impressions were of the work of the Constitutional Court and whether you enjoyed acting and how you found the work to be.
It was an enormous privilege to spend 2 terms acting in the Apex Court, and I'm most grateful to have been afforded the opportunity. It was intellectually challenging in a good way, in a thoroughly enjoyable way. I enjoyed the hearings. I particularly enjoyed the insight into en banc decision making. The most I've been exposed to previously was in full bench appeals in the High Court, and it was fascinating and interesting to see how en banc decision making works, where you're dealing with, at the time that I was acting, 10 judges working together. I was also comforted by the fact that I was able to fit into that decision-making process, notwithstanding the particular path by which I arrived at those acting opportunities. At a collegial level, the judges there were extraordinarily welcoming. They were very egalitarian, treated me with great respect and as an equal with them.
No, thank you very much. You have not been able to produce a judgment, is that correct?
That's correct, Chief Justice, in the
Yes.
sense that one hasn't been handed down. I've
Yeah.
got one that is about to be handed down, and another one that is at the read-through stage. Which means that it's very close to hand down.
Yeah. Well, I can just confirm to the commissioners that the fact that none of your judgments has been handed down has really not been because you have not been applying yourself properly to the work, or that you have not been diligent. You have been very diligent and you have been applying yourself. It's simply that because you were sitting with so many other judges, the process does take some time before a judgment gets ready. But I'm aware that one is about to be handed down.
Thank you, Chief Justice.
Yes, thank you. Now, so having acted for 2 terms, you still feel that that's where you would like to be, namely the Constitutional Court?
Indeed, and not just a case of still, I think a case of all the more so.
Yeah.
Having spent 2 terms there and having fitted in comfortably there.
Yes. No, thank you. Now, of course, in your practice, you have done many constitutional cases in the Constitutional Court and in the higher courts. And of course, having acted for 2 terms, you have also been party to many matters that have been heard during the 2 terms in the Constitutional Court, which raise various issues, including how you deal with orders of invalidity and so on and so on. Is that correct?
Yes.
Yes. Now, I just want you to share with the commissioners what comes to your mind as issues that you must apply your mind to when in a matter involving the constitutional validity of legislation, when you have concluded that an order of invalidity must be made. What other issues should immediately come to your mind as issues that you must apply your mind to?
Well, as a starting point, you would, in terms of Section 172(1)(a), be mandated to declare the legislation to be constitutionally invalid. That would be the starting point. You then move to 172(1)(b), and there you would then deal with the consequences of that declaration. And that would be particular to the circumstances of each case. And the criterion is that a just and equitable award must be made. One would have to think of the impact of the order there on the parties. One would have to think of the impact of the order more widely, and that may result in various things. It might be that, for example, that the order can effectively follow suit from the declaration of invalidity, and retrospectively the legislation could be left invalid without more, or the court might prefer to limit the retrospectivity of the order of invalidity and only make it prospective, for example. And then the court might also wish to consider whether they suspend the order of invalidity while Parliament is given the opportunity to correct the shortcoming. And it may also be that the court will devise an interim regime which will apply during the period that Parliament applies their mind to the matter.
And thank you very much. And when would reading in and when would reading down arise in a matter, a constitutional matter?
I think it's best to start with reading down, because reading down wouldn't involve an order of invalidity. It's an interpretive device in respect of legislation to try to read it in keeping with the Constitution and to avoid having to make an order of invalidity. Obviously, it mustn't stretch the limits of the language, but that is a possible solution to a constitutional problem. That would be reading down. Reading in would be a mechanism in circumstances where there is a finding of constitutional invalidity, and there is then a need to decide: does one simply strike it down completely, or does one repair the flaw, as it were, by reading in additional words to bring it within the realm of constitutionality?
And do you want to say something about the principle of subsidiarity?
In the context where the Constitutional Court is working, it essentially says that where a fundamental right has been embodied in the form of legislation by Parliament, that is the focus of attention or the focus of attack. It's around the legislation that the attack and the decision-making of the court must take place. You don't look immediately to the constitutional provision that lies behind it. Obviously, if you were challenging the validity of legislation, then you would be testing it against the Constitution.
And the Constitution provides for the jurisdiction of the Constitutional Court in various ways. One of them is that in regard to certain matters, it provides for the Constitutional Court to have exclusive jurisdiction. Do you remember one matter or two matters in respect of which the Constitutional Court has got exclusive jurisdiction?
Well, it would be, there's a list, but the most important ones are where the president, where the court is concerned with a constitutional obligation of Parliament or the president.
And Section 177(1) of the Constitution provides for 3 grounds upon which a judge may be removed from office. 2 of those grounds are gross incompetence and gross misconduct. That means that mere incompetence and mere misconduct is not enough to remove a judge from office. That might sound extraordinary to people. What is the constitutional significance of that provision that makes gross incompetence, gross misconduct to be the grounds of removal for judges?
The provision is there to protect the independence of the judiciary and simultaneously to protect the separation of powers between the 3 branches, the legislature, the executive, and the judiciary. The risk, if you don't have a provision like that, is that the legislature, for example, which has the ultimate power, might be tempted to make allegations of mere incompetence, for example, or mere misconduct, in order to remove a judge who's making unfavorable decisions. So that's essentially the reason that you have that provision.
Yes, no, thank you. And lastly, what can you share with the commissioners about what actual severance is and what notional severance is?
Well, severance is similar, performs a similar function to reading in. If one is looking at a solution to a constitutional case or a constitutional problem that doesn't involve simply striking down the relevant legislation in its entirety, you might be able to look to particular words in the statute and see if you could sever them from the statute without destroying the underlying purpose of the statute, but at the same time solving the constitutional problem. So, briefly said, simply deleting a word here and there to bring it within the field of constitutionality. Notional severance would be used where severance doesn't work, but you also don't want to strike down the provision in its entirety. So your order might say, to the extent that the legislation in question has X outcome, that must be ignored. So, I mean, an example might be where, which has come up, where evidence that's elicited in a particular forum, there might be a provision that says that incriminating evidence is admissible, and that might be in conflict with Section 35 of the Constitution. So one might say in an order, to the extent that that provision might be read as allowing the use of the evidence in criminal proceedings, it is unconstitutional, and to put it colloquially, you may not go there, you may not use it. And adding those words, to the extent that, at the beginning of the order, would have the effect again of bringing it back within constitutional bounds.
Thank you. Minister?
Thank you very much, CJ. Good morning, Advocate.
Good morning, Minister.
Yes, the last time you were here, you told us that you were one of the first land court, the first group of the land claims court judges.
Yes.
So I just want to get from yourself, you are now aware that the Land Claims Court Act has been amended or repealed to give way to the Land Court.
Yes.
And it will be operational very soon.
Yes.
On the benefit from your experience when you started with the court, what is it that you think that court could benefit from people like yourself who were there when the land court was started? And what could be the difference now that you will expect the court in terms of the land justice issues that the country is seized with?
So I'm understanding your question to say, what difference does the new act make? How might it benefit land adjudication?
And what do you think the new judges can learn from yourselves who were there when the land court was started, the land claims court?
So I think one of the most important things is it's brought certainty to the institution of the land claims court. And that's been something that's been a hiatus for, I don't know, since I left there, 24 years. And it's good to see that in this round of interviews, people are up for appointment to positions in the land court. And so I compliment you and I compliment Parliament on that legislation and bringing it through. And I know it's taken a lot of initiative and hard work from your side. what is good about the statute, and I hope it isn't necessarily the end of a trend, is that it brings within the jurisdiction of the land court additional legislation which wasn't available, as it were, to the land claims court, such as, for example, the Land Reform Provision of Land and Assistance Act, and the Upgrading of Land Tenure Rights Act, and as I recall, one or two other statutes. And I think that will allow for a more coordinated approach to land issues from one judicial institution. It's also formalized, as I read it, a full court system, so there can be full court appeals within the court, which I think will also help with the jurisprudence. For me, one of the, and this I think is advice that I would give to, as you put it, to the judges who are being appointed, I think one of the aspects that has real potential is the fact that they have jurisdiction under the Land Reform Provision of Land and Assistance Act of 1993, because I think some of the provisions of that act can potentially be used to provide for the missing leg of land reform. So the missing leg of land reform statutorily has been redistribution. There's legislation to deal with restitution. There's legislation, substantial legislation to deal with tenure reform. There's always been a shortfall, and in fact, there is still a shortfall as far as land redistribution is concerned. But, and I say this prima facie, and if I were to be appointed to the Constitutional Court, I might come to a different view if a matter came before me. But on a prima facie or preliminary basis, I think there is some potential, particularly in Section 10 of that Act, to address the land redistribution problem.
Yeah, my last question relates to what one of the current justices of the Con Court, when we interviewed him here, Justice Matapo, suggested that he believed could elevate or help for expedition of matters to be adjudicated as quickly as possible by the Con Court, that we should merge the Supreme Court of Appeal and also the Con Court, and it should work the same way the Supreme Court is currently working, kind of in chambers. So you will understand the language. I heard you speaking about unbanking. I suspect is the opposite of that. Have you considered such a view, or what do you think? Can that help in terms of access to justice for litigants?
I'm not sure that I heard all of your question, but I think you proposed the concept of a merging of the two courts as a means of expediting adjudication and improving access to justice. Is that correct?
Yes, it's not me proposing it. It was Justice Matapo when he was being interviewed. But you are correct. That is the proposition.
I think if something is more or less working, I don't think one must try and fix it or change it. And I think that it is more or less working, the current system. I think that if one looks at the adjudication of all of the respective courts at the different levels, which is something I've had an opportunity to do now while I've been acting there, each has its particular role to play. The advantage that the Constitutional Court has is that they have a limited jurisdiction when it comes to things, for example, like adjudication on factual issues. They don't get involved in purely factual appeals or disputes. And the Supreme Court of Appeal has the capacity to deal with those kind of disputes and to deal with them well. And they have the additional advantage of being able to spread that work, which inevitably is a larger number of cases across panels of the court. They work in panels of 5 or 3. I think that particularly if you look at the history of the Constitutional Court, it was something that arose out of our apartheid past. The parents of the Constitution, as it were, wanted to have a final adjudicative body that was representative and that would make considered decisions on the Constitution and its interpretation and the legislation. And I think that there remains a specialist role of that sort in the Constitutional Court. I wasn't a fan at the time of the expansion of the jurisdiction of the Constitutional Court to include its general jurisdiction. But I've changed my mind. Having been at the court, I've seen that it can work, and I think it can play a meaningful role in relation to developing the law on specific legal questions that are placed before it that go beyond purely constitutional issues.
There was some interference. I don't know where it comes from. Secretariat investigate so that we don't have a repeat. Okay, you may proceed.
Perhaps just to finish off, there are some changes that are needed, though, specifically to Section 1672 of the Constitution. What isn't working at the moment at the Constitutional Court is the requirement that the court sits en banc also for adjudicating applications for leave to appeal in particular. There, they should be able to have the same arrangement that the Supreme Court of Appeal has in terms of the Superior Courts Act, to be able to deal with applications for leave to appeal in small panels of 2 or 3. That's urgently needed in the Constitutional Court, and given the Constitutional Court's case law, that can only happen through an amendment of the Constitution.
Thank you, CJ.
Thank you. Justice Mulumela.
Thank you, Chief Justice. Good morning, Mr. Dodson.
Good morning, President Mulumela.
Just following up on your last response in relation to the tremendous increase in the workload of the Constitutional Court and your suggestion that a constitutional amendment might be necessary to enable that court to work in panels of judges, do you think that increasing the complement of judges at that court, which would also obviously require a constitutional amendment, would alleviate the situation in relation to that workload?
It might alleviate the situation, but I don't think it is the solution. I think that there is merit in that design. The numbers on the court are already more than other apex courts around the world. And I like and appreciate the original conception of the court on that basis, a court of 11 judges. So I wouldn't advocate for an increase in the number of judges, but I would advocate for both the amendment to provide for panels as well as an increase in the resources of the court. You know, when the court's jurisdiction was expanded to a general jurisdiction, which inevitably meant a much bigger caseload, I don't think a single resource was added to the court. There was a visit while I was acting at the Constitutional Court from the Chief Justice of Canada and one of the judges on that court. And it was interesting because they have 9 judges in their Supreme Court, and they have a similar caseload. They have a caseload of about 400 coming through the court each year of applications of various sorts. I think the Constitutional Court is around about 360, 370 at the moment. I don't know the exact figure. They have, A, the ability to sit in panels as far as applications for leave to appeal is concerned, B, the ability to sit in panels as far as the hearing of actual matters that are set down is concerned, C, they have what they call the law branch assisting them. It's a team of experienced lawyers, some of them up to 30 years experience, 21 lawyers who are available to the court to assist with preparing memoranda and providing assistance to the judges. That is apart from the 3 research clerks that each of the judges has. So the Constitutional Court has been left behind in terms of the provision of resources to that court. And in my view, that's the solution. Provide the court with additional resources to recognize the expanded jurisdiction, which was several years ago, and urgently needs to be attended to with respect.
Yes, thank you. As the Chief Justice has pointed out that you have previously been interviewed by this body before, and the transcript of your previous interviews is available. So my starting point would be that you'd agree that there's no doubt that you are already widely experienced as a lawyer.
Yes, I've been in practice or judging for between 37 and 38 years.
Yes. So what has happened between the last interview and today's interview is that you have now acted for 2 terms at the Constitutional Court. Is that right?
Yes,
Which would that mean that your general profile has been enhanced because you have been exposed to a variety of matters covering all the branches of the law, not only in your hearings, but in your participation in the various applications in that court?
indeed, President Molamela.
Okay, thank you. My last question is, what do you think is the justification for the requirement in terms of Section 172 that any declaration of constitutional invalidity by any other court, be it the High Court, the Supreme Court of Appeal, must be confirmed by the Constitutional Court? The rationale for that?
I think the rationale for that is related to the separation of powers. And it is an indication of respect for the separation of powers, in particular between the legislature and the judiciary. And I think it's to promote comity as between the legislature and the judiciary, and a mark of respect that that confirmation would have to happen at that level for it to be effective.
Thank you very much, Mr. Dodson. Thank you, Chief Justice.
Judge President Lambo.
Thank you. Good morning, Advocate Dodson.
Good morning, Judge President.
I just want to check your thinking about what I'm going to raise with you. More often than not, judgments from the Concord are delayed, not because the justices there are not doing their utmost to expedite things, but one of the reasons is that court is flooded. I don't know whether I should say by or with petitions. I'm an African, so English is a fourth language to me. So I just want to understand what your thinking is about how that can be resolved. My take is most of these petitions that go to the Court can and may be effectively resolved by the Supreme Court of Appeal to start with, and by full courts in the high courts. So I want to know whether you think there would be any benefit if that court were to be strong in terms of granting leave to itself or granting leave to the SCA, where the SCA has not had that matter but simply refused the petition to it. I don't know if my question is clear.
The last part I struggled a bit with, I must confess. I understand that there, indeed, and you're quite correct, that there's a problem in relation to an avalanche of applications that are going through to the...
Let me just explain it.
Yes.
A number of the petitions that go to the Concord come from the SCA, where the SCA has refused leave.
Yes.
So I'm saying, is there any benefit if the Concord would grant leave but refer it back to the SCA to deal with the matter?
Yes.
Because I think the CC would benefit a lot with matters that have been dealt with and determined by lower courts, in the same way as the US Supreme Court does things.
Yes, I think that's an eminently sensible suggestion, and I can't say that I saw anything being remitted to the Supreme Court of Appeal during the period that I was there. But also to give you an indication, there were literally less than a handful of matters that actually reached set down. So what one is finding at the Concord is that most of the time the Concord is in agreement with the Supreme Court of Appeal. both when they give judgment and also when they refuse a petition. 9 times out of 10, the Constitutional Court concurs with the Supreme Court of Appeal. So from that point of view, I don't think it's going to make, because they concur, I don't think it's going to make all that much difference. But certainly there are some matters, I think, that might have been set down in the Constitutional Court that could have been remitted to the Supreme Court of Appeal. And in one matter, we would be prevented from going into details because the matter's pending. But it is, let me put it this way, it's an issue that's been discussed.
I see. My last question is, the role of the ConCourt, one of its objectives is to clarify and stabilize jurisprudence in the country. Now, what's your view about the length of time that justices of that court should ideally serve? I see that if you are appointed, you'll be there for just over 11 years. Would it benefit the country if you'd have a cohort of justices who serve quite a longish period together?
Yes, most certainly, because if judges aren't there long enough, they accumulate the institutional memory, but then as they go, they lose it. So yes, my short answer is I agree with you. I agree with you fully. I'm not quite sure how you resolve it, but what it does suggest is that if you're thinking about people who are coming from the ranks of judges, it means they need to be getting there sooner. That seems to me, from that perspective, to be the only way of getting there. If one applies Section 174(5) to include people like me, for example, that might also provide opportunities for people to get there in time to spend a good chunk of time on the court. I think perhaps the difficulty is that for High Court judges, they have to wait their turn, as it were, to act in the Supreme Court of Appeal. And there are a lot of High Court judges, and there are only so many positions to act in the Supreme Court of Appeal, and they've got to wait their turn. And possibly if that could be considered, it may be that you would be able to get High Court judges coming through the system earlier, both into the Supreme Court of Appeal and then on into the Constitutional Court.
Thank you, Advocate Dodson. Thank you, CJ.
Before I go to another commissioner who will ask questions, let me do a follow-up to Judge President Lambo's first question. Isn't the problem that causes delays in the Constitutional Court this, that one, you have an increased volume of cases that must be dealt with. Two, you have the same number of judges who had to deal with a lower volume many years ago. Three, each of the 11 judges must take part in all the matters that need to be dealt with. Whereas if you look at the Supreme Court of Appeal, it might have, for example, 100 petitions or applications for leave to appeal. But because it is able to dispose of petitions or applications for leave to appeal on the basis of panels of 2. If you have got 100 new applications or petitions in the Supreme Court of Appeal, the 24 or 25 judges in the Supreme Court of Appeal can share that 100 new applications or petitions and divide them by, 12? And with the result that no judge will have will have to take part in all 100 petitions. Whereas in the Constitutional Court, if there are 100 applications, every judge must read all those applications and take part in deciding them, except where we use 8, which is the quorum. But otherwise, all of them must take part. And that then one means for each judge, let's say if it's 100 petitions, if that is 1,000 pages to read altogether, it means in the Constitutional Court, each judge must read all those papers, whereas in the SCA, one judge won't have to read so many. They'll only have to read those that they will be involved in. Isn't that is what takes the time?
Absolutely, Chief Justice. I mean, last night I did some arithmetic thinking about it. I took the example of let's say this. Well, I looked on the website. If you take into account acting judges, the number I counted was 30 judges in the Supreme Court of Appeal. They operate in panels of 2, so you have 15 panels working. So if it was 100 cases, they would each deal with 6.6, or let's call it 7. If it was 1,000 cases, they'd each deal with 66. In the Constitutional Court, each judge is dealing with all 365 of the cases. So in a way, the Supreme Court of Appeal, if they've got 30 judges, has 15 times the resources of the Constitutional Court. The other dimension of it, it's not a big contributor to it, but the other component of it is that there's another level of decision making that the Constitutional Court has to consider. So they have to, if there's been a judgment from the Supreme Court of Appeal, that also has to be considered by the Constitutional Court judges as part of their papers. And in the Supreme Court of Appeal, each judge simply reads the papers, and they sit together and they come to a decision. The problematic consequence of all this is that I think there's the wrong allocation of time as a result in the Constitutional Court between applications for leave to appeal on the one hand and spending time on judgments on the other hand. But I think it can be addressed, and the most urgent thing is panels. I don't think that on its own will address it. I think there also needs to be an injection of human resources of the kind that I've mentioned.
Of course, the proposals which we have made public are now to address the issue of the inability of the Constitutional Court to dispose of those new applications in panels. So in terms of the proposal, it's envisaged that we could have, if a constitutional amendment is made, we could have maybe panels of 3. I mean, panels of 3 would make 9, and then there would be 2 judges. If, of course, we say, well, let it be a panel of 2, then we could have a panel of, 5 panels at least. Now, we would still be below the number of panels that the Supreme Court of Appeal is able to have. But it could make a big difference, because if it's a panel of 3, it means that instead of, if you have got 300 new applications, instead of each judge in the Constitutional Court having to read and participate in 300 matters, they will participate at least in 100. if you have a panel of 5 on the basis that panels of 2 can dispose of these new applications, then the load comes down even more. And that is what is sought to be addressed. And of course, the issue of resources and getting experienced lawyers to be employed in the constitutional court so that they can do a lot of work like preparation of memoranda and therefore take off the load from the judges, even though the actual adjudication would still be done by judges.
Indeed, Chief Justice.
That's what the proposal says, isn't it? Okay, all right. Thank
Indeed,
you.
Chief Justice, and as you're aware, I contributed towards the
Yes.
process of preparing that
Yes.
statement, and I fully support it.
Yes. Thank you. Commissioner Marmogai.
Thank you very much, Chief Justice. Good morning, Advocate.
Good morning.
When we are interviewing for the Constitutional Court, I'm more interested about what the judge will do as opposed to what the judge has done. And of course, what the judge has done, it's important. I have 2 questions, possibly 3 for you. My first question is in relation to the concept of judicial restraint and judicial activism. There is a sector of the community that says judges don't go far enough. And there are those who are saying judges actually go beyond far enough. I want to understand, in the context of the current legal system that we have, where the courts are continuously called to discuss political issues, issues that have to deal with the decisions of either the executive or the legislature, policy-orientated decisions, budgetary decisions. What should be the approach of the Constitutional Court? Or should it be an individual judge who decides whether he goes into the restrained pocket or the activism pocket, and in line with separation of powers? What should be the actual position, if there is such a thing, of the Constitutional Court?
Well, one would hope that there would be a level of consensus as to the approach to those issues from the court. But of course, an appellate court that consists of more than one judge is designed to ensure that hopefully the best outcome is achieved, even if it involves a majority and a minority decision. I don't think that one can move away from the concept of judicial economy without running into dangers. And that's because of the simple fact that if you don't decide the matter strictly within the ambit of the facts that are before you, you run the risk that another case comes down the line with different facts that demonstrate that to the extent that you strayed beyond the factual dispute, you got it wrong. And you don't want that, particularly coming from an apex court that has nobody above it to correct it. In terms of judicial activism, my own view is that we have a transformational, and if you want to put it colloquially, activist constitution, particularly insofar as it has provided for socioeconomic rights. So I don't think you need to be an activist judge in the way that you might have needed to be in the apartheid era, where you were fighting against laws that were designed to oppress people. And you would need an activist judge who might try to find spaces within that legal regime to defend as best possible human rights. But at the same time, the approach to adjudication must be a transformational approach to adjudication. There are articles based on speeches that were given both by Justice Lange and by Justice Moseneke, which are very helpful from that point of view. And in fact, if you read Justice Lange's article, he specifically warns against the dangers of excessive judicial activism, that you can end up doing more harm than good. I hope that answers your question.
No, thank you, Advocate Dodson. My second question is linked with the first one. When you look at the jurisprudence of the Constitutional Court from Grootboom, Subramani, and then the TAC, which you were part of, and other judgments, it is clear that with respect to socioeconomic rights, the approach has been to take this reasonableness sort of approach. In 1992, Dennis Davis wrote an article where he was arguing against the justiciability of socioeconomic rights. And he pointed out some of the challenges that will arise when these rights are justiciable and they can actually be enforced. And we saw in these judgments some of those challenges coming through. Obviously, I don't agree with his take. But the point that I'm asking, but that I want to engage you on is, while there is this line of reasonableness has been taken, there has also been an idea on the side that actually that is a wrong approach. And the concept of minimum core should be the guiding principle. I just want to get your stance on that. As a judge who will be sitting in that court, as to what is your view with respect to these two seemingly contradictory positions? While we know a clear position from Constitutional Court, we know what it is, but there is this lingering view on minimum core. What is your stance on that debate?
Well, in the TAC case, I was part of the legal team that was briefed specifically to argue for a minimum core of health rights. And that was the basis upon which we argued that nevirapine should be made available. And we didn't persuade the court as to minimum core. I think that the jurisprudence is settled. I think that you can't, at this point in time, given the number of judgments that have applied the reasonableness criterion, start to walk back on that. And I think that is all the more so from the perspective of the separation of powers doctrine. I think that the reasonableness standard is something that works in terms of the separation of powers. The executive and the legislature are used to being tested on the basis of reasonableness, particularly in the field of Pudger, for example. So there's a familiarity about it, and there's a legitimacy about it. Once one strays into the notion of a minimum core, the court is much more directly addressing how resources should be allocated. And ultimately, that isn't the function of the courts. That is the function of the legislature and the executive.
Thank you very much, Advocate Dodson. Thank you very much, CJ.
Thank you, Commissioner Steinberg. Except if there are some on the virtual media, that was the last one on my list, but I see there are requests for more. Okay, thank you.
Morning.
Morning, Commissioner Steinberg.
I have two questions for you. The one is apropos the last question that the Chief Justice was putting to you. Given that we have very finite resources for the judiciary in this country, and given that we know the high courts, particularly the Gauteng high courts, are in crisis from having not enough judges and support, do you think that if the minister pulls a miracle out of the hat and gets more resources for the judiciary, they would be better spent in the high courts or in the constitutional court in the way that you've discussed with the CJ?
I mean, it's a very difficult question. I mean, the obvious answer is both need money spent on them. But let me be frank. The Constitutional Court judges work unbelievably hard. They're often exchanging emails at 1:30 in the morning. They work through weekends. They work through public holidays. judges who are on sabbatical leave continue to work on judgments that are being discussed. They have to attend some of the meetings to discuss judgments. I think they have an impossible caseload. But I'm married to a High Court judge. I know from having acted in the High Court in both Johannesburg and Pretoria that they too work under enormous pressure and strain. So it's impossible to answer. They both need the additional resources. If the resources are scarce, they will have to be divvied up in some way, and both have a legitimate demand. And that's the fact of life with scarce resources. You're never going to get all that you want, but something needs to be done.
But if the Constitutional Court didn't have to sit on bunk every time, and if only 2 or 3 judges were needed to make a decision about applications for leave to appeal, would that not alleviate the workload a great deal?
I think it would ameliorate the workload a great deal. I'm not convinced that it's a complete solution to the problem. Just knowing how much work goes into a lot of those petitions. Some of them are really complex, number one. Some of them require case management. So the case arrives at the door of the Constitutional Court, but there are aspects that need to be clarified. And so a directive goes to the parties to make submissions on a particular point. It'll come back to judges' conference. It'll again be discussed. There'll be a decision, for example, should it not be set down? There's an invitation to then submit final submissions and for the record to be filed and so on. So yes, it will help a lot. It's not a complete solution.
And then my second question is regarding remedial relief and the powers under Section 1721B in particular. Many of us in practice face the problem in advising clients on prospects of success, particularly in public law cases, because of the wide-ranging discretion the court has after declaring a constitutional invalidity to nevertheless allow for it. And increasingly in private law, particularly in the law of contract, where the public policy considerations have been given more weight. So again, it makes advising clients and their prospects of success difficult. I would also suggest it makes life more difficult for high court judges, who then must rely on a very wide set of considerations and factors when it comes to exercising their 1721B requirements. What do you think the remedy for this is? Is there a way of both finding what is just and equitable in a particular case that happens to be before the court, but also creating some black letter law that provides certainty, which of course is a key feature of the rule of law, is certainty for business people who contract or for people who come to court to challenge something on a public law basis?
It's difficult to think how one could, as it were, tie down the Constitutional Court in the exercise of that discretion. I mean, particularly against, for example, precedents like, I think it was Electoral Commission versus Mhlophe, where Chief Justice Mogoeng said that the discretion is wide, and to use his words, he said that judges should not self-censor in applying the discretion under Section 172(1)(b). So I see only two ways out of it. The one is to legislate. So, for example, in the contractual field and challenges on the basis of public policy to contracts, one way of dealing with it would be to legislate it and to try and get a rule-based system similar to what you have in Germany. If you don't have that, then you're going to have to wait for the jurisprudence to build up. And that really is the other option. In preparing for the interview, I read an article by Marius Pieterse from Wits, who looked at section 25 and section 26 and took a holistic view of how the legislation has gone, particularly in relation to the right to housing and cases under PI, Prevention of Illegal Eviction from an Unlawful Occupation of Land Act. And what he demonstrates is that although along the way, because of the very reasons that you give, there has been uncertainty, the jurisprudence has reached a phase where there is a significant level of certainty. And where viewed holistically, the impact on spatial injustice has been substantial from the court. So that option seems to me to be built into the nature of courts. They work incrementally. They build up a jurisprudence incrementally. And yes, it is frustrating. And because of where I am, I sit in the same position as you. I know the frustration. But I think one has to work towards that. I also think that in the way that one writes judgments, one can be mindful of the need, as far as possible, to provide certainty.
In English law, where a judge wants to, having set aside a decision, and if a judge wants to in any way then allow for that decision to nevertheless stand, there's a list of rules or strict guidelines that a judge would need to follow. Is there not room for a development of the law in that direction?
I mean, it would be difficult to, for the reasons given in relation to the professor's questions, there might be difficulty in the courts laying down a set of rules. I might be wrong about that, and I would need to see I'm not familiar with them, and I would need to see them to see what would be your authority for doing them. If the facts of a particular case that came before a court allowed you to lay down a set of rules, then yes, absolutely, and I think it would be a desirable thing. And when I talk about judges being mindful of creating certainty, there are certainly opportunities that come to look at the case law in a particular case and say, this is where we've arrived at, and I'm now summarizing what the law is. And you see that quite often in judgments. In my Cornwall judgment, for example, that's referred to in my list of cases, that's what I did in relation to rescissions of judgment under under Rule 42. So yes, opportunities do come, provided they're within the facts of the case, to do things like that. And so yes, I would endorse what you say if the facts of the case allowed you to do it.
Thank you, Advocate Dodson, and thank you, Chief Justice.
Thank you. Commissioners, we have just finished an hour with this candidate that we know very well, or most of us know very well. I've got two hands of commissioners who want to ask questions, and I know that those commissioners have interviewed this candidate before. I want to say to them, and they are Commissioner Ngwaitobe and Commissioner Singh, I want to say to them, I will abide by their judgment, but I want them to just reflect whether whatever they wanted to ask is really, really important. If they say it is, I will allow them. But I would be happy if they say, no, on reflection, it's fine.
No, Chief Justice, fortunately, I don't fall into that category because I did not interview this candidate.
How? Okay. I apologize.
So I'm sorry, on the rule you've set, I win.
No, you have. I seem to think I could still see you in my mind asking him questions, so I'm very wrong.
No,
that's
but I
fine.
have asked him questions before, but not in this panel.
Oh, okay. Okay, I'll let you ask the question, and Commissioner Singh will let me know after you whether he wants to ask.
Yes, thank you, Chief Justice. I'm not going to keep you long, Mr. Dodson. The first one is just to make sure that you've had a chance to respond to that complaint, stroke objection from the, I think, Mpela community. You know what I'm talking about?
Yes.
Yes. What is your view on it?
Well, I've set out, there was a complaint by a member of the Mpela family, and it came from the Legal Practice Council. I immediately reported it to the Chief Justice because I was, in fact, a sitting judge at the time. I prepared a response and provided a response timeously to the Legal Practice Council responding to it. I immediately made it available to this body to ensure that there was full disclosure to this body. And the complaint, I think, is based in, with due respect to the person involved, perhaps a misunderstanding of the processes. I think the complaint is more against the attorneys and seems to be related to a bit of a breakdown in communication with the attorneys. There's a suggestion that I hid the outcome of a judgment from the Supreme Court of Appeal. There's an allegation that I said that the case was lost in the Supreme Court of Appeal when it was in fact won. We got less out of the Supreme Court of Appeal than we got out of the Land Claims Court, so my advice in that regard was not incorrect. I didn't hide anything from anybody. And if the truth be told, I'm a bit hurt by the complaint. I know that one should have a thick skin about these things, because I achieved extraordinary things for the Mpela family. They were successful African tobacco growers and other crops who ran an irrigation farm on the banks of the Crocodile River near Tabazimbi. I acted for them for free. Our case was met with enormous skepticism. People couldn't believe that African people could be successful irrigation farmers. I arranged to get the aerial photography from the 1930s. We proved that there was irrigation farming going on. From the aerial photography, the land was still wet from the irrigation. The case was difficult. They'd been awarded market value compensation at the time. It was a reason to abandon the case. I said, let's carry on with the case. Let's find a way. Let's use our ingenuity to try and get a solution. And ultimately, we were successful. The community retained the farm that they'd bought with the compensatory money. They didn't have to give it back, as the Restitution Act provides for. They didn't have to give any money back. And in addition, they were ultimately awarded 86% of the other farm that they lost for racially discriminatory reasons. So it was a result that I'm extremely proud of. And I don't have anything to apologize for or answer for, frankly, in relation to what took place there.
Yes, thank you. We looked at it at the Objections Committee. We thought it had no merit. In fact, when you look at what you achieved, it was actually quite extraordinary.
Thank you.
The next question this was not a question, so I still have two questions. My first question, I was interested in the conversation you were having with the Chief Justice about why the Constitutional Court is not producing judgments timeously. There is an article by Norina Ali and Leo Bonzia. They point to two other reasons, because they trace the decline in the speed of judgment production from 2013. And they say, it's correct what you say, the expansion of jurisdiction of the court, which is what the Chief Justice has been saying, that has been a factor. But they point to another factor, which is in 2013 was in fact the last year that the court had its full quorum, C-O-R-A-M. So it has not functioned with 11 full-time appointed judges. And so it's, even on the current resources that it has, it's always operating under capacity, which is something that we can solve without doing all of these things. Let's change the constitution here. Let's change that clause. The appointments are within our control. Do you have any comment on that?
I agree with you as long as you don't offer it in any way as an alternative to panels and an amendment of the Constitution to provide for panels. I agree fully. It's gone on for too long that they haven't operated. It's almost become the norm for it not to have its full complement.
Yes, and absences. They also point out to absences in the court that even those judges who are available. So firstly, we've got a problem that the positions are not being filled by us. But then those positions that are filled, there are absences there. And that, again, is something we can solve.
Yes.
Now, the next question, the final question I want to ask you is, I was interested in this conversation that was going on yesterday with Professor Bilchitz about what, in fact, is the vision of the Constitution for the. The reason I ask you this, is that you see, I came across an article in 2022, in fact, a letter by the former Chief Justice Arthur Charles Wilson to Judge Kirk Cohen, who was the Judge President of the Transvaal at the time. It's a 1994 letter. And this is what it says. I just want your comment on this. It says that, so he's being congratulated for being the president of the court, so he's responding to accept graciously the congratulations. But then he says, and then Kirk Cohen says to him, we're going to help you, to build this court. So he's trying to say, no, I don't actually need your help. He says, we will start with a clean sheet with no precedent to bind us. And we will have the responsibility of giving life and substance to the provisions of the Constitution. So I just want to ask, whether that vision in what you have seen, given specifically your time as a practitioner and as an advocate, whether in fact we are building the new Constitution, or what we have done is to just revert back to old precedent, particularly in areas like contract, property, delict, and crime, which was the core areas of the common law. Because sometimes I fear that instead of building a new jurisprudence for a new country, it's much easier for judges to just see what the judge said in 1956 and just apply that. And given that you've had to apply a new statute, the Land Restitution Act, and where you truly had no precedent and you were operating from a clean slate. So where are we in this debate in the Concord of, actually this is a court for a new constitutional order, and it is not a court that is merely intended to regurgitate vices of the common law?
Thank you. That's a very thoughtful question. The system of precedent has upsides and downsides. I think it was Professor Alan Dershowitz who said that the way that you argue and win cases is by persuading the judge that somebody thought about this long ago, and it's already part of the law. But there's a downside to that, because there is a gravitational pull of the existing body of case law, a strong gravitational pull. And I acknowledge that, and I accept what you say. And there is always a danger that that gravitational pull impedes progress and transformational adjudication. The test is ultimately, are we achieving an equal society? That has to be what everybody strives for who is in decision-making positions, whether it's in the legislature, the executive, or the judiciary. We have to strive towards a society that is more equal. And for as long as we live in a society that isn't equal, between those three branches, we are falling short. And I think we need to take that into account as something that inspires us towards rethinking, whether all the time rethinking whether we're on the trajectory that was set for us, and to be careful and to be mindful of that. And if one does that, then I think one can keep that trajectory going. Taking it specifically to the Land Claims Court, I think we got some things right and some things we didn't get right in moving from that clean sheet, and it may have been, in some respects, the gravitational pull of precedent that inhibited us. But I think all one can do is to come back to the concept of transformational adjudication, and in every case that you consider, to think, am I being pulled in the wrong direction here by precedent? Is there another direction that will be consistent with precedent, but that will achieve the transformative goals of the Constitution nonetheless?
Yes, I suppose I was trying to get you to commit to your own vision of the Constitution as a manifesto of transformation or as an instrument to bring certainty.
I just couldn't hear you, I'm sorry.
I suppose I was also trying to get you to commit, if you want, or maybe not, about your own vision of the Constitution as either a manifesto of transformation or as a legal instrument to bring certainty, because those two are in tension, particularly in the areas of the common law. And I want to know what your own vision is about what the vision of the Constitution is.
As you've seen from my answer, I acknowledge that tension. But my own vision of the Constitution is that it must ultimately serve the purpose of attaining an equal society. And every component of it that we interpret and apply must have that in the background as the ultimate goal to be attained by everybody involved. And of course, it imposes a duty beyond simply the judiciary. It imposes a duty on the other branches of government, but it also imposes a duty on legal practitioners. So, for example, to give perhaps a concrete example of my own vision, I have acted for over a long period of time for the Department of Health in the Eastern Cape. I've seen the incredibly damaging effect of massive lump sum damages award on the health budget. Somewhere between 80 and 90% of people in the Eastern Cape are dependent on public health care because they're too poor to afford anything else. Massive billions and billions of rand are being taken out of the budget to satisfy claims in respect of a small number of people, and around 25% of that money goes as legal fees in those cases. So I've come to the department, got me involved in one case, and I said to them, let's rethink, let's look at what the opportunities are that the Constitution provides, and let's rethink the approach to damages. And we won a case recently in the Eastern Cape, which has completely changed the lump sum damages rule. The lump sum damages rule was established 300 years ago. And we also changed the rule that damages must sound in money and can't be paid in kind. And we established it on an arbiter basis in the Constitutional Court in two cases, the DZ case and the PN case. They said, come back with a properly pleaded, properly evidence-based case, and we'll think about taking this beyond an arbiter. And we've done that. We put an enormous amount of effort into preparing a case and bringing it to the Eastern Cape Court. And they've now done what DZ invited. They've said yes, and they've developed the common law to provide different systems of damages, which impose very, very strict, allow for payment in kind by the department to provide the healthcare that's required for an injured child who's been a victim of negligence at the hands of the state. But ensures that there's the proper supervision as far as that is concerned. And that frees up billions and billions of rand. So that's what I would bring. I would bring that approach. I see a huge opportunity in terms of Section 172, in terms of Section 39 to develop and in terms of Section 173, to develop the common law in a way that achieves a more equal society. And because I won't be able to sit in that case were I to be appointed, but had it not been me who brought the case, I would certainly have decided the case in my favor, if I can put it that way.
I think many of us
Yeah, we
would
all
have decided
yeah.
cases in our favor. Thank you, Chief Justice.
Thank you, thank you. Before I go to Commissioner Singh, I just want to do a follow-up to Commissioner Ngwatobi's question that is based on some article by some authors who say, from what he has said, another reason for the delays is when vacancies are not filled in the constitutional court. I want to put something to you. I mean,
Yes, Chief Justice.
there's no doubt every institution should operate with a full complement for as long as possible, and of course, over the years, we have struggled to attract in sufficient numbers suitable candidates. That's part of the problem. But when we talk about new applications, the fact that there is one vacancy that has not been filled or two vacancies that have not been filled, does that reduce the number of applications that each judge must read?
No, Chief Justice, it doesn't.
If there are 300 new applications, all those judges, each one must still read 300 applications.
Indeed, and all the Constitution does to say that figure of 8 is a minimum. The principle is that it's en banc decision making. All the judges must participate in each decision, and that's confirmed in the two judgments. Just to give a bit of background, when I arrived at the court, I thought that perhaps the justices of the court were taking too conservative an approach to Section 167(2). And then I, in fact, prepared a memorandum and went and did some research on it. And there are two binding judgments of the Constitutional Court that cement en banc decision-making. They were both judgments that arose out of the litigation in relation to Justice Slaughter, and they confirm, even in relation to applications for leave to appeal, it's en banc decision-making. So, sorry, it's a long answer, but yes.
No,
Chief
that's
Justice.
all right. Commissioner Singh?
Thank you very much, Chief Justice. I'll be very brief, but it's a follow-up question, not a new question.
Thank you.
Follow-up question to Commissioner Ngwatobi. Good morning, Advocate
Good morning,
Thompson.
Commissioner.
In your last interview, one of the commissioners asked you a question that arose from a comment from a law body. It was Nadel in particular.
Yes.
Where I think they averred that the philosophy, they feel that you're not according to the values and principles of our Constitution. That's what they said. And your response was, this statement is a mystery to me, and I think it is very, very unfair as no information was given. And I have never heard of any criticism of that sort ever. Now, they've repeated that comment now for this application that you. Has anything changed? So my direct question to you would be, in your own view, and I know the response you gave to Commissioner Ngwatobi, have you furthered the principles and values of our country's Constitution throughout your career and your judgments, and have you given effect to the transformative nature of our Constitution? Are there any examples that you can cite? Thanks.
So the complaint, what I did this time is firstly I wrote back to the Judicial Services Commission Secretariat, and I said, please could you speak to Nadel and ask them what the source of this allegation is. And the Secretariat said they don't get involved in correspondence. I then asked, I then reported on what had happened to the people that nominated me, because I thought I should tell them. They followed up with Nadel and said, please could you give us the documents, the sources for your criticism, and they weren't able to produce any. The other element that surprises me is this: that is that Nadel, in fact, in 1995, supported my nomination as a judge of the Land Claims Court. I have done nothing in the last, I don't know, 30 years, in the last 30 years, to invite that sort of a comment. I can't begin to fathom it, and I stand by what I said the last time. It's grossly unfair to put a comment like that before a body like this without having any basis to substantiate it. And yes, I believe that my entire approach to my legal career, from the time that I started in the legal aid clinic at Pietermaritzburg University, has been dedicated to realizing what ultimately became the vision of the Constitution. It didn't exist then. And as far as examples are concerned, there are a lot of them in my curriculum vitae, and I won't try and repeat those. The one I like to talk about is the one that I've already spoken to with Commissioner Ngukai Tobi, because it was a case where I wasn't just acting for, I wasn't challenging the state, I was acting for the state. But I brought about an approach that was also mindful. I suggested to my client that they subject themselves to an incredibly strict order to make sure that the disabled child in that case, who'd been the victim of negligence from the state, would be cared for and catered for the rest of his work, for the rest of his life.
No, thank you very much. Thank you, Chief Justice. I thought that the Eastern Cape example case would suffice to explain his position. Thank you.
Thank you very much.
Sorry, Chief Justice, can I just put on record more information in relation to that adverse comment? They said that they would get back to us, but they haven't done so.
Okay, no, thank you very much. I've seen no indication that commissioners who are on the virtual platform, that there's anybody who wants to ask a question. That being the case, I think therefore we have come to the end of this interview. Thank you very much, Mr. Dodson, once again for availing yourself. You are now excused.
Thank you, Chief Justice. Thank you, Commissioners.
Thank you.
Thank you very much, Chief Justice.
Yes.
For being granted the opportunity.
Okay, Commissioner Makwanisha, go ahead.
No, Chief Justice, at the rate at which we are going, our decision to finish at 6 will stand. That is one.
Commissioners must all come in, please. Commissioners must all come in. Secretariat, please bring in all commissioners who are still out. Good morning, Justice Mahoga.
Good morning, Chief Justice.
How are you this morning?
I am well, Chief Justice. Are you well?
I'm well too. I'm well too, and all the commissioners are well.
Thank you.
Thank you very much. Let me begin by thanking you for availing yourself as a candidate for the Constitutional Court vacancy, as well as availing yourself for this interview. We appreciate it very much.
Thanks, Chief Justice.
I'm not going to explain certain ground rules because you are not appearing here for the first time. You have appeared for High Court, you have appeared for Supreme Court of Appeal before. Is that correct?
That's correct, Chief Justice.
Yes. The only difference is that since you appeared for appointment to the Supreme Court of Appeal, is that we have adopted selection criteria that guide us in the selection of candidates. And in all our questions, we will be seeking to get information from you that will assist us to see how you meet those criteria. You understand?
I do, Chief Justice.
Thank you very much. I'm not going to go through your academic qualifications. You do have BProc and LLB. You are a candidate for LLM.
I must correct that, Chief Justice. I'm a student for LLM. I understand there is a
difference.
A difference, yes.
Yeah.
Yes, I'm a student, yes.
Well, maybe it's a difference without distinction without a difference. But I think everyone understood when it says candidate that you are busy with your LLM.
Yes.
Yeah.
You have to reach a particular threshold.
Or to be a candidate.
To qualify as a candidate.
Oh,
I
okay.
haven't reached that threshold yet.
You must have completed the papers.
Yes.
Yeah, okay, all right. I don't think anybody will take that against you. And you did articles in the early 90s, and you were admitted as an attorney in the mid 90s. And you practiced as an attorney for many years, and you were appointed as a judge of the North Gauteng High Court. Is that correct?
That's correct, Chief Justice.
All of that is correct that I've said, yeah?
Yes, Chief Justice.
Yes. How many years did you sit as a High Court judge before you went to the Supreme Court of Appeal?
8 years, Chief Justice.
8 years. And during that period, you wrote a number of judgments which were reported. Is that correct?
That's correct, Chief Justice.
Yes. And you have now been in the Supreme Court of Appeal for how long?
It will be 6 years. I was interviewed exactly on this date in 2018, and I was appointed with effect from the 1st of June.
Yes. Okay. Or exactly on this date?
Exactly on this day, yes.
Oh, that's interesting.
Which happens to be my daughter's birthday.
Yeah. And in the Supreme Court of Appeal, you have also produced a number of judgments that have been reported, some of which have been regarded as very important. Is that right?
That's correct, Chief Justice.
Yes. You have had the opportunity of acting in the Constitutional Court for 2 terms, is that correct?
That's correct, Chief Justice.
Please share with the commissioners your experience of the work of the Constitutional Court and how you found your acting stint to be.
Thanks, Chief Justice. Firstly, it was a privilege to be asked to act in the Constitutional Court. I found the work to be intellectually stimulating. It was a rewarding experience for me. But the sheer volume of work, I had thought that having sat in Gauteng, nothing could faze me. But I was just surprised by the sheer volume of work in the Constitutional Court. But the collegiality is something to write home about. The scholarship and the intellectual rigor that goes into the judgments of the Constitutional Court is everything to be expected from an apex court in any country. Thanks, Chief Justice.
No, thank you very much. You have included in the questionnaire some judgments or some cases, you have referred to some cases where you wrote judgments that you regard as very important. Obviously, we have had a chance to read those, but I will ask you to say a few words about a few of them. Do you want to say something about the Clicks judgment, which appears at page 10 of your bundle, that was later confirmed by the Constitutional Court?
Yes, Chief Justice, thank you. The Clicks judgment, it was a minority judgment in the Supreme Court of Appeal. I took a view that the matter concerned a constitutional issue regarding Section 27. Obviously, there are business interests implicated in that matter, but I took a view that it implicated a constitutional right, enshrined in Section 27. That was the starting point in my judgment. And as we know, ultimately, the majority of the Constitutional Court upheld my minority judgment. And it is important because it involved community pharmacies. Had the Constitutional Court ruled in favor of Clicks, it would have had devastating effect on a number of community pharmacies across the country.
Yes. Do you want to spell out that detrimental effect it would have had?
The effect it would have had is, had clicks been successful, it had the effect that clicks could manufacture medicine and sell it. So a clicks outlet in a particular area could sort of emasculate the little community pharmacies in a particular area.
So in a way, that would have been anti-competitive, which might not necessarily be in the competition law sense, but
Yes.
basically, realistically, that what it would squeeze out
Yes.
small competitors.
Exactly, Chief Justice.
Yes. And PAF versus SCH, it's a judgment that you refer to. Do you want to say something? Because Professor Bradley, you point out, Bradley Smith has described that judgment of yours as groundbreaking.
Yes, Chief Justice.
That's on page 11 of the bundle.
Yes, that judgment concerned the hiding of assets in a trust by a husband during a divorce case. And we had to, in a way, pierce through the veil of a trust. And we looked at the jurisprudence of our court, the Supreme Court of Appeal, especially the case of Badenhorst versus Badenhorst. And we came to the conclusion that the circumstances of the case called upon the court to pierce through the trust veil, to come to the assistance of the wife, because otherwise she would have been stripped of what she would have been entitled to.
Yes. And do you want to say something about I see that you have done one on environmental law, Harmony Gold. Do you want to tell the commissioners why that judgment is important?
Harmony Gold concerned, excuse me, Chief Justice, concerned the duty of mining companies to treat the polluted water as a result of their mining activities. So in this instance, a company having done mining activities and having polluted water in a particular area sold the mine to another company and said, we are divested of any responsibility to clean up the water resources. I disagreed. I said, well, that obligation continues to follow you, irrespective of the fact that you might have sold your company and mining operations to another company. The Supreme Court of Appeal agreed with me and upheld my judgment.
Yes. Now, you have also produced judgments during your acting stint in the Constitutional Court, is that right?
That's correct, Chief Justice.
Yes. Do you want to talk about the importance of two of those judgments?
Chief Justice,
Any two?
Well, I've produced two judgments in the Constitutional Court, Ole Seitze versus Minister of Police, and the Casino Association versus the MEC in Northwest. Ole Seitze concerned the development of the common law by the Supreme Court of Appeal, unwittingly so, it concerned whether the principle of once and for all is applicable to two causes of action. You would recall that Chief Justice, both the High Court and the Supreme Court of Appeal said, well, you should have, Mrs. Olisitse should have combined her actions in one. So she couldn't separate the two. That is the action for unlawful arrest and the action for unlawful detention. And as a result, they said, both courts said, she couldn't divide the two actions because they arose from the same set of facts. And we disagreed with that approach because we said these are distinct causes of action and each one of them has got its own requisites and it can be brought separately from the other. And we said to the extent that both the High Court and the Supreme Court of Appeal had approached the matter in the manner they did, they developed the common law, but without complying with the Constitution. Chief Justice, you would recall that you preferred a linear route in that matter. But yes, that's where we arrived at. And the casino matter involved levies that were imposed by the MEC on the Casino Association and the members of that association, I think Sun City and another company. And we decided that those levies were effectively tax. And we said, well, you can't, as a legislature, as the executive, impose tax without the intervention of the legislature. So that is why we ultimately declared those levies unlawful and ordered the MEC to repay part of the levies that had been paid pursuant to the regulation that was in issue.
Thank you very much. You have had an opportunity to sit in matters where orders of constitutional invalidity have been made. When you deal with a matter sitting in the Constitutional Court where there is a constitutional challenge in terms of legislation, once you have concluded that an order of invalidity should be made, constitutional invalidity in relation to legislation, what are the immediate issues that should come to your mind that you should also address in the remedy? What are the issues that should immediately come to your mind to say, I will have to deal with this and that as well?
Yes. Chief Justice, we are guided in that regard by Section 172. So the starting point would be 1721, in terms of which you would have declared legislation to be inconsistent with the Constitution. And then you go to B. B gives you sort of remedies. What do? You would start to think of retrospective effect of the declaration, or you might want to think about suspending the declaration and giving an interim order. There are various other concepts that come into consideration, like reading in. the court might read in certain words into the statute to make it constitutionally compliant. For example, you might, in the National Coalition for Gay and Lesbian case, you'd add a word into a statute and say, this statute must contain this particular word. You might also want to sever certain words from legislation, which makes that legislation to be unconstitutional. Severance basically means you take out words, you scratch out words and say this word is out because its presence makes this legislation to be unconstitutional. So you sever it. You have both actual severance and notional severance. Actual severance is actually what it says. You sever words and say these words are out. Notional severance is just to limit the effect. For example, in I think Ferreira versus Levin, where it concerned the section 4172 of the Companies Act, where it says, if you give evidence at an inquiry into companies' affairs, that evidence can be used against you in subsequent proceedings. It might be criminal proceedings. So the court notionally severed that and said, well, to the extent that you would be required to sort of implicate yourself, to that extent, it is unconstitutional. Chief Justice, you might also want to employ an interpretative mechanism called read down. Read down is not really a remedy, but it's a mandatory interpretative exercise that the court must undertake to make sure that a constitutional provision, a legislative provision that is unconstitutional can be interpreted in such a manner that it does not limit a right.
Well, so a reading down will not come in if you have concluded that the statute is invalid. It comes in while you are interpreting to make sure that the statute is read in a way that is consistent with the Constitution.
That's correct, Chief Justice. As was done in cases like Hyundai and recently, I think, in Makate.
Well, you have answered a question that I was going to come to also on severance. You have already dealt with it. And reading in and reading down, you have dealt with. What can you tell us about the principle of subsidiarity?
Well, the principle is this. If the Constitution makes provision for a right, a litigant, let me rephrase. If the Constitution makes provision for a right and legislation is enacted to give effect to that constitutional provision, a litigant cannot approach the court to rely directly on the constitutional provision, but must rely on the legislation that has been enacted to give effect to that right. Unless, of course, the allegation is the legislation itself does not adequately protect that right. For example, Section 33 of the Constitution makes provision for just administrative action, and it commands that national legislation should be enacted to give effect to that right. That legislation is PAJA. So a litigant cannot override PAJA and rely directly on Section 33 of the Constitution.
Thank you. Section 1771 of the Constitution provides 3 grounds for the removal of a judge from office. 2 of those grounds are gross incompetence and gross misconduct, which suggests that if a judge is incompetent or if a judge is guilty of misconduct, which does not amount to gross incompetence, which does not amount to gross misconduct, that's not a ground to remove them. That might sound odd. What do you think is the constitutional significance of these provisions of Section 771, which say you can only remove a judge for incompetence if it's gross incompetence, for misconduct if it is gross misconduct?
For me, Chief Justice, it goes to A, the tenure of judges, tenure and security of judges, and B, the independence of the judiciary. I think it was deliberate that the framers of the Constitution put the threshold that high, that a judge should not be easily removed from office. To remove a judge from office, it must be because of gross incompetence or gross misconduct. I think it was deliberate that the threshold is that high to protect the independence of the judiciary, that judges should not be afraid to make mistakes which can be maliciously be used to remove them from office. So it is about security of tenure. It is about the independence of the judiciary.
Thank you very much. I will now allow the minister if he has got any questions.
Yeah, thank you very much, CJ, and good morning, Judge Mahoka.
Good morning, Minister.
You will be pleased to know that I see that you're a lecturer at the PLT, that I'm one of your students.
Yes, I think together with former Minister, I can't remember, but yeah, former Minister of Communication, Faith Mutambi, I think, yeah.
Yeah, so I'm glad that today the roles have reversed, I'll be assessing you.
Yeah.
But I hope that the minister is not going to think this is an opportunity to get marks.
Yes. I just want us to traverse a bit what you dealt with the CJ on the clicks matter.
Yes.
What is of interest to me is that while this you dealt with this matter in terms of the regulations, the Pharmacy Act 53 of 1974 and the Constitution.
Yes.
While when you look at it, it has the characteristics of competition law or anti-competitive conduct or behavior. What I want to find from you, I mean, with the Competition Act, there is a process of inquiry by the Competition Commission, which will obviously help the tribunal, the appeals court, and also when it comes up, it has benefited from all those processes. How did you arrive at this conclusion, which has been obviously confirmed by the Concord, which shows that it was a right kind of conclusion without these earlier inquiries that have been put in place in terms of the competition law?
Yes, Minister. As I said, my starting point was Section 27 of the Constitution. That was my starting point, and it influenced everything that I said in that judgment. You would note that in the judgment, I didn't concentrate on any antitrust considerations. I did not go there. I just said, well, let's look at the aim of the regulation, and let's look at what the Constitution says.
How do you think this could also impact other judges or courts dealing with almost similar matters? Because, I mean, what is in the Pharmacy Act, you may find it in other statutes
Yes.
aimed to regulate the same kind of conduct, but the court might rule differently, and that may lose the importance of the transformatory objectives of the Constitution.
Yes. Yeah, but I think that the Constitutional Court, in its majority judgment, has laid the path. I think we all have to follow that. I think it's a well-reasoned majority judgment of the Constitutional Court, and I think it has laid down important principles as to how these matters should be approached.
Lastly, it's a different question I've been asking all the candidates. And I'm glad you come from the Supreme Court of Appeal, where your former colleague, Justice Matapo, was, when he made a proposition here during the interviews that he's of the view that we need to collapse or merge the Supreme Court of Appeal with the Concord, because his view is that you work in chambers in the Supreme Court of Appeal. One apex court can benefit from that, and also the additional judges that will come out of that merging. Do you think that could enhance access to justice?
Yes, Minister, I must say, I haven't given that much thought. But if you ask me to give an opinion on that now, I would maintain the structure as it is. I would maintain the Supreme Court of Appeal as it is and the Constitutional Court as it is. Having sat in both courts, I see the benefit of an apex court having the judgments of the second highest court in the land. I've seen that benefit and I've felt that benefit. So I wouldn't collapse any of the two courts. I think it works well so far. It might well be that there needs to be some form of intervention in the Constitutional Court in the manner that it does its work relating to the speediness with which it produces its judgments. But I think the present setup with the Supreme Court of Appeal and the Constitutional Court maintaining their separate entities, I would maintain that for now.
Thank you, CJ.
Thank you, Minister. Justice Molo.
Thank you, Chief Justice. Good morning, Justice. Justice Makhuka.
Good morning, President Molemela.
Yes, JP Mlambo was whispering next to me here, so he disturbed me. I'm sorry about that.
No problem at all.
Yes, how are you?
I'm well, my sister. How are you?
I'm well too. Thank you very much. Just on that last point, following up on the minister's question, I think it's something that is now common knowledge. It's in the public domain that the caseload or the workload of the Constitutional Court has increased tremendously ever since 2013, when the jurisdiction was amended to make it a court of general jurisdiction. You agree?
I fully agree, yes.
Yes, and it would seem that that in itself has had an impact on the handing down of its judgments. Would you agree too?
Certainly, yes.
Yes, so this question that I'm posing to you doesn't really have a wrong or right answer. I'm just trying to explore solutions to the problem that is existing at that court at the moment. A suggestion has been made that the court could improve its efficiency if it worked in panels. I'm sure you'd agree with that as well.
I fully agree.
Yes, yes. And that would require a constitutional amendment, obviously. Yes. And in making that proposal, a comparison has been made between the Constitutional Court and several other courts in other jurisdictions. And so there are courts in other jurisdictions which have a higher judges complement than the Constitutional Court. I think there's a court somewhere that has a complement of 16 judges in its highest court. So what would your comment be in relation to a suggestion that increasing the current complement of the judges of the Constitutional Court could also alleviate the problems that it is experiencing at this moment?
I would agree with that, but also how it goes about doing its work. The frustration that I had, if I could put it as such, was how long it takes to give out an order whether a matter should be heard in that court or not. Coming from the Supreme Court of Appeal, where these applications are dealt swiftly, it created a lot of frustration in me. You'd know that in our court, on a Tuesday, an application for leave to appeal would land on my desk. I leave out everything. I deal with that. At the latest by Friday, the order should be out. If by Friday the order is not out, there's something wrong. In the Constitutional Court, it takes months and months and months, sometimes up to 7 months, to produce that order that says, we are not going to hear this. And the public out there does not know what goes into it. What goes into it is a lot of work. Basically, it's a judgment. A colleague would produce a memorandum, and other colleagues would have a look at it. They would have their say, and because it is a court which sits and bank, all at least 8 colleagues, or if the full complement is reached, all 11 colleagues should ultimately agree with the outcome. But what the public sees out there is the order, that little order, that this does not concern our jurisdiction. And it attracts a question. Why did it take so long for you to tell me that this matter does not engage the jurisdiction of the Constitutional Court? Yes, I agree that the number of judges can be increased, but how they go about doing, especially on applications for leave to appeal, should be looked into, because that also impacts on the time that is left for judges to concentrate on their core function of judgment writing, research, and scholarship.
Yes, thank you very much. That was just a follow-up. I'm now asking the question. The jurisdiction of the Constitutional Court is set out in Section 167(3) of the Constitution. At first blush, it may seem as if it's something that is easy to determine. However, we have seen several judgments of the Constitutional Court where there were divergent views from the very judges of that court as to whether a matter raised constitutional issues or whether it raised arguable points of law of general public importance. So what would you personally take into account in relation to establishing whether the jurisdiction of that court has been engaged?
Look, I think in every case, it's a case-by-case determination, sometimes a value judgment of what is right. And so it is never an easy exercise, especially if it is clearly not a constitutional matter. Then you have to take into account those other factors. It's never an easy situation. It's a case-by-case determination.
But what would you regard as important factors, for example, in relation to establishing whether a matter raises an arguable point of law of general importance, for example?
Well, obviously, yes. The question is, does this raise a matter of importance? Does it affect our jurisprudence? Does it have wider implications beyond the parties? So those are some of the considerations that you want to put into the picture.
Yes, thank you. Section 172 of the Constitution provides that where either the High Court or the Supreme Court of Appeal has declared legislation invalid or conduct invalid, that order must be confirmed by the Constitutional Court. What do you think is the rationale behind that?
Well, the Constitutional Court, by design, is the apex court in the country, and you would want to have assurance that the best legal minds in the country have confirmed what the High Court would have said. I think the framers of the Constitution were careful that it should not end at the level of the High Court or at the level of the Supreme Court of Appeal. It should be the apex court in the country that says that, because it's got wide implications. Some of the declarations of invalidity in the High Court, in the Supreme Court of Appeal, got wide implications for the country. I mean, if you just look at the cases that went to the Constitutional Court, coming from the High Court, very, very important matters. So you would want that to be confirmed by the highest court in the land.
Yes, thank you. My last question, CJ. You have been a justice of the Supreme Court of Appeal for 5 years now, and you are also a presider. Would it be fair to say that you have by now been exposed to a variety of cases touching on literally every branch of the law?
Yes, I think I've written extensively on most aspects of the law.
Where you did not write, you were part of the panel.
Of course, I mean, you know that as a presiding judge in a particular panel, your duty is to guide, to make sure that the law is properly stated, the jurisprudence is kept compact. So, yes.
So if appointed to the Constitutional Court, you would be able to hit the ground running, to use common parlance?
I think so.
Thank you, Justice Makhoka.
Thanks, my sister.
Thank you, Judge President Mlambo.
Nkwe, Kgotso,
Mapisa.
I was disappointed you didn't address your president as Minna Tsipi. But anyway.
I was tempted.
Nkwe, when you acted in the Concord, would I be correct that you would have been involved in leave to appeals or petitions in matters which went to the SCA and those petitions were dismissed?
Yes.
Right. And I think that's what...
I'm sorry, what was the answer?
He said yes.
Yes, okay.
Yes.
I think both the CJ and your president dealt with how both courts deal with their work. The SCA way of doing work is lauded as more efficient because It's in panels in terms of petitions, in panels in terms of hearings. I'm not sure I understood your question about the panel's solution for the Concord. Did you suggest in
Yes.
both respects?
Yes.
Petitions and hearings?
Yes. There are really matters in the Constitutional Court that I felt, look, this could be done by at most 5 colleagues. You don't need the whole panel of 11 or 8 judges.
What would you say to the view that says, because the SCA has that advantage of panels in terms of both aspects, that it would create the necessary buffer that ensures that what goes to the CC coming from the SCA will be something that engages the jurisdiction of the CC. That is, a view would have been expressed by the SCA.
Yeah,
You agree with that?
I agree with that.
Yeah. And the reason I'm asking that is, it appears to me that it would be more advantageous to the CC to reduce its appetite of hearing matters where the SCA hasn't expressed a view. You agree with me?
Well, look, remember there is a constitutional provision for direct access. Some of the matters that ultimately I had in the Constitutional Court, they've not gone via the SCA, gone from the High Court straight to the Constitutional Court.
I'm aware of that. I'm not talking about those matters.
Yes.
Yeah, there's not many of them. And
Okay.
in any way, the CC's approach to those matters is far more strict.
Okay.
Yes.
So you're talking about matters that
Yes.
went through the SCA system.
Yeah.
Yes. To that extent, I agree that the SCA would create what you call the buffer.
Yeah.
Yes.
Okay. Because the paneling solution for the CC is something that would go against the grain of some apex courts internationally, because they all sit in bank.
Yes.
But nevertheless, you support the paneling solution for hearings as well.
Yes.
Okay. Thank you, CJ.
Thank you. Those were the only hands I had, and I see there is one now, Commissioner Nzaitobi.
Good morning, Justice Mahoka.
Good morning, Toby SC.
Yes, I just want to ask 2 questions. I mean, one is always tempted to go back to this question about what kind of a constitutional court we have in mind before getting bogged down to the logistics of making it possible. Because when the current frame of the Constitution was designed, the country really wanted a special court to deal with 350 years of apartheid colonialism, which had displaced a legal system based on dignity and imposed a European system which is founded on racism and dispossession. And the idea was, well, let's get a special court that will sit and bank. And its primary function would be to develop a new jurisprudence for a new country.
Of course, yes.
Now, whenever we talk about empaneling this and empaneling that, I wonder whether we are not forgetting why the Constitutional Court was established in the first place. Now, if I can ask you then the first of my 2 questions is whether you think the Constitution embeds within it a vision of the economy. I mean, we always talk about social justice, but it seems to me after 30 years of trial and error, there is no social justice in South Africa, despite the Constitution and the Constitutional Court. And one could say it's because the Constitutional Court is not doing enough to translate the vision of the Constitution into practice. Or one could say it's because the executive is not doing enough, or because the parliament is not doing enough. This ball of the absence of social justice keeps getting pushed around. But you are applying to be a judge of the Constitutional Court, so you should answer for the Constitutional Court. Do you think there is a vision of the economy in the Constitution itself, that the economy of South Africa should be a transformed economy?
In the Constitution?
Yes. Well, that's the only weapon you have as a judge, is the Constitution. But do you
Yes.
think it embeds a vision of economic transformation?
Well, yes, it must.
Yes, just expand on that. How? I mean, one of the ways of looking at the Constitution is that it's a series of rights
Yes.
in the Bill of Rights, but it does not itself require economic transformation, and that's something that must happen, in a sense, outside of the Constitution.
Yes.
But if you are going to say, I actually want the economy to transform, the stock exchange to transform, is that sourced in the Constitution or elsewhere? The reason I ask this is because I've got this problem that the common law of contract and property is taking place in parallel to the Constitution.
Yes. Well, the Constitution does not explicitly provide for the economic solution that you speak about, but the Constitution provides for justiciable Bill of Rights, especially on socioeconomic rights, and that's the closest you can get to the economy, socioeconomic rights. I don't know to what extent courts and judges in particular can do to uplift the economy of the country, but to the extent that matters can come to the Constitutional Court, where rights are involved, rights are violated, I'm sure that the Constitutional Court would, as it has done, would vindicate those rights.
No, I don't disagree with you that the Constitution contains a vision for the Bill of Rights. It's there, it's spelled out. In fact, that was the big demand of the struggle.
Yes.
I'm asking you whether the Constitution contains also a vision for economic transformation so that we can transform the stock exchange through the law.
Well, as I said, I don't think there is any explicit reference in the Constitution to that. It might be implicit if you read the Constitution widely as a vehicle to reconstruct South Africa, but there's no implicit or express provision in the Constitution for that.
Yes, but what do you think?
Well, Commissioner Ngwetho, he has told you what he thinks.
No.
He thinks expressly there is nothing, but he thinks maybe somebody can imply. I think that's the gist of his answer. I don't know if you understood this. You can follow up. I'm just saying he seems to have expressed what he thinks.
No, well, okay. I mean, I don't know, Justice Mahoka. I mean, this is not a trick question. It's to really try and engage with why do we have so much inequality after all of these marvelous legal reforms? Why do we have so much poverty? Is it because there is, in the Constitution itself, a poverty of dealing with the economic question? Or is it because we're not doing enough to realize the economic vision in the Constitution? And if it is there, you've said, okay, well, it's not expressed, but are you saying it is implied? And it's implied in the socioeconomic rights provisions?
Yes, I mean, as to whether we have done enough, we might have to look to the executive. Might have to look to the executive as to whether the executive has done enough to marshal all the resources in the country to make sure that this economic emancipation is realized.
Okay, yes. My issue, you're not applying to be in the executive, you're applying to be in the judiciary. I just want to know whether there are any legal tools that we have that we are maybe not using or maybe we can use.
Yeah.
So when you are a judge of the Concord, would you have this vision of economic liberation through the Constitution? And if so, where in the Constitution are you going to look?
Yeah, look, I must say I haven't applied my mind to that question, but I'm a product of the liberation struggle. I was part of the liberation struggle in the Black consciousness movement, and that remains the economic empowerment and upliftment of black people in particular, remains at the back of my mind. It worries me, as it worries you, obviously, that after 30 years, we haven't moved as speedily as we should have.
Yes, all right. So something you'll think about. Now,
Yes.
the next question relates to the clerk's judgment, not the substance of the judgment. I've read it, but it's the answer you gave when you were first asked about the question, which is you were looking at the impact of the decision by clerks, particularly on community pharmacies, that it would squeeze them out. Now, the reason I ask is related to my first question. You know, we had a debate when Justice Unterhalter was here about what he referred to as consequentialism in judicial interpretation. So whenever I hear a judge saying, I'm worried about the consequences, it always sounds like they're not worried about the doctrine. They just want to know whether the consequences will be something palatable or not. So where do you fall in those two schools of thought between sort of doctrinal-based adjudication and consequentialist-based adjudication?
Well, look, I've always been a pragmatist. I might straddle between the two schools of thought, but I'm always looking at the consequences. You look at my judgment in the Magidwana matter, where about the Marikana legal representation. I had no legal basis effectively to get the injured minors to be assisted by the state. But I had to think consequentially as to what would happen if these people are not represented at that commission. And that's how I came to the conclusion that they should be assisted by the state.
Thank you, Chief Justice. I have now been answered.
Okay, thank you. And there may be two follow-ups. Yes, Minister. Shall we try and limit follow-ups to one question?
Yeah,
Yes, Minister.
Thank you, CJ. My follow-up relates to the first question that you said you have not really applied your mind to. So I'm a bit confused because when I read the clerk's judgment and your answer to me, when you said you started with the Constitution to apply its transformatory effect, particularly on the concentration in the economy, the outmuscling of community pharmacists. It sounds like a transformatory interpretation of the Constitution. So that's why I'm a bit ambivalent to the response you have given to Advocate Ngwaidobe. I'm a bit confused. Is that not the answer?
I don't know. I think I was dealing with the doctrinal issue as to basically he was asking me my legal philosophy. That's how I understood his question. That are you a doctrinal judge or are you a consequential judge? You think about the doctrine.
That one is the second question, Judge Bahok. The first one relates to when he asked you whether the Constitution has got instruments that you can use to transform the economy.
Yes.
Yes. So I'm asking you because this clerk's judgment does reflect that aspect, particularly on the community schemes. The economy is concentrated. It relates to opening up the economy, the health sector, but you did not provide that. So that's why I'm a bit confused, Uri.
Yeah, I take your point.
Yeah, so that is my question.
No, thanks. I take your point. Yes. So the clerk's judgment is a good example of the answer to Advocate Ngwaidobe SC. I think that's what you say, and I agree with you.
You're done.
I have a follow-up.
Before I go to Commissioner Pillay, I just wanted to say, notwithstanding that assistance, no marks will be given. Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Justice Mahoko.
Good afternoon, Commissioner.
Justice Mahoko, I want to follow up on the second question asked by Commissioner Ngwaidobe, and to which you answered that you focus, during your judgments, you focus largely on the consequences of whatever dispute you're arbitring. May I just ask you this, and I was concerned about this when I was reading your Ndesha judgment. I think that's the matter involving the admission of an attorney who hadn't complied with a requirement of the act which you found to be peremptory.
Yes.
So you considered the act, you considered that the requirements of the act are peremptory, in that the applicant has to have done PLT either during articles or immediately after articles.
Yes.
You were faced with an applicant who had done her PLT course before articles.
Yes.
And you were, in that matter, presiding over the admission of the applicant.
Yes.
And notwithstanding the fact that you found that the section of the Admission of Attorneys Act was peremptory, you then still went on to admit the applicant.
Yes.
And you did it through an adoption of a purposive approach to the interpretation of the section.
Yes.
When I read it, this is a 2018 judgment. When I read it, it immediately struck me that you conducted the exercise without considering, for example, separation of powers concerns. Because your ultimate interpretation of the judgment made a marked change to the requirements of the Act. I just wanted you to talk us through that process.
Yes. Let's start with the effect of what would have been had I adopted the Law Society's approach. It would have meant that many black candidate attorneys would not have been admitted, despite the fact that they would have done practical legal training and they would have passed board exam. They would have had to, there would have been a problem with the admission. And that's a situation that I couldn't live with as a judge. It's an old judgment, as we say, 2018. I can't remember the exact reasoning, but my approach was, despite the peremptory language of the Act, there was a leeway to admit that candidate, despite the fact that the sequence was not right, because ultimately what was in issue was the sequence. I could have said to that candidate that day, with all the parents and everybody who was there to support her, and said, despite the fact that A, you have done practical legal training, B, you have passed the board exam, I can't admit you because the sequence was not right. Majority of black candidate attorneys are not able to get articles without doing practical legal training. Practical legal training gives majority of them the basis to get articles. And that was the basis on which I approached the matter.
And can I just follow up on that last bit, the factual matrix that you took into account?
Yes.
Because obviously this was a standard application for admission by an attorney. You took into account facts around systemic circumstances of black candidates specifically.
Yes.
You don't make a note in your judgment that you're taking judicial notice of that. You don't say where those facts are extracted from in the context of an ordinary admission application. So I just wanted to get a sense of how you dealt with that.
Well, I think those facts are notorious. The fact that most black candidate attorneys struggle with entry into the profession are sufficiently notorious. I didn't have to get any document or empirical evidence about that. I know about that. It is historical and it is well out there. We know about it. It is sufficiently notorious.
Thank you, Chief Justice.
Well, I just want to do a follow-up on that. I didn't get to reading the judgment, but I read what you say in the questionnaire about the judgment, and I was also concerned a little bit about the the fact that while the statute only contemplated this training to be taken into account if it's done during articles or after, you concluded that somebody who did the training prior to articles complied with the statute. That seemed a little problematic to me. And I think the separation of powers concern that Commissioner Pillay raises goes to saying there are times where, as a judge, you see what the statute says,
Yes.
and you may see its consequences maybe are undesirable or they are unfair, but nevertheless, you might decide that is something that must be rectified by Parliament. And it's not your role as a judge
Yes.
to rectify that. I think that's what
Yeah.
Commissioner Pillay is raising.
I take the point, Chief Justice.
Yes. Sometimes a judge reads a statute, sees what has happened in a particular case, and doesn't think that there is a good reason why the position should be as stated in the statute, but decides that I must just indicate that Parliament must consider whether it shouldn't amend. And Parliament can consider that amend if it's persuaded that not amend, or the judge can just point out the challenges and say, I'm not able to come to your assistance. There are situations where interpretation permits. There are situations where interpretation doesn't permit. But one of the things also that concerns me is if you concluded that the statutory provision was peremptory, whether there was room for you to come to their assistance, because I may be wrong, but that seems to suggest that you were saying there was substantial compliance. There was no strict compliance, but maybe you were thinking there was substantial compliance because the training, the candidate attorney had undergone the training.
Yes.
They just happened to do it before. But of course, the legislature might have good reasons why they think it should be done only by people who have started, who are in the, going through their articles or after.
Yes.
Yeah, but you understand. I'm not saying you are right or wrong, but I'm just saying that there may be those
Chief Justice.
concerns.
Yes.
Yeah.
I take the point, yes. As I said, I haven't read the judgment recently, but I think that's the part that I took, that there was substantial compliance. I think that's what might have influenced me. Thank you.
Yes, thank you. Commissioner Waitobi.
No, I'm happy to pass this one on, Chief Justice, given
you.
that I've already asked 3 questions.
Thank you. Commissioner Lucas.
I will really, for the interest of time, also pass.
Thank you very much. We are doing very well. Commissioner Marumachai.
I have a follow-up. Mine is a follow-up
Is a
to
follow-up?
this line.
Oh,
yeah.
I'm sorry. I was going to put you later.
Yeah.
Okay, follow-up.
Just concerned about your answer about consequentialism and doctrinal philosophy. When you sit on the Constitutional Court, you're making law for everyone for all time. What do you do if, on the facts of that particular case, the just outcome would create a precedent that A, is not legally sound, and B, might create havoc in other ways. How do you then balance, the old adage that hard cases make bad law, right? How do you balance trying to find the right consequences of a case with the impact of that forever and a day? That was the context of the debate with Justice Unterhalter. I think it was apropos the Eskom Vaal River development, where he may be wrong or right. That is not my point. His minority judgment was saying that I realize my judgment would result in hardship for people, but at law, we cannot do anything else. It would be wrong. And we would also open the floodgates in a manner that would put Eskom on its knees due to incapacity. So I'm less interested in a debate on that judgment because I think it's highly debatable. But the principle that I'm articulating.
Yes. I think you are correct. We should try to stay as close as possible to the law. And majority of cases lend themselves to that. There will always be difficult cases where the law is not that clear. The law does not provide for simple answers. And those cases would be few and in between. And those are the difficult cases. But I agree we should stay as close as possible to the law. We should be guided by the law in all what we do. But as lawyers, as judges, we must also think about the consequences of our judgments on society.
So what do you do when the consequences suggest one thing, but the precedent suggests another?
Well, look, I mean, in the Constitutional Court, that's an apex court. It can develop the law in a particular direction. It could well be that in certain cases the consequence must be unpalatable, like you mentioned in the Eskom matter. But if that's what the law directs us to do, that's what we should do.
Thank you. Thank you, Chief Justice.
Thank you very much. And maybe, Justice Mahoka, maybe sometimes we might wish to say, well, these consequences are a result of a choice made by the legislature.
Yes.
So we shouldn't feel bad because we are not responsible.
Exactly, Chief Justice.
Okay, all right. The minister, the executive is laughing. Commissioner Marmoha.
Thank you very much, Chief Justice. Good afternoon, Judge Makoka. This side.
Oh, hey, Prof.
No, thank you very much. I initially had two questions for you, but from your interaction with President Molimela, the third question arose, and I want to start with that question. There have been a number of decisions from the Constitutional Court which have dealt with the issue of this general jurisdiction. Not desirably, but touching on it, right? And I think as the people of South Africa, we want to make sure that when the judge goes to that court, they are fully engaged with the jurisdictional elements of the court. And I want to give you a chance to really answer that question, because I thought it was an important question, which I did not think that you really answered it. Because there's not really been a test or criteria that has been designed for us to really know what this thing actually means. When you are sitting as one of those judges, when memos are being circulated and the question is asked, does this, oh, well, everyone is clear. that the constitution is the constitutional jurisdiction is not engaged, then the general jurisdiction, what are you actually looking for to agree with any colleague who says it has been engaged or it has not been engaged? What exactly are you looking into?
As I said, it's a case-by-case situation. Firstly, from my own personal perspective, does it relate to our jurisprudence? Would this case have an impact on our jurisprudence, on any aspect of our jurisprudence? Two, does this case have wider implications for the country or the community beyond the parties themselves? Thirdly, does it appear that the judgment of the Supreme Court of Appeal needs to be rectified? Because sometimes the judgment of the Supreme Court of Appeal is clearly wrong, but as the Constitutional Court, we might say, well, this is not the case for us to pronounce ourselves on this matter. But taking into account all those, it might come to, well, it is wrong, and in any event, it's got wider implications. It impacts on the jurisprudence. We need to clarify this aspect of our jurisprudence.
Thank you very much, Judge Makoka. The second question that I have, last year I had an occasion to come across an issue where these contracts, these credit sale agreements, where people sign them and they are buying cars and all those kind of things, and you are bound to the contract, and once you are bound to it, it's a pro forma form, you are just signing it, and later on there's a default judgment against you, you have to pay. And it raises an important question. There has been a debate in South Africa with relation to the contract and how the Constitution impacts contract law in South Africa. And we have seen decisions where the judges of the Supreme Court of Appeal have not been particularly happy with the jurisprudence that is coming out from the Constitutional Court, even some of them writing extrajudicially to express their opinions on the role of what we reasonably agree to be abstract concepts like fairness, Ubuntu, and all those kind in relation to the contract. I just want to know, as a judge who's moving from that court to that other court, where do you stand in relation to the debate as to what should be the role of the Constitution in contract law in South Africa?
Well, contract law is not immune from the constitutional scheme. Contract law, like all other law, yields to the Constitution. The Constitutional Court has laid down, I think, a Buckhazen case, Botha versus Rich. They've laid down very, very useful guidelines as to how this should be approached. And I think that's the jurisprudential basis on which matters of choice, pacta servanda, should be approached.
Okay, for the sake of time, let me leave it there. Thank you very much, Judge Makoka.
I'm sorry I was not helpful to you.
No, you gave me your view. I wanted your view. There's nothing wrong with that. Yeah. Thank you, Judge Makoka.
Thank you.
Thank you. Commissioner Singh.
Thank you very much, Chief Justice. Just one short question. Good afternoon, Judge McColgan.
Good afternoon.
In 2018, when President Maya asked you a question about gender representativity in the SCA, you were noble enough to say that if 3 female black women are recommended, you will step down.
Yes.
And that was very noble of you. I'd just like to know, since then, have you done anything to contribute to gender transformation agenda within your field?
Commissioner Singh, that has been an ongoing project of mine. I have been involved in SAJE, in training of aspirant female judges. Last year, I did 2 sessions with them. There's a group that is under the tutelage of the former DJP of Gauteng, Mojapelo, retired Deputy Judge President Mojapelo. It's a group of women that have journeyed with him for almost 6 months. So I was part of the people who assisted that group. I lectured to them on several aspects of judgeship. In my own court, I've made sure that those acting colleagues of ours that came to our court got the necessary assistance, got the necessary empowerment, and yes, it's an ongoing project.
Thank you very much. You've lived up to what you believe in. Thank you, Chief Justice.
Thank you very much. Commissioner Pillay, or are you covered already?
I'm covered, thank you.
Thank you very much. Commissioners on the virtual platform, I didn't see any hand. I therefore think that we have come to the end of this interview. Thank you very much, Justice Mahoka, for availing yourself once again. You are now excused.
Thank you, Chief Justice. Thank you.
Mic is on permanently.
Good afternoon, Justice Keepers.
Good afternoon, Chief Justice.
How are you this afternoon?
I'm well, thank you. How are you?
All right. I know that you have been waiting since yesterday.
Yes.
I apologize that we are only able to interview now. I should have apologized to Justice Mahoka as well. We just couldn't finish on time yesterday, despite our efforts to finish as soon as possible. But I must thank you for, one, availing yourself as a candidate for appointment to the Constitutional Court, and also for availing yourself for this interview.
Yes, it's an honor and a privilege.
Yes. No, thank you very much. I think that between the time when you appeared before this body for your appointment to the Supreme Court of Appeal and now, the important development that has happened from the side of this commission is that it has published selection criteria that guide it in selecting candidates. So when we ask you questions, we will be trying as far as possible to ask you questions that will help us to see how you meet those criteria. You understand that?
Yes, I do. Thanks.
Yes. Thank you very much. I see that you have 5 academic qualifications, 4 degrees, and a postgraduate diploma. Is that correct?
That's correct.
Your degrees are BProc, which you got in 1982, LLB, which you got in 1986, LLM, which you got in 1988, and another LLM, which you got in 1991. And the first LLM you got from the University of Cape Town, the second one you got at Harvard University, and LLB and BProc were obtained at the University of South Africa. Is that correct?
That's correct, Chief Justice.
The diploma you got in 2019.
Yes.
And I see that it's a postgraduate diploma in theology.
That's correct.
Is that correct?
Yes.
And you got it cum laude.
That's correct.
Yes. No, thank you. On a light note, I just want to say I do observe sometimes in regard to CVs that we get in this commission that some people, I think usually younger than me, they write their CVs by starting where they are at the moment and then going down up to when they finish school.
Yes.
So I
Modern
see,
way, Chief Justice.
I see that you started like that as well under 5.1. You started with the postgraduate diploma, which you got in 2019.
Yes.
And then LLM, which you got in 1991. And then LLM in 1988 up to BProc in 1982.
Yes.
Is that right?
That's the modern way, I'm told, Chief Justice.
I suspected that it is a modern way. That's why some of us, like me, are not getting used to it. We are used to the old way. But the next one might not have permitted a modern way, because paragraph 6 of the questionnaire asked you to furnish chronological particulars of employment since leaving school or university, and you started with acting justice in the Constitutional Court.
Yes.
So it looks like that's the first job you did after school or university. I asked the staff here to check for me the meaning of chronological, just in case I was wrong.
Yes.
And I'm told that the college institutionary says if things are described in chronological order, they are described as shown in the order they happened.
Yes.
And another dictionary says following one after another without an interruption.
Well, all I can say, Chief Justice, if that is going to be a standard, then there's no hope for my appointment to the Constitutional Court.
Because you see, you started up, so you are going down.
Yes.
Okay, all right. You were admitted as an attorney and practiced as an attorney for only a few years. Is that correct?
Yes, I hardly even practiced.
Yes.
I just qualified just for a few years, you're quite right.
Yes. Well, your page 6 of the questionnaire says you were at Fairbridge in Lawton as an attorney from
Yes.
June 1988 to June 1990.
Yes.
So you would have practiced at least for, what, 2 years?
Yes, that's correct.
Yes. And then later on, you practiced as an advocate at the bar from 1993 up to when?
December 2012.
Yes. So you had a long practice.
Yes, it was almost 20 years.
Then you were appointed as a judge in the Western Cape High Court from 2013? Yeah, and up to 2018. And then in 2018, you were appointed to the Supreme Court of Appeal.
Yes, but I should say that I was acting at the Supreme Court of Appeal from the 1st of November 2016.
Oh, does that mean you only sat in the High Court for something like 3 years?
Just over 3 years.
Yeah.
So I acted until I was appointed. In other words, once I started acting at the Supreme Court of Appeal, I never left.
They snatched you.
Yes.
Okay, all right. And so you have been in the Supreme Court of Appeal for about 5 years.
Yes, in June, in fact, on the 1st of June, it will be 6.
Yes, okay. You got an opportunity to act in the Constitutional Court for 2 terms last year, is that correct?
That's correct, Chief Justice.
How did you find your acting stint? Would you like to share that with the commissioners?
Yes, thank you. It was refreshing and different. I was running in the Rosebank one day, and I thought of the times when I appeared in the Constitutional Court as counsel and how stressful that was. Now I was a judge. It was quite an overwhelming thought, both overwhelming and humbling, because I was given an opportunity to serve the people of this country in the highest court. My experience there was that it underscored what I've always said. I've said this once and I'll say it again. Being a judge is no easy task. Being an appellate court judge is even harder. This is a very hard job, and at the Constitutional Court in particular, you hear cases of the greatest constitutional and public importance affecting the whole country. And your judgments have consequences. They have consequences in the real world. When I finished my stint in the Constitutional Court, some of you might know that I wrote the minority judgment in Vodacom versus Makati. I don't have to tell you that judgments have consequences. I shall say no more about that judgment because it's on appeal before the Constitutional Court. That said, the Constitutional Court was an extremely welcoming environment, very collegial, I was made to feel very welcome. I got on well with colleagues. And one thing that particularly impressed me, that even when you differ on a judgment, there is that collegiality. There's even that help to assist you with your dissent. And I think that speaks volumes for collegiality at that court. But I must also say that the judges at the Constitutional Court work extremely hard. When I met the clerks for the first time, I asked them, what do you find most difficult? So we have these 30 clerks, whatever number they are, and I asked them, what do you find most difficult about being employed at this court? And I was comforted by their answer because I had experienced exactly the same problem. And the answer was the emails. I mean, everything is done via email. The applications for leave to appeal are relentless. You've heard about that. The judges work extremely hard. And in the middle of all of this, you can be confronted with an urgent case that requires the Constitutional Court to determine it expeditiously. And I had that experience when, as you know, Chief Justice, we dealt with the One South Africa case dealing with a 15% requirement to qualify as an independent candidate, and the New Nation Movement case, which challenged the composition of the National Assembly. So in the middle of that workload, the elections are looming, and you've got to deal with an urgent application of this nature that has serious consequences, that involves radical and basic, really fundamental rights, such as the right to vote and to stand for public office, and the composition of the National Assembly, and whether it complies with the constitutional requirement of proportional representation. So my experience in that court showed me that the judges work extremely hard. It's no easy place. By the same token, there's a human side to things. And I think being a judge, you can't be aloof. You, after all, are a servant of the people. And I had a very good relationship with the clerks, to the point that when the clerks had their farewell on the clerk's farewell, my clerk, Mr. Thomas White, said, and I was quite touched by this when he said, well, Judge Schippers was not only a mentor and really gave me a love for the law and as a passion for the law, but he said he was like a father to me. And that to me was far more important because there is that human aspect. And as recently as 2 weeks ago, Thomas sent me a WhatsApp with my alma mater emblem, Veritas from Harvard. He had won a scholarship. I had written a recommendation for him, and he was admitted to Harvard. So it has been an absolute joy to be there, but really hard work. Thank you, Chief Justice.
Thank you very much. Now, there are numerous reported judgments that you wrote, both when you were a judge in the High Court in the Western Cape, as well as judgments that you have written as a judge of the Supreme Court of Appeal. Is that right?
That's correct.
And you have referred us to them and included some of the judgments and judgments that you have written in the Constitutional Court as well. Is that correct?
That's correct.
Now, with regard to judgments that you have mentioned in your questionnaire,
yes,
as the most significant, one of them is AfriForum. Would you like to share with the commissioners what AfriForum was about and why you regard it as that important?
The issue in AfriForum was whether the gratuitous public display of the flag was hate speech, unfair discrimination, or harassment as meant or as within the meaning of those terms in the Equality Act. AfriForum said it was a cultural symbol, and basically the first line of defense was that they were entitled to display this flag as it was displayed at the Black Monday protests to commemorate to protest against the murder of farmers, and that it was a form of expression. They were entitled to display this flag. I came to the conclusion that the flag was no benign cultural object. The message being sent by those who display the flag is clear. Life in South Africa was better under apartheid, and black people are to be downtrodden, despised, and denied their humanity solely on account of their race. I remember when I wrote this judgment, and this was not in the papers, there was a reference to the fact that Mr. Dylan Roof, who had murdered 9 parishioners in the United States, went into a Bible study, sat with them, and then murdered them, shot all of them, 9 of them. And I recall that there was only a reference in the papers to the fact that Mr. Roof had affixed to his jacket the old South African flag. And below that, the old Rhodesian flag before it became liberated and gained independence and became Zimbabwe. And I recall writing this judgment early in the morning. It was something like 3 o'clock. And I went onto the internet and I watched his interview conducted by the FBI. And as was, I say in the judgment, what they said about this man, about his racism, his hatred for blacks, his embrace of white supremacy was chilling. And it dawned on me how a symbol of this kind and the impact that it could have on humanity. What are you saying when you display this flag? What does that flag signify? You'll recall in the papers there was Mr. Hatang who said that it reminded him of when his mother used to go down the road and work in white areas in service of his grandmother, and white children used to shout at her, "Here comes a baboon." And one doesn't really appreciate the depth and the sheer, I would say, gravity of racism unless you read these stories and you realize the impact that this flag can have. And for those reasons, I came to the conclusion that this flag was a symbol of hate within the meaning of that section, that it was a form of unfair discrimination, and that it was a form of harassment, and that it has no room to be gratuitously and publicly displayed. If you want to celebrate its historic significance, you can do that in an environment and within a museum.
Thank you very much. Do you want to say something about the case of Gongose and others?
Don Kose, the issue was whether the appellants were exercising their customary rights. They were found guilty of attempting to fish in a marine protected area. And the minister's case, in short, as I recall, was that the appellants could have applied for the permit, but they did not. And it was one of the first cases where I came to the conclusion that the customary exercise, the right of a customary right, in other words, a fishing right to go and fish in a protected area, was protected under customary law. The appellants had presented evidence in that case to show that they had practiced this since time immemorial. They produced expert evidence. Quite apart from that, they also showed their association with the sea in relation to their traditional practices and their customary practices. And I found that there was no post-constitutional extinguishment of their customary rights by the Marine Living Resources Act, which was the act in issue there. I also found that it was unnecessary to apply the Canadian standard, that is, interference with customary rights has to be clear and justified, or Australian law, that the requirement of a permit does not sever connection with Aboriginal peoples with land. Instead, I applied Section 211 of the Constitution, which enjoins courts to apply customary law, rendered subject only to the Constitution and legislation dealing specifically with customary law. And I found that the appellants proved a customary right of access which was not inconsistent with the environmental rights under Section 24 of the Constitution. And the landmark significance of this case was that the exercise of a customary right was for the first time regarded as a defense to unlawfulness in criminal law.
Thank you. You have said in matters where the constitutional validity of legislation has been an issue. Is that correct?
I've sat in, I should qualify that, Chief Justice, and that is, I've decided a matter in the Constitutional Court which was delivered, the Scalabrini case referred to in the questionnaire was delivered in December 2023. And that case dealt with the declaring unlawful two provisions of the Refugees Act. Those provisions stated that unless a refugee renewed his or her permit within 1 month of expiry, they were deemed to have abandoned their asylum applications and could be dealt with as prohibited persons under the Immigration Act. The High Court found that these provisions were unconstitutional, and the Constitutional Court had to confirm its unconstitutionality in accordance with the powers conferred on it in 172 sub 2. And I upheld the order of constitutionality, or the unanimous judgment of the court, I should say, upheld the issue of unconstitutionality because those provisions violated the right to dignity. They violated children's rights as well as the principle of non-refoulement, which is a subject close to the heart of Judge President of the Gauteng Provincial Division, Judge Malambo. But
Maybe let me interrupt you. I didn't necessarily want you to discuss it. I just wanted you to confirm that you have sat in such matters.
Yes, and then can I just mention one other matter, and that is in the capacity of the at the SEA. It's a matter of DA versus the Minister of Home Affairs, and that dealt with the unconstitutionality of Section 6 of the Citizenship Act, in terms of which it was declared that those provisions are unconstitutional because they provided that if you acquired citizenship of another country, that you automatically lost South African citizenship. That matter is pending confirmation before the Constitutional Court. Thank you, CJ.
When you have concluded in a particular matter sitting in the Constitutional Court that either a statute or a particular provision is constitutionally invalid, and that's one of the orders you are going to make, what other matters should come to your mind as matters that you must apply your mind to in relation to the orders that you should make?
Well, as you are aware, CJ, 172(1)A says you must declare invalid law or conduct inconsistent with the Constitution to the extent of its inconsistency. But then, when you make that order, as you point out, the court then has to balance two important considerations. The first is the obligation to provide appropriate relief under Section 38 of the Constitution. And the second is that that relief must be just and equitable. Another consideration, of course, that you take into account is the principle of separation of powers and the deference that the court owes to the legislature in devising a remedy. So what the court then does is that the court is given the power in 172(1)B to make an order that is just and equitable. What does that order do? That order, as I understand it, regulates the impact of the declaration of invalidity. How do you regulate the impact of invalidity? There are a number of options. The first is severance, where you sever the good from the bad. The second is reading in, which controls the retrospective effects of the declaration of invalidity. And the third, you could suspend the declaration of invalidity and give Parliament a chance to correct the defect.
In terms of Section 167, the Constitutional Court has jurisdiction in regard to a number of matters. And in terms of Section 1674, it has jurisdiction, exclusive jurisdiction in regard to some matters. Do you remember just one matter in respect of which it has exclusive jurisdiction?
Yes, as I recall, it's exclusive jurisdiction in relation to matters involving the conduct of the president, particularly in executive conduct. And one of those cases that comes to mind is Law Society versus the President of South Africa, relating to the protocol that was signed by former President Zuma, where the court found that the conduct was unconstitutional.
You were checking in the Constitution.
Yes.
Okay.
If I can just, it's one thing.
And tell the commissioners what you know about reading in and reading down.
Well, as I've indicated, reading in controls the retrospective effects of a declaration of invalidity. And what the court does when it reads in, it generally applies notional severance. One of the cases that I've listed in the Constitution, in my lists of judgments, is IUC versus the IBA. I was involved as counsel of that case, in that case. And that case had a provision where the clause 2A of the Code of Conduct found that the broadcasting of material which is likely to prejudice relations between sections of the population was overbroad, because that provision would sweep within its wake legitimate speech. There the court read down the provision by stating that it applied notional severance. It declared that clause 2A was inconsistent with section 16 of the Constitution and invalid to the extent that it prohibited the broadcasting of material likely to prejudice relations between sections of the population. But then it added the proviso, which rendered it constitutional. And that proviso was provided that that order did not apply to incitement for war, propaganda for war, incitement to imminent violence, or the third one, incitement, advocacy of hatred. In other words, what the court did there was that it read into that provision section 16.2 of the Constitution. Another example would be the Ferreira versus Levin, where the court also, through reading in, applied notional severance and said that you could not take the fifth, as it were. You could not refuse to give evidence at a 417 company law inquiry. But then it provided, again, by reading in, to say that it adds a condition that such evidence is inadmissible in criminal proceedings. Reading down is something else. Reading down happens when it is really a form of statutory interpretation. As you will know, Section 39 requires one, when you interpret legislation or when you develop the common law, to give effect to the spirit, purport, and object of the Constitution. So reading down is really, its purpose is to avoid inconsistency between the Constitution. But of course, there's one caveat. When you want to read down a text, you must make sure that that statute or act or whatever the impugned provision is reading, when you read it down, that the text is reasonably capable of being read down. So in the one case, it's a remedy. In the other case, it's really a form of statutory interpretation.
And what's the difference between actual severance and notional severance?
Actual severance is where you remove the actual offending words or words of a statute from a legislative provision. Notional severance is normally used when the statute is overbroad and you want to restrict its application. And I've given you the examples. The statute's overbroad, you want to restrict its application. The two examples I've given you is IUC versus IBA and Ferreira versus Levine.
And what's the principle of subsidiarity?
The principle of subsidiarity simply states that where a effect is given to a constitutional right in a statute, you cannot rely directly on that provision of the Constitution. One of the cases that I've cited is, for example, Beto Star. And so when a party wants to challenge a decision on the basis that it is administrative action that is unlawful, unreasonable, or procedurally fair, you cannot rely on Section 33 of the Constitution directly. You've got to go via the Promotion of Administrative Justice Act, and it was decided in Beto Star that that particular act was intended to cover the judicial review of administrative action, and it does so.
Section 1771 of the Constitution sets out 3 grounds on which a judge may be removed from office. 2 of those are gross incompetence and gross misconduct. What is the constitutional significance of that choice made by the drafters of the Constitution to say a judge may not be removed from office for mere incompetence, it's got to be gross incompetence, and for mere misconduct, it's got to be gross misconduct?
Can I answer that question in 2 ways, Chief Justice? First of all, the Constitution recognizes that the judiciary is independent. So its foundation is really the independence of the judiciary. I think it was an article written by Justice Mohammed, who said that, independence of the judiciary goes to the very heart of democracy. Subvert that independence and you subvert the very foundations of the society that it protects, and you subvert effectively the rule of law. So there's a reason why you have these provisions. Judges need to be independent and they need to be protected. On the other hand, there is a public dimension to it. And the public dimension is this, and we've dealt with this case recently. I was on the panel in Motata, FUL versus Motata. And the standard for gross misconduct is whether the conduct of the judge is so manifestly and totally contrary to the impartiality, integrity, and independence of the judiciary that the confidence of individuals appearing before the judge, of the public in its justice system, would be undermined, rendering the judge incapable of performing the duties of his office. Let me hasten to add, the court did not define, because it wasn't necessary, to define precisely the standard. But that generally, internationally, is the accepted standard. But on the facts of that case, the court came to the conclusion that this was the type of conduct that would undermine public confidence in the judicial system and would render the judge incapable of performing the duties of his office.
I will now give the Minister an opportunity to ask questions if he has any.
Thank you very much, CJ, and good afternoon, Judge Sipas.
Good afternoon, Minister.
With regards to the Afro Forum and the Nelson Mandela Foundation matter, which is, for me, one of those exceptional cases where the Nelson Mandela Foundation decided to protect a right. What do you think could be the lessons for many such organizations that were involved in the struggle to be active in not only promoting the rights enshrined in the Bill of Rights or in the Constitution, but also to promote, to protect and also to develop, to continue to participate in the development of the Constitution, such as the other foundations of our struggle stalwarts, or even organizations like NADEL, PLA, and other organizations that were involved in the struggle for what we now have as our constitutional democracy, and not just leave it to nature.
Yes. Yes, thank you, Minister. I think that what this case illustrates is the beauty of the Constitution. One, for example, particularly non-profit organizations are entitled to advance their rights and can, in fact, approach a court on any basis, obviously, if it's sourced in the Constitution. And an example, one of the examples is the Freedom Under Law case, which sought to advance the independence of the judiciary and to protect the judiciary. There are various other organizations that could take a leaf from the book of AfriForum, because even though AfriForum, even though it was a personal, there were personal incidents which indicated that there was a violation of the equality provisions of the Equality Act and the fact that it was hate speech. The bringing of the action was to the benefit of all. We know now that whenever this flag is going to be displayed, that unless if it is gratuitously displayed, then it constitutes a violation of the Equality Act. So various other organizations, by similar means, can, for the benefit of society as a whole, utilize the provisions of the Constitution. They are, after all, enforceable rights.
The reason I'm asking you this question is because there's a paucity of such progressive organizations like the Nelson Mandela Foundation and other progressive organizations that were there during the struggle to promote, protect, and advance the rights. So I will just want to hear more about what do you think, I mean, this is a role that the Nelson Mandela Foundation played, and in terms of this advancement, particularly the development of the Constitution that has now been left to those sometimes who were not there when
Yes.
during the period of the struggle.
Yes, I think that people are aware of their rights, and particularly when it comes to children's rights. I mean, I think there's a paucity of non-profit organizations to advance children's rights. The provisions of the Constitution are there, and many times the difficulty is to have an organization that has a structure, such as maybe Women's Legal Center, that advance the rights of women. And the other problem one has is resources. But there's no reason why people like organizations like the Nelson Mandela Foundation cannot, for example, partner with other, not partner in the sense of become, to lose their identity, but partner in the sense of bringing joint applications. And the neat part about our Constitution also is that it allows for this, particularly when when one has regard to the amicus curiae provisions, which allow parties to intervene in proceedings if affecting human rights and thereby promote human rights. That's the furthest I can take it, Minister.
Yeah, my last question relates to a question I've been asking all your colleagues. You come also from the Supreme Court of Appeal.
Yes.
And Justice Matapo, when we interviewed him here, he made a proposition to the extent that his view is that we should collapse or merge, for lack of a better word, the Supreme Court of Appeal and the Con Court, because in the Supreme Court of Appeal you work in in chambers or panels, which could benefit the apex court if we do that, have the panels that are now merged, including the benefits of the additional judges that will have come out of that. Do you think that could enhance access to justice and also maybe help with the litigation costs, that one layer of litigation will no longer be there, but there will still be a benefit of an apex court, which works in a form of a panel or of some sort?
Yes, Minister, with respect, I take a different view. And the reason why I take a different view against the merger of the two courts is that the Constitutional Court has established its place in the hierarchy of courts as the final arbiter which pronounces upon cases of the greatest constitutional and public importance that deserve only the apex court's attention. It's got that unique role, and in my view, it does fulfill that unique role. My second response to your question, Minister, is that it's simply not practical. And I say this because in the SCA, you have about, and the President can correct me if I'm wrong, President Molemela, you have a complement of 25 judges.
Now 26.
26. Thank you, President Molemela. 26 judges. Now you got 11 judges in the Constitutional Court. So what you will have on an apex court is 37 judges in a single court to serve a population of something like 60 million people. I don't think that's workable. The United States Supreme Court serves 330 million people. There are 9 justices. So where does the difficulty lie, Minister? I think the difficulty lies, and you would have heard of this, probably I've seen some of the interviews conducted, for example, in 2022, and you've heard this, it's a recurring theme, that the CC receives about, the Constitutional Court receives about 400 applications for leave to appeal annually. The SCA, as I have it, and again, the President will correct me if I'm wrong, receives more than 1,000. So you collapse these courts into one and you will have a single Constitutional Court with 3 times its current workload. Bearing in mind, of course, that you need judges in the Constitutional Court to sit on bank on applications for leave to appeal. So with respect, I think it's simply not workable. I think the Constitutional Court has carved out for itself a unique place in our constitutional jurisprudence and in its ability to pronounce upon the cases of greatest constitutional and public importance.
Thank you, CJ.
Thank you, Minister.
Thank you, Minister. Justice Molemela.
Good afternoon, Justice Skeepers.
Yeah, thank you. Afternoon, President Molemela.
How are you?
I'm well, thank you. How are you?
I'm well, thank you. I just want to follow up on the minister's question and to readily point out that there's no right or wrong answer to the question, but it is a question that is being posed. And I think it is very key to pose it to people like you who have actually acted at the Constitutional Court in the hope that perhaps you could make suggestions that could help in assisting with the problem that is experienced at that court, because it is public knowledge now that since 2013, its workload has increased tremendously to the point of actually impacting on the handing down of judgments. And several proposals or propositions have been made, one of them being for that court to start working in panels in relation to applications for leave to appeal, for example. And a comparison has been made with various other apex courts in other jurisdictions. You alluded to the United States, for example, which has 9. There's, I think, Germany, speaking under correction, which I think has 16 as the complement of judges. So my question is, would that court, if it were to work in panels, for example, would it benefit from having more judges? In other words, the complement of judges being increased from 11 to a higher number, for example. What's your view on that?
Yes, thank you, President Molamela. I've indicated that if you're going to have an apex court, then I suppose there's no reason why you should not have panels of judges hearing particular cases. But bearing in mind, when you look at the system as it works now, there's almost, as it were, a sifting process, because the Supreme Court of Appeal does a large number of cases. And although there is a tendency now, as almost as a matter of course, to go to the Constitutional Court on further appeal, the major backlog happens particularly with the increased jurisdiction of the Constitutional Court, which you've heard about before, and I don't need to go through that again. But suffice it to say that panels at least of 3 dealing with applications for leave to appeal would significantly reduce the workload, in my view, of the Constitutional Court. And then the question arises, if that is a possible solution, do we really need a merger? Because I think
No, I think you misunderstood my question. Sorry for the interjection.
Sure.
So mine is separate from a suggestion of a measure, just the increase in the complement of the judges without merging 2 courts.
Yes, I suppose there's no, one can increase the complements of judges and let them work in panels. I don't know how that will work in practice, but theoretically it seems to me to be a possibility.
Yes, thank you very much. You have been a justice of the Supreme Court of Appeal. You said in June it will be 6 years now. And having worked in that court, I think you'll agree with me that you have been exposed to a wide variety of matters covering almost every branch of the law. Would that be a fair assessment?
That would be a very accurate assessment. And let me say, in my practice, courtesy of briefing patterns, I've never ever done a shipping case. I've never ever done a intellectual property case. But at the Supreme Court of Appeal, I had the opportunity of writing judgments on shipping cases and on intellectual property. And you get a wide array and variety, even criminal law, which some cases can be quite important.
Yes, thank you very much. So in addition to that experience, you have now acted for 2 terms at the Constitutional Court. So how has it added value to your experience, your acting stint at the Constitutional Court?
Yes, thank you, Justice Molamela. I think, President Molamela, it has made me realize that, first of all, my appellate court experience has been almost invaluable. It's not like a high court where you make a decision and there's a further appeal against your decision and somebody can correct it. You learn at the appeal court particularly that you write for the rest of the country. And because you have that mindset and you have the concern that your judgments have consequences, it made it a bit easier at the Constitutional Court to deal with constitutional issues and other issues. And again, as I've said before, it impressed again upon me the importance of recognizing the consequences of your judgment. When you write, and I've had this discussion about 10 days ago with the Chief Justice when we had a discussion about the case, you've got to look down the road. What is possibly coming? You must even have some kind of idea of what is coming around the corner, because you can make a decision and you can override the judgment. You must be very, very careful that you decide only what you are called upon to decide, and that the judgment cannot be misinterpreted and utilized to establish some other principle which you never intended when you wrote it.
Thank you very much. When you peruse section 167, subsection 3 of the Constitution, it relates to the jurisdiction of the Constitutional Court. A simple reading of that clause creates the impression that it should be fairly easy to determine whether the jurisdiction of the Constitutional Court is engaged or not. However, I know of at least one, if not more, case of the Constitutional Court where the court itself was split in relation to whether an issue raised a constitutional issue or not, and also on whether it raised an arguable point of general public importance. What are the factors that should be taken into account in making this determination?
Well, there are numerous cases that say this, but as I understand the position, when you're talking about a constitutional matter, you're talking about the interpretation, the protection, and the enforcement of the Constitution, or legislative interpretation, or an issue involving the application of Section 39(2) of the Constitution. Likewise, the exercise of public power or constitutionally envisaged legislation such as the Labour Relations Act or the Promotion of Administrative Justice Act are all constitutional matters. And when you're dealing with the court's power, you're also talking about a constitutional court, rather a constitutional matter, or when you're talking about fair procedure. When it comes to matters of public importance, there the Constitutional Court considers whether there are new and difficult questions of law. It will consider minority judgments that are very forceful in the SCA, or a majority judgment that is not necessarily persuasive, or where you have a situation where the academics have commented on a particular aspect of law, but it has not yet been judicially determined, or when there are divergent opinions in the lower courts on a certain legal issue.
Thank you very much. My final question to you is this one, and I will preface it with what the Constitutional Court stated in the case of Women's Legal Center versus the President. And it said the power to grant litigants direct access outside the court's exclusive competence is one this court rarely exercises.
Yes.
Yes. Now, there have been a number of articles written by academics where they have lamented this in some instances, saying that it is a lost opportunity for the Constitutional Court to dismiss an application for direct access, only for it to a year or two later now come and decide the same issue as a court of final instance. What are the circumstances that one should take? Or let me put it this way, what are the advantages of granting direct access? Because those who advocate for it say that it brings quicker certainty.
Yes.
So yes, what are the advantages thereof as opposed to the disadvantages?
Yes, thank you, President Molomela. I think it depends, of course, on the nature of the case. Some cases don't lend themselves. Ideally, what you would like is the Constitutional Court to determine, to have the benefit of the lower courts, particularly the views of the SCA when it comes to determining matters, because after all, it helps the court, and it also is a recognition of the doctrine of comity. But there are certain cases where you cannot do that. One case is example that I was involved in was Mohammed, where you have a situation where the person is handed over to the United States, to the FBI. He faces the death penalty, and there is no time for a lower court to pronounce upon it because the matter is urgent. There are other cases where there are benefits, and I take your point, President, that it may be later down the line the court might decide it. But I think that is the way, I suppose, it happens in practice. because some cases, like One South Africa, New National Movement, cannot wait on the decision of a lower court. And the Constitutional Court has set out the precedents stating why the circumstances and in its rules when direct access would be granted. And as long as it retains consistency, and I believe it has, in the application of those rules, there should be no difficulty. It will happen, of course, as you point out, that there will be cases that subsequently are decided by the Constitutional Court, and you might say, but we could have decided this 2 years earlier.
Thank you very much, Justice Skeppers. Thank you, Chief Justice.
Thank you very much. I didn't keep account whether that was 2 or 3 or 4 questions.
It was 3, Chief Justice. The first was a follow-up to the Minister's question. Thank you, Chief Justice.
All right. Commissioner Marumohai.
Thank you very much, Chief Justice. Good afternoon, Judge Skeppers.
Good afternoon, Mr. Mogai.
Marumo Akai.
Marumo Mogai, thank you.
I wanted to deal with the Makate judgment, but obviously for reasons that you provided, that it has already been taken to, so I will leave it there, because
Yes.
there is really an aspect that I really wanted to converse with you. The Constitutional Court has had occasion to deal with cases that calls upon it to interpret either regional instruments or international instruments. I think one of them, it was the International Trade Administration Commission. The decision there was granted by the former Deputy Chief Justice Moseneke. It was heavily criticized in the economic circles, in the academic circles. And then there was the SADC decision. That was, I think, the person who penned that judgment, it was a unanimous judgment, was the former Chief Justice Mogoeng.
Yes, the Law Society case.
And yes, and it appears to me that there is a worry with respect to the grappling of international law principles and how South Africa should actually grapple with them, or the Constitutional Court should grapple with them. I'm not sure if you are aware of these debates, and if you were to be appointed, how would you contribute positively in ensuring that at least that court seems to be dealing with the international law generally better, to the extent to which those criticisms have merit? I'm not saying that they do.
Yes, thank you, Professor. My response to the question is I don't know, I'm not aware of those debates. But when one has regard to for example, to the Law Society case, the Constitution enjoins the court to take into account international law. There's no question about that. But by the same token, there's always this, like in the Law Society case, you had for example, you had the powers of the president. Powers of the president was to be involved in international relations, and it's the executive's exclusive power. I think it was section 232. And then the court found in that case, as you point out with Justice Mogoeng, that the president, even though that power was the exclusive purview of the executive, the court still has to apply the Constitution, and specifically Section 7.1, which is the Bill of Rights being the cornerstone of democracy, Section 8.1, where the Bill of Rights binds the executive, Section 8.2, where it binds a natural person. So ultimately, because of the supremacy clause, you're going to have this debate, because the court would have to navigate a very careful path. Because you will recall in that case, the president signed a protocol which removed the judges which rendered the SADC tribunal for claims by individuals against member states impotent because there were no judges. So international law has its role, but ultimately it's the supremacy clause and the Bill of Rights that has to be interpreted together with international law to resolve the issue. But fundamentally, really, in my view, it's a supremacy clause.
No, thank you very much, Justice Kiepas. My last question to you, it is something that it has been there with respect to the role of contract law. I mean, the Constitution in terms of contract law.
Yes.
How do you infuse between the two? There are those who are saying, look, leave contract as it is, don't interfere with it, because you're going to create uncertainty and all those. And there are those who are saying, no, like you have just said, the supremacy principle, you need to. I'm not sure if you are aware of those kinds of debates. What if you are and you have thought about it? Where do you lie in between? Because there seems to me that there has been differences of opinion between the judges of the Supreme Court of Appeal who have retired and some of the judges of the Constitutional Court.
Yes.
And now that you are moving from one court to the next, one would want to know where you sit on this debate.
Well, one of the questions, I think one of the cases that illustrates the point is the Bidika case, where you've got to infuse constitutional concepts into the law of contract. And my response to that is your position is dictated firstly by principle, as you will appreciate, but also by the Constitution, because in Barkhuizen, for example, the court held that public policy was informed by Ubuntu. And as we know, Ubuntu, I think one of the best definitions I could find was that of Justice Madala in Makwanyani, that it carries the idea of humaneness, social justice, and fairness. So in the field of contract, you can apply the principle, but the court has already given effect to the principle of Ubuntu, and gradually that will have to be developed. But to answer your question, I would apply the principle and as far as possible, make sure that there is effect given to the spirit, purport, and object of the Bill of Rights, because after all, the contract law is common law.
Thank you very much, Chief Justice.
Chief Justice, may I ask for your permission to follow up on the contract question?
Yes, okay, thank you.
Good afternoon, Justice Skippers.
Good afternoon, Mr. Kutobi.
Very nice to see you. Now, on this point of contract, we had an interview with the Justice Unterhalter a couple of months ago. And
Yes.
as you know, he is the author of the famous or infamous Capitec judgment.
Yes.
And he pointed out that there is a real risk that this country will fail to develop what he called a constitutional vision of contract.
Yes.
And the conflict really is illustrated by the discussion you've had now with Professor Marumoahai,
Yes.
which is we seem to be giving platitudes to constitutional development in contract. Because in truth, what we do, we take a clause in a contract, we look at its meaning, we give it effect. And we do that over and over again. One day someone says this is unfair, and then we say fairness has got no bearing on contract. Yeah. Now you've just said, oh, well, let's look at Barkhuizen. It has a sentence that says Ubuntu. Yeah. And Ubuntu is a much broader concept. It includes social justice, it includes communitarianism, it includes fairness. But the law right now is that you cannot strike down a clause in a contract because of fairness. And so where exactly are we discussing this constitutional vision of contract? So I suppose my question to you is really this, is what are the tools that you are going to use as a judge of the Constitutional Court to actually reform the law of contract? We are dealing with the law of contract that we imported from Jan van Riebeeck. And then the English came and introduced theirs, but it has stayed very stubborn. And this is the point Justice Unterhalter made, that actually there's a real risk in this country that there will be no development of a constitutional vision of contract. So I just want you to explain your own vision going to the Constitutional Court of engaging with this vexed question of contract.
Yes, thank you, Mr. Nkatobi. It's a very difficult question because ultimately the difficulty is you want to create certainty in the law. But like everything with development, there's got to be that one point where you're going to make this change. And it seems to me that I think the starting point is to look at those provisions and to ensure, it seems the only principle I can, and I've not applied my mind to this question in detail, but it seems to me that the only principle I can think of is justice and fairness. But it's a difficult standard, and then the impact, of course, out there in the real world is to make sure that you gain certainty in the law of contract, because you're going to affect the commercial world out there. But in the first case, of course, when that development starts, it will have to be finely drawn, and I'm not sure, I haven't thought about it in detail, and I'm not sure that a radical departure is warranted or whether one does it incrementally. I'm afraid that's the best answer I can give you, Mr. Nkatobi.
No, I appreciate that, Justice Skippers. I guess what I'm really struggling with is that everybody says the common law must be interpreted through the prism of the Constitution. I fear that that has become a slogan, because when a clause is in front of you, you look at its meaning, its plain meaning, and that is how Pacta Servanda Sunt has actually survived the Constitution. So that's why I ask, well, we're trying to make you a judge of the Constitutional Court, but what vision are you bringing to the Constitutional Court insofar as the true transformation of the common law to be in line with the Constitution? But I guess your point is, well, you will see when the case comes.
Yes.
Commissioner Nojesi.
Thank you, CJ. Good afternoon, Justice Keepers.
Good afternoon, Mr. Ngwesi.
Yeah, I'm one of those who say thank you for coming here. I just want to ask you only one broad question. This arises from the debate subsequent to the order, if you are aware of, issued by, or directive issues by Judge Motta in the Gauteng Division, where he questioned legal representation. If one...
Sorry, wait, question, I'm sorry?
The question will relate to that.
Oh.
Yeah. If one have regard to the preamble of the South African Constitution, one of the commitments is that it is intended to improve the quality of life of all citizens and free the potential of each person. In relation to that, what is your view about transformation regarding briefs in relation to briefing patterns?
Yes.
And also, if you can, broadly, answer whether our courts, in terms of economic transformation, is there anything that has been done? And if any, how would you go about, or what role courts can play in that regard? It's just a broad question like that.
Yes. Thank you, Commissioner. On the question of briefing patterns, I've been out of practice for the last 20 years or so, and I don't know if they have changed. I doubt that they have. My own view is that there is a stubborn resistance, particularly in boardrooms, where private firms in particular don't brief black counsel and women counsel as frequently as they should. Apart from that, and that has been my experience, and I suppose the experience of many people around this table, that there's also an expectation that you have to prove yourself, quote unquote. You have to demonstrate that you have certain abilities. And it's difficult to change that mindset because, and then you can also understand, Commissioner, why you have things like the Employment Equity Act. You don't have that, you're not going to get that necessary achievement of equity. So I don't know if I'm answering your question, but it's difficult to say from the bench what should be done. But there's no reason why you cannot, even when you have conversations with people in the profession, and they look up to judges, where you can actually say to them, but I've noticed that when you've instructed X, Y, and Z, why is it that you haven't instructed A and B? And I think that's the most one really can do on a private and on a social level.
Just as a follow-up, because I thought it's one. There's this directive, it's unfortunate if you have not seen, that Judge Mota issued where he questioned legal representation. He actually take a positive step as a sitting as a court. And in this forum, the former Chief Justice Mkhweng would repeat that. And there are a lot of, you have in your court on key questions, on particularly those commercial cases,
Yeah.
where you see that blacks are not even appearing in most of the time. I'm just trying to see if would it be proper for just judges, or in your case, just to question or to take some step to say, this is what is happening is transparent in this court, and then make some steps as Judge Mota did, or do you agree or you don't agree with this approach? That's the last question.
Yes, thank you, Commissioner. I'm not sure that one can, as it were, from the bench, question why certain advocates have been briefed. But if one notices a tendency, one can, I suppose, privately, and also where we are invited to provide talks and so forth to address the question, or even write papers on it. I think the academics should, take steps to make sure that, rather to encourage this kind of discussion and debate, but more than that, that the practice be followed.
Thank you, Judge, and thank you, Chief Justice.
Thank you. Commissioner Mangena, I hope I tried.
Thank you, Chief Justice. You got it right.
Thank you. I was looking at Commissioner Nguraitobe and he seemed to doubt that I got it right. So I'm happy to be vindicated.
Yes, I think I'm wrong. Good afternoon, Justice Shubas.
Good afternoon, Mr. Mangena.
Yes. Yes. Without being presumptuous, I would want to believe that you'll agree with me that law serves the people and not the other way around.
Excuse me, not the?
Law serves the people, not the other way around.
Correct.
Yes. Now, once the people feel that the law does not serve them, they consider it unfair, they consider it unjust, and then feel not obliged to observe it. You agree with that?
Well, I would think that if the law is, if people were to adopt that position, that they don't need to observe the law because the law is unfair or unjust, then in my respectful view, you'll have an unruly society and you'll have chaos.
Very, very true. And in the context of Gongo's judgment,
yes,
you had a situation wherein the law was pretty much clear that if you do not have a permit to fish,
Yes.
you are committing an offense, which is a contravention of an existing legislation.
Yes.
And the High Court confirmed the conviction. But then I'm impressed with the approach that you adopted in your judgment that sought to vindicate the community's rights, because in spite of the community's knowledge of the fact that they needed to have a permit, they've always held the view that that law was unjust, right? Now, and which was an innovative way of looking at it, because you had a situation wherein law was clearly in a collision with justice. So, and the approach that you adopted was, for me, very good. And I thought I should comment you on it, but also ask you if that is the kind of trait that you will take with you if you are to be appointed to the Constitutional Court, where you will be proactive in making sure that regardless of what the law is, you would always look at the Constitution as you did with Section 211 of the Constitution in Gongo's case, to ensure that justice is advanced.
Yes, thank you, Commissioner. I have one answer to that, a single word, absolutely.
Thank you.
Sorry, Chief Justice, I do want to just follow up on this single word.
Okay, Commissioner.
No, the reason is because I think Justice Skippers actually can expand on this, because it's very important to the discussion we were having about contract.
Yes.
But this is now customary law, which is
Yes.
another ugly stepdaughter of the Constitution, because it's as ignored as a development of contract.
Yes.
Now, the question I want to ask about Gongose, every time I teach pupils customary law, it's one of the first cases I refer to, because what it illustrated is that customary law can be a defense to a criminal charge, which in fact is the first time it has ever happened, because it negates the unlawfulness component. But it has a much wider historical significance, because as you pointed out, the Xhosa speakers of that area, Dwesa Cwebe, had lived there for more than 1,000 years with a form of life. And the white colonizers came and imposed a system of access to the sea and access to fish and access to the river, which over time became embedded in regulations. And the regulation in issue there was the Transkei regulation. Now, in that sense, it's a promise to what is possible under the Constitution, which is the Constitution recognizes custom as a source of law in the same status as the common law, in the same status as the statute law, although the statute can amend the custom. But customary law is grossly underdeveloped. So that is why I think you could expand on the impact of the Gongose case on the jurisprudence, and whether that is something you think the Constitutional Court itself, right, needs to give effect to, beyond the slogan that customary law is equal to the common law, to actually show its foundation. I mean, what we know statistically in this country is that 22 million South Africans are living under customary law, almost half the country. And yet their legal system is still treated as a secondary legal system.
Yes. Yes, thank you for that question, Mr. Kaitobi. I think you are correct. The case illustrates the potential of customary law being used and also being developed, because, as you point out, there were, if one look, for example, at the Gongose case, the customs that they had were not to not conserve the the resources. Quite the contrary. And when one uses that to show that, but there was conservation here, in the same way as you point out, I think that the principles of customary law, for example, could be applied in a different situation when that particular issue comes up. And the court has to grapple with it and to decide whether or not the customary law principle should should trump the common law on that particular aspect.
Do you think customary law can trump the common law of land ownership?
Well, it has, if I may say so, particularly in the Richtersveld case. Although that was pre-constitutional, there's no reason why post-constitutionally you can't apply the customary law. When I say pre-constitutional, I mean that pre-constitutionally the rights, the persons, the Richtersveld community's rights were taken away. But that doesn't mean that it cannot apply post-constitutionally.
Thank you.
Follow-up, CJ.
Sorry?
Moima.
Oh, okay, yes. Okay, go ahead. On my list, that's the last edition, except for those on virtual, if there is anyone who has indicated, and Commissioner Pillay, and that will be it. Thank you, Commissioner Moiman.
Thank you, CJ. The question that I want to pose, greetings to you, Judge. The question
Greetings to you, Commissioner.
Yeah, the question that I want to pose is whether customary law in certain instances, is it not a double-edged sword? Particularly in reference to the point that, as Ingrid has indicated, that 22 million people in our country lives under customary law. Majority of those people live under what we call communal land. And in that situation, they are subjected to a dualism in property regime, in the sense that they do not enjoy the security of tenure, the protection that those that are living in urban areas enjoy in terms of property regime. Those that are entrapped under what we call communal land do not enjoy the same rights to property as those that are living in urban land. So what is that could be done to ensure that the property protection that is afforded to other South Africans is also enjoyed by those that are entrapped under communal land regime, which obviously indicate and illustrate that they do not have the security of tenure. Thank you.
Yes, thank you, Commissioner. There obviously is legislation dealing with that. But as I've indicated to Mr. Ngatobi, that once you have an assertion of customary law rights, it will, and that assertion, and the sad part is, as in Gonkose, is that you unfortunately need resources and you need experts to prove this. But once customary law is established as a right, then it seems to me that when there is an assertion of that right to particular land, it could be enforced. But of course, we have legislation, and the difficulty is that the legislation has specifically provided for restoration of land, whether it be communal land or whether it be under the Restitution Act.
Thank you. Thank you, Chief Justice.
Thank you, Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Justice Skeepers.
Good afternoon, Commissioner.
Justice Skeepers, I just wanted to pick up on the theme of what's possible under the Constitution, and with specific reference to your Mwelasi judgment.
Yes.
Now, you recall that this concerned the appointment of a special master.
Yes.
To address the backlogs in applications by labor tenants
Yes.
to the DG for award of land to which they were entitled to or which they occupied. And you, in deciding whether or not it was appropriate to appoint a special master who would consider a system which would make sure that these applications were processed effectively, etc., you took the view that a special master as a system was foreign to South Africa, firstly. And secondly, you described it as a textbook case of judicial overreach.
Yes.
And then the matter went to the Constitutional Court, and what the Constitutional Court found was because of the very compelling facts underpinning the request, namely the plight of labor tenants and the inability to have their applications processed timeously, that it was a typical matter which warranted the court to introduce an unusual remedy, which is what the appointment of the special master is. Now, looking back at the decision of the Constitutional Court and then your decision in the SCA, do you have different views on the extent to which one can utilize Section 38 for innovative remedies?
I think that's a very appropriate observation, Ms. Pillay. The Constitutional Court found that I was wrong. I accept that. And my concern was that the special master they had in mind was a senior counsel who was going to do a job which the Director General, in my view, should have done. My big concern was that this was going to be a budgetary intrusion. And for that reason, I came to the conclusion that I did. But as you will know, there was some minority opinion, not that it's of any comfort. The fact is, I was overruled in the Constitutional Court. So when, and that dealt with really the separation of powers anticipates unavoidable intrusion of one branch on the terrain of another. But as was stated in De Lange, it also engenders interaction, but it does so in a way which avoids diffusing power so completely that government is unable to take timely measures in the public interest. So in short, the reason for my decision in that case was simply because I thought that the Director General should have done his job and that there should have been proper monitoring by the Land Claims Court judge, because what had happened in that case was that every time an order was presented to the Land Claims Court, all it did was confirm the order. And there was no direct inquisitorial, in my view, intervention by saying, you said this last month or you said this 6 months ago, where are you now? And enforcing the department to do its work.
No, sorry, Chief Justice. I think I started this, what is possible under the Constitution. Yes. I thought what Commissioner Pillay is asking is what is possible under the Constitution, specifically what is possible on innovative remedies under Section 38 of the Constitution. I think the case was used just as a back shadow.
Yes, thank you, Mr. Nkakobi. It seems I've misunderstood the question, but the point is taken.
Thank you, Chief.
Thank you very much. I have not seen any hands in the virtual platform. Therefore, it seems that we have come to the end of this interview. It remains for me to once again thank you, Justice Skippers, for availing yourself. You are now excused.
Thank you, CJ.
Thank you. Commissioners, we are at 2 minutes to 2. Yesterday, we were told that the latest we should get into the dining room is 2 o'clock. I suggest that we take the lunch break and come back and deliberate And I suggest that we take 45 minutes like we did yesterday. That will mean we would be back at 2:45, and then we deliberate. Hopefully, we would be done in a short time. Is that fine?
Chief Justice, I also suggest no caucuses during lunch.
I think, Commissioner Ngweto, you must make an application to the three of us. We can make an order. No caucus. Thank you very much. 2:45 then. Thank you.
We are waiting for you, Miss Photographer. Thank you. Good afternoon, everyone, and good afternoon, Justice Karelse. How are you? Please switch on your mic.
Okay, there you
Thank
go.
you.
Thank you. Good afternoon, DCJ and the rest of the commissioners.
Let me first apologize on behalf of the Commission for keeping you waiting. You were supposed to be interviewed first thing this morning, then that time changed, and here we are. So let's do this. Are you comfortable?
I am, thank you,
Okay.
DCJ.
You hold 2 degrees, a BA and an LLB
That's
from the University of Durban-Westville. You have a long judicial career which started in 1998
That's right, DCJ.
when you joined the magistracy in the Johannesburg Magistrates Court.
Yes, that's right, 26 years ago.
And well, just explain a bit to me. It says magistrates, criminal court / family court, Mitchell's Plain.
Okay. I was in Johannesburg and then I got transferred to Mitchell's Plain. And I was exposed to all areas of law, family court, civil court, criminal court. In Mitchell's Plain in particular, I was exposed to those courts.
All right, but then before you joined the magistracy, you had done a few other things outside the legal field. You were an underwriting clerk for one insurance company and a junior banker at some stage.
That's right. I worked for an insurance company as a trainee underwriter. I'd finished my BA degree and went to find a job in Johannesburg and studied for about a year, saved some money, and came back to complete my LLB degree at the University of Durban-Westville. So
And then you became a public prosecutor.
I became a public prosecutor, I think, in 1994. And I...
And you remained with the magistracy for 6 years before you joined the Johannesburg High Court.
That's right.
Okay. Was that in 2008?
2008, yeah. I was one of the successful candidates on the Bridget Mabanta / Pius Langa Sprint Women Judges program. And that was in 2008. And I never went back to the magistracy after that.
And you remained in that court until 2021 when you ascended to the Supreme Court of Appeal.
That's right, DCJ.
But you had intermittently acted in the land claims court during your time at the High Court.
That's right, over a 12-year period.
Can you just give us the time periods? When did you work there?
Okay, so in 2008, I completed the theory of the aspirant judges conference program. And afterwards, I was mentored. I was assigned to Judge Gildenays, who was at the Land Claims Court. At the time, I knew absolutely nothing about land issues. And so to speak, I was thrown into the deep end. And from about 2009, I think I got appointed on the 26th of August 2009. I was then seconded to the Land Claims Court. I would serve time in the High Court and then serve time in the Land Claims Court. So I got there when just the late Judge Baum was still the head of the court. And that was, 2009. So so I did stints in both the High Court and the Land Claims Court for a period until 2021 when I was elevated to the Supreme Court of Appeal.
All right. I'm sorry, I just overlooked one important aspect of your CV, your stint as a regional magistrate. And I want to mention in that regard a fact you told us about the last time you were here, that you actually took that job to set up a sexual offences court in that area.
Okay. At DCJ, my career path, I've actually been actively involved in areas of the law that were, gender-based violence. I, in fact, at the beginning of my stint as a magistrate, I was seconded to set up guidelines for the Domestic Violence Act. In fact, we set up the Domestic Violence Court in Mitchell's Plain, the first It wasn't in Wynberg, in Cape Town, it was in Mitchell's Plain at the time. And thereafter, I was seconded to set up the Sexual Offences Court in the Cape Town Regional Court. It was, I think, also the first of the Sexual Offences Court. And from there, I was then transferred to, or I think it was the other way around. I set up the Sexual Offences Court in Tembisa as well. It was the specialist court dealing with sexual violence matters for a number of years.
And in 2018, you were lured to the Supreme Court of Appeal and acted there.
Yes,
for
under
how
your
long?
stewardship. Yes, yes, DCJ.
All right. In 2020, you acted as the Deputy Judge President in the Johannesburg High Court, not so?
That's right, DCJ. That was in the height of COVID. I was asked to act during that period. It was a very challenging period, but really one of the highlights of my career.
Yeah, and I mean, you mentioned that one of the law bodies who have commented on your candidature say you served in that position with distinction, to use their words.
Thank you.
How long was that acting stint?
About 6 months, because then I was asked to act again in the SCA, which was from the 1st of December 2020, if I'm not mistaken.
What was the nature of the duties you did during that time?
As a DCJ, I
As
managed
DJP.
I managed about 60 judges. I had to allocate work. In fact, Gauteng in particular, I was also fortunate because I was one of the pilot judges to implement, that had to be trained to implement a case line. So fortunately for Johannesburg at the time, when COVID came, we had already had some training, and of course we went straight into hearing matters. I think Johannesburg was we didn't operate for a week or maybe 2 weeks, but thereafter we were able to do hearings virtually. So I had to manage case lines, I had to manage judges who for the first time had to deal with working online. It was very challenging, but I think we all got on with the job. I had a great relationship with colleagues. I think, I'd like to believe that I had great support from them because, as I said, during that challenging period of time, colleagues bought into the whole idea of online court. And our court ran like it would run like on a normal day. So, the other thing that I found a bit challenging was initially I found that, the male judges were not very receptive, that I was appointed as the acting DJP. But as time went, and I think they came around. I had to assert myself. I'll give you an example. I would tell a colleague, here's an allocation, and they would say, I'm busy with something else. I've played my own role. I'd send the file down and I'd say, well, deal with the matter that's been allocated to you. So those are the challenges that I had. So I had to be firm and assert myself, which I did.
I recall that there was an expectation that you'd make yourself available for permanent appointment to that position when it was advertised.
Yes.
But when the time came, you declined the invitation. May I ask why? And I know that a whole lot of people begged you to take up that appointment.
I had, I call a spade a spade. When I was asked to act, it was really, when I was asked to act, I was asked if I would make myself available for the position. I think my acting stint was dependent on me saying I wasn't going to make myself available. But at the time, because I wouldn't do something I didn't want to do. But at the time, I had started to enjoy the work at the SCA, and I knew that I needed to grow as well. And I knew that I enjoyed judgment writing. I knew that I enjoyed being in court, and I knew that in Johannesburg I wouldn't get the opportunity as often as I would in the SCA to sit in panels and to be able to, be involved in decision making, judgment writing. So I think that was one of the main reasons why I decided that I would take. But also at the time, you know, my heart had always been in the LCC, to be honest, and I've displayed that. But the position for JP or the position, all the act had not come into operation by then, and you know, I'd been in the judiciary for more than 12 years, and I think, you know, human nature, one wants upward movement. And so that wasn't available to me. And as I said, I'd enjoyed my stint tremendously at the SCA and got great value learning from colleagues. And so I thought at the time where I was, that's what I wanted to do at the time.
By my count, you've been a judge for 16 years now.
16 years.
4 of those spent at the SCA.
That's right, DCJ.
Okay. And during this span of 16 years and in all the courts in which you have sat, you have produced written judgments, some which have been reported.
Yes, DCJ.
And quite a few of them on land reform and land restitution. How many were upheld on appeal?
To the best of my knowledge, well, one was a review, a REVA, but of course it went to the SCA, and then the Concord, in a minority judgment, agreed with me. And then the other judgment was my LCC judgment, and brings back memories, Justice Mir. I recall that back then, restitution matters, 2 judges were allocated matters. And it was my first restitution matter, and I recall a day or 2 before the hearing, it was to be held in Cape Town, your mom later, Fatima Mir, passed away. And you had to attend a funeral, and I had to run with the case, which ended up all the way in the Constitutional Court. And the Constitutional Court basically confirmed my findings.
That was Florence.
Yeah.
Good. All right. You have been involved in a number of organizations that are concerned with the promotion of the advancement of women in society, in the legal field, particularly in the judiciary. And one of those is the South African chapter of the International Association of Women Judges.
Yes.
I mentioned this one because I know that you have mentored a number of young women who aspire to become lawyers, young women who are already in the profession, who are looking for a gateway in getting good work, and junior colleagues. Is that right?
Yes, DCJ. And I continue to do so.
Yeah.
I love training, and I love, you know, if I hadn't been given a chance at the time, back in 1998, if the door wasn't open for me, I would not have been here where I am today. So I'm also clear that I need to transfer skills that I've acquired over the last 16 years to others.
Yeah. And you served in the gender committee of the Commonwealth Magistrates and Judges Association.
That's right,
as well.
yeah.
Mm-hmm. And you were an NEC member in Jawasa.
That's right, yeah, an NEC member.
Mm-hmm. Well, let me come to the heart of things. You've applied for to lead a very important court, which, like the rest of our courts, is beset with a number of challenges, chief of those caused by, issues such as lack of resources. The minister knows very well about this. You would have had time to check what the situation is in this particular court, and I want you to tell us what you have found in that exploration, and if you have found that there are challenges, what you intend doing to address them.
Thank
so
you,
in short, I just want you to give us a brief vision of that court. Sorry, what you have in mind for that court.
Thank you, DCJ. As you would know me, I take everything seriously. I did go to the land court, as it is now known. The commencement of the act was on the 5th of April, 2024. And I went and I engaged with the staff members, with other judges. I spoke to the court manager. and the registrars to find out what the position is with the court. And where they sat, I've got a list of reserved judgments, I've got a list of the number of cases that are outstanding. And, the difficulty with that court, and I really know this because I was involved at the time, Justice Meer was for almost 10 or 11 years when Judge Bum and Judge Gildenhuys retired. She was basically the only permanent judge at that court. So I would come in an acting capacity and others would come in an acting capacity. So that was a great challenge. And of course, fortunately with the legislation, judges there, I think 3 judges have now been appointed permanently to that court. So that was a great challenge. My vision for that court is, look, the most important thing I think with a court like that is that one must ensure access to justice, access to our courts. And land claims matters really come from all parts of the country. I traveled to places that I'd never seen before. I mean, I didn't know that a place like Wackerstroom existed. So beautiful. Places like Dalton that I had to travel to hear matters, to hear witnesses. And that's one of the challenges and sacrifices judges make at that court, that they've got to leave their home and find themselves in very far off the beaten track places. But that's access to justice. That's what we have to do. This court, because most of the people that bring these claims are not wealthy people, they're the poor. And I always believe that, my own experience in that court is that once the litigants see a judge involved, somehow the process is trusted. They trust the process, they trust that everything's going to go according to, their own understanding of how things work. So my strategy for that court would be, one is modernization. There's just no getting away from that. That court has to be modernized, it's got to be digitized. Fortunately, I've got that experience. I picked it up in Johannesburg when I was the acting DCJ. I got thrown into the deep end with case lines. There's court online, and yes, they have hiccups, but my philosophy in life is no matter how little or how small the resources you have, you make the best that you can with the little that you have. So that's never, ever going to be an excuse for me that we don't have resources. We're going to have to fix and work within what we have. And the efficiency of the court, I'll do my best. Justice Meer has left a fabulous legacy in that court. She single-handedly ran that court. And my sense is that if I'll just be taking the baton from her. That court's been transformed. There are 3 women in that court from a gender perspective. 2 black females, 1 of African descent, 1 of Indian descent, and a white female, and 2 men, 2 males, while effectively one's an acting judge and Justice Nube. So from a transformation perspective, that court, has the face of the country, so to speak. It represents everyone. I'm a colored female of colored descent, so my face will just be added to that beautiful court, a rainbow nation. I think also I would like to work with and I have this view that, you can't work in boxes. We're all, the separation of powers, people tend to treat it as if, you're all in a box. I believe there's an interdependent relationship. The judiciary has to work with the legislator who makes laws. We've got to implement it. So that interdependent, this notion of it's a misnomer to be totally independent. So we've got to work with one another. And that's the culture of the LC. In my time there, Judge Meer's management style was to include all her judges. We'd be involved in interview processes. We'd be involved in going to meetings. We'd be involved in training. I recall we trained the new panel that got appointed to the new panel that I think that won the tender for litigation purposes. We had to train. I also had to train Botswana judges. So the culture in that court, which was a cooperative culture with the staff, very happy staff at the LC, I must say. And so for me, I would just be wanting to retain such a culture. But I think the most important thing now is, one, what does digitization bring? It brings about, better service delivery for our communities. It brings about the reduction in queues, in paper, just across the world. I mean, if you're looking at climate change, we'd be saving paper. We'd be adding to this wonderful thing of trying to save the planet. And I think also, for me, what was very striking during this whole COVID period was the access that people had to our courts. I remember in Johannesburg, we set up a court room for those who could not afford a laptop or data. They would be informed by your registrar or clerk to attend court, and they could make representations even if they were representing themselves. So digitization can work even in the most dire circumstances. One can find ways in which to find solutions. One of the things I've always said, especially with the land claims, and I know that us judges traveling has a huge impact on the budget, but something that we have to do. And the LC through Justice Mir have come up with an idea that what they'll do is go to the communities, hear the witnesses, let them see the process, and once all of that's done, to save costs, come back to the seat, which is in Randburg, and then continue with the trial. I'd like to even go one step further. I would like to suggest that through the Department of Justice, maybe the Ministry of Agriculture, Land Reform, and Rural Development, because I know that the Chief Justice, together with the Minister, can also, in terms of the new Land Act, can also direct that, halls and community centers can be used as courts. And I'd like to suggest with digitization that even those cases where you hear witnesses and have to go back to the seat, that the community can still be involved. You can live stream what's happening from these. I don't think it takes a lot of money to set up such a structure. We did it in Johannesburg. And so I would also suggest that, with digitization, the courts can even go to the communities in that way. And also, I think just also live streaming, most people have Android phones today, so I think, access is even greater in that respect. I think that the new Land Act, what I would like to encourage, and there's a huge emphasis on mediation and arbitration. I think it's a valuable tool to have, and I think that lots of matters are going to be finalized. With now having the court having the power to direct that, if you can see that matters can be resolved, direct that mediation takes place or arbitration. Those regulations still have to be thought through and have to be put into place, but it's a wonderful mechanism to try and also, litigate through not through mediation, but also to reduce the number of the litigation and expedite hearings. And I don't know, I read the Act quite carefully, and I'm not sure if judges are excluded from mediation. And I know in Germany the judges are part of the mediation, and then they don't sit in on the matter, like case management matters. I know that we just, in terms of the Act, there should be 5 judges in that court. So it's going to be a bit of a challenge because of, you may have to recuse yourself, and you've got such a limited number of judges. So I think the alternative dispute resolution is a fabulous tool that's been put into the new Act. These are non-judicial powers that comes through, that we find now in the new Act. So the new Land Act also gives the land court increased jurisdiction. And I think what it does, it will bring certainty and stability to that court. In a sense where all land issues will be concentrated in one place. People will not be confused. They won't have to run to the High Court, to deal with something to do with the Alienation of Land Act, or they may, so they'll know where to go to. It'll give certainty to people. The Act is also increase the jurisdiction of that court. And of course, the Act really creates two courts, the Land Court and the Land Appeal Court. So once again, instead of parties waiting to go all the way to Bloemfontein, because it never had full court status, the Land Court, all the way to Bloemfontein, and to wait in the queue, and Bloemfontein is so busy. I come from there. It's a very busy division. And I think matters will be finalized far quicker. And it will also enhance the jurisprudence of land issues. So I think I would like to, see that that's implemented in the most streamlined fashion. And again, digitization, it may come a time, I don't know what's the answer, but there may come a time when you require judges from other divisions to assist. And with digitization, you just have to put on your computer and 3 judges can sit as a full court. You don't necessarily have to come all the way to Randburg to have the hearings done. So, I believe with my experience, it literally feels like, often people ask me, so why are you doing this? Because, well, at the time, this position was never available. It's like coming home. I have been there for 12 years. I stayed because I had the option of not doing that work. And I actually, if memory serves me, I had to appeal to my DJPs together with Judge Bam and Judge Meer to release me to go and do that work. It was a struggle. I don't think people gave that court the credit that it deserved. It was almost a court that was relegated to the background, not treated with the how do I put it? With the seriousness that it deserves. I mean, land issues is one of the most important issues that this country faces, and we got to get it right. That's a long vision, DCJ.
No, it's not. Have you finished? Have you finished?
Yes, thank you.
Okay, thank you. Do you have any reserved judgments?
Not at all.
Yeah. Okay. All right. That's it from me for now.
Thank you.
Okay. AJP Mayor, do you have questions for the candidate?
I have just 2 questions. Good afternoon, Justice Carroll, sir. You've had a long and productive career in the judiciary, and you have been known at the Land Claims Court for your energy and as somebody who gets things done and gets things done efficiently. I'd like you to explain what in particular about your leadership role in the High Court would you bring to the Land Claims Court, or do you think should be transferred to the Land Claims Court, and which would hold you in good stead for this position you've applied for?
Well, I think throughout my career, even as a prosecutor, I was always identified with leadership positions, control prosecutor. I'd have to step in for the assistant. When I was a magistrate, I had to step in. I was tasked with setting up for the very first time sexual offences courts. And I think what I bring from the High Court, look, Johannesburg's very busy. It taught me time management, taught me to manage my work. I've not ever been on the list of reserve judgments. I've managed that very efficiently. And there's no doubt when you're sitting in the land court and you then have to go to Johannesburg, the work follows you. So there's no such thing as cutting off that I'm there for a particular time and that's it. I'm only going to open that file. I had to juggle my time through the evenings at night. And I think the experience I gained being in such a busy division in Johannesburg it will be with me. It's developed me as a person, as a judge. And the one thing I forgot to mention, Judge Meer, was one of the things that I found was quite effective even during my time as the acting DJP. As I said, during that period, during COVID, none of the cases came to a halt. We carried on, we finalized matters efficiently. And one of the good things that I found, and it's something that I would like to work on, is to engage the various organizations, the bars, the LPC, the AFT, Nadal, the rest, the BLA, and to try and encourage, because it's I don't know if people are afraid to come to that court. But the work is so interesting. And you get so much satisfaction when you've given a judgment that's changed people's lives. It's given them back their dignity and restored their faith in the democracy of this country. When you just give someone something back and you acknowledge that they'd been dispossessed at some point in time. So we need a lot more help. We need a lot more people that are interested in that matter. We need a lot more skills from the profession, to engage these issues, because the issues are novel. Often you'll get a counsel and you'll get a junior counsel who hasn't any clue, and the issues are so, how do I put it?
So emotive.
Exactly, thank you, Judge Mir. And you'd really would like, you can't help, present someone's case for them. But that's the difficulty there. And I think that the more seasoned, experienced counsel get to grips with the Land Act, and I know for a fact they'll enjoy the work, but also they'll also be able to help towards the jurisprudence. But one of the things, coming back to what I actually wanted to say, one of the things was that Johannesburg, in my time as the decent acting deputy judge president, together with the JP Mlambo at the time, was the bar and or the associations were encouraged to come forward and give of their time to do pro bono judicial work. And it was a fabulous, fabulous method to try and reduce the workload, as well as, in fact, in the LC, it's hard to say LCC, I must get used to saying the LC. In fact, in the LC, I think it'll work fabulously, because you then get, practitioners to come for a week. You'd give them matters where it's probably an application or a trial, not really restitution matters, because with restitution matters, they take up your time, and it's difficult for counsel to give up their practice for a long period of time. So for me, I would try and encourage that. It would also encourage people to get to grips with the Land Act, and I'd hope that the senior members of the associations, think about that and offer assistance to that court.
I think some of the commissioners may be curious as to why a Supreme Court of Appeal judge would make a shift from the SCA to the Land Court. Do you want to say anything about that?
Yes, Judge Mir. I think someone said, well, why this is a demotion? I said, no, it's not a demotion. At the end of the day, I'm a judge, and where I have to serve. Doesn't matter what title I wear. I am very invested in that court. It's my passion. I've been there for 12 years. People spoke to me and said, I've got a lot of value to add to that court, and I must make myself available. So I certainly don't see it as a demotion at all. I just see that in fact, I'm even a better judge for that, because going to the SCA, I was actually fortunate because of my experience, I was assigned either as a scribe or as a panelist on LC matters. And I learned a lot from colleagues, but I also was able to share my skills with other colleagues, and often colleagues would phone me up and ask me, what do I think about it? So sitting as an appeal court with different views, managing all of that, I think I'm a better judge today than I ever was. And don't see it as a demotion, Justice.
Thank you. Nothing more from me.
Thank you.
Do you have questions for the candidate colleagues? Yes, Minister.
Yeah, I only have one question. You have addressed the issue related to the challenges of the capacity of the court, that the new act will help to bring the permanent judges. But the other capacity and challenges I've heard in the past was that also the matters, also being mindful of the separation of powers, that the commission was also struggling to process matters and so forth. And also the other leg that we have mentioned earlier of the tender from rural development, you will be aware that is now with the Legal Aid South Africa. So how will you enable the court to expeditiously deal with matters, considering that the entire value chain, that some of them may not be really in your hands?
I know that is the difficult part, Minister Lamola, but I think I've spoke to the court manager, and there's a task team that's been set up to try and capacitate the court. But I spoke to the court manager, and she believes that as the court stands right now, things will come in slowly, that the court is capacitated to manage whatever comes in. Of course, we can't go looking for cases, unfortunately. We can't, we can't tell people to bring cases to us. But I expect an influx of cases, but I think that working with both the Department of Justice as well as the Rural Development, and I think that everybody certainly is committed to that court working. I can't see any challenge not being able to be overcome.
Thank you, DCJ.
Yes, Commissioner Matulu-Lepu, you can go ahead.
Okay, thank you, DCJ. Good afternoon, Justice Carlson. Well, you spoke about the innovation about mediation, and I love mediation.
Sorry, I can't hear.
I'm saying I love mediation because I'm a mediator.
Okay.
But the problem, what I've seen is that it does not bring the relief that it's supposed to bring because it's a voluntary process.
Yes.
So how do you think you can actually encourage parties to really go for mediation, especially in a sense of the land claims, when we know that land claim is a political issue and a very,
Well, I think if I understand the new Land Act, I think that the presiding judge has the power to direct mediation. So it's not a voluntary thing. If you're sitting with a matter and you see that this matter can be resolved through mediation, then you give that direction. I think you can even stop the proceedings and say, no, this matter must stop. We're going to suspend proceedings and we're going to direct that mediation takes place. So it's putting that process, through the department, I think, with the regulations and how to ensure that people are, trained, skilled, understand, because I think that's going to be quite a bit of a challenge to get people with the necessary skills. And I think they are there. They just need to, come on board and assist with that. So that's the one thing. And I think also, even if judges are not allowed to mediate, I would imagine that we should keep judicial oversight, since it's our order that we're given direction to. So we will control that process by oversight, an oversight role during the mediation process.
Thank you, DCJ.
Thank you, Commissioner Matulu-Lepu. Commissioner Nyambi?
Thank you, DCJ. Afternoon, Judge.
Afternoon to you.
One question from my side. As we know that the issue of land is an emotive one in our country. Anything that stand out, because you are valuing yourself for a leadership position coming from SCA to the Land Claims Court. Anything that you have experienced as a legal practitioner or a judge?
Sorry, everything that I?
Anything that you have experienced that will demonstrate that was a challenge that you have come across that will demonstrate that you are ready for this leadership position? Your worst experience as a judge that you are able to deal with in a way that will show that you are ready to lead this very important critical court.
Thank you for that question. In fact, you remind me of when I first came to Johannesburg, and I recall that we were three female judges. And there was one time I was given a allocation of I just want to tell you about my personality and how I go about taking on challenges. And I recall that it was a 100 million rand tender. And as people that know Johannesburg, there was a time when you would get to 400 cases, unopposed matters, to finalize it on Tuesday, and then Tuesday afternoon to start with the opposed matters. And in came a barrage of very senior counsel, very lily white, and sat in the courtroom and, of course, asked to address me and says, well, am I ready to hear the matter? So I said, yes, the matter will stand down, and in a half an hour, we'll hear the matter. So those were the challenges. I prepared myself for that. And, when I'm given a challenge, I don't think I shy away from a challenge. In fact, people that know me know that I'm no pushover. And if I am committed to something, I don't do it 50%, I do it 100%. this new sort of land court, the act, it will be treading completely new ground. And I know that I'm looking forward to it because it's a challenge, and as I said, the culture in that court, look, Justice Mir, I know that she's going to be available. With that kind of institutional knowledge and memory, I would be a fool not to think that I can't, access her and ask her for leadership advice. And there's many people in the judiciary. There's my deputy sitting across from me, from the SCA, that's going to retire. He knows I call him very often when I require advice. So I'll not be treading in the dark alone. I know it's a new area, it'll be new things being set up, but I'll get the assistance that I require.
Thank you, Judge. Thank you, DCJ.
Thank you, Commissioner Nyambi. Commissioner Klo?
Thank you very much, DCJ. Good morning, good afternoon, Judge Karese. I hope I'm pronouncing it correctly. All right. Judge, there are two sets of claims. The first set is call them the old order claims.
Yes.
And the second set is the new order claims.
Yes.
And if you go around, you get people asking a question. We belong to the second set, the new order claims. And no one comes with an explanation as to when are we going to get our claims settled. And what do you think is the bottleneck? Or where do you think the bottleneck rests before these, especially the second one, could be addressed?
The way I understand it, I'm sure there's a moratorium, Constitutional Court, I think in land movement matter, if I'm not mistaken, placed a moratorium on all claims. The Concord said that the first set of claims must be finalized. I think gave the department 2 years, but I don't know if it's been revived again. I'm not sure of it. I think they were meant to revive the moratorium because I think it would have lapsed it had 2 years in which for them to finalize the outstanding claims. So the way I understand it, I think there's a moratorium on claims, the new order claims. They were meant to finalize, and I think, there was meant to be reports, and so I don't think it's done.
So where do you think the problem lies?
Well, I don't think the judiciary can help with that. I think it's a question for the departments, the Department of Justice, Rural Development, to go and maybe revive that or expedite the matters. So the bottleneck probably lies at the administration, because at the LC, the cases that are in front of us, I think that come before us and are ready to be heard. All kinds of means are done to hear matters. But I think that the Concord, the way I understood it, the Concord ordered that all the old claims had to be finalized before the new claims were to be dealt with. So I don't know whether they're just standing, whether they're waiting to finalize, whether they're being processed. I don't know any of that. That'll be a question that the department will have to answer. Unfortunately, I don't have that knowledge.
Let me rest at that, TCJ. Thank you so much.
Thank you.
Thank you.
Prof. Marumagai?
Thank you, DCJ. Good day, Judge.
Good afternoon.
I just want to ask something. I've been checking this act out.
Yes.
And I was quite intrigued by section 12 or section, I think, the one that deals with assessors.
Assessors, yes.
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 I was quite intrigued at how it has been drafted. I'm not going to burden you with the details. I just want to get your sense. And of course, you'll draw on your experience. When I look at this section, it seems to us to suggest that there will be a need for assessors. But it is not quite clear from my reading as to in what circumstances would a judge decide to sit with assessors in land claims court. And it's quite different as to how it has been drafted with how assessors are kind of like used in the Criminal Procedure Act. What is the role of assessors and what value are they bringing in the adjudication of matters before the land claims court, the land court?
Okay, yes, you are right. I think that the land claim, the act, the amendment, before the amendment, I think that assessors were almost peremptory for assessors to be used in restitution matters. Now it's not peremptory. Now judges have almost the discretion to use assessors or not. Assessors have been plagued that court. People are not making themselves available as well. Assessors, I think, in my experience, when I did my restitution matters, assessors, you'd normally get a valuer. So basically, they give an idea, the value of the land and how to assess that. But basically, I've never worked with an assessor who didn't have that skill. So that's where the value comes in, when you have someone who's got that skill, because judges are not valuers. You don't understand how they value a property. So that's how I did. That's what I did. But I know that the land court has made representations, they've made submissions about the question of assessors and asked that the regulations be drafted in a certain way because of the various challenges. And I know for a long time we couldn't get assessors in the land court because we had to fly people from all over. There was a limited amount of assessors, most times because people were not paid well, and I think there's still a debate of what they're going to be paid in the future. Currently, I think they get paid 3,500 Rand a day. But if you look at the act, it doesn't seem that that's where they're going, and there'll be full-time assessors or something to that effect. So it does pose a challenge, but in the past, you really couldn't go on with the restitution matter unless you have an assessor. Now you can carry on without it. It depends on the facts in the case and how intricate it is. I suppose a judge will have to apply his or her mind to see whether or not it's required in the circumstances.
Thank you very much, Judge. It seems a little bit weird to me, but thank you very much for that explanation. Thank you very much, DCJ.
Well, I just add that the problem with using assessors, not just confined to the land claims court, it affected the high courts as well.
Yes.
And because of all these budgetary constraints, and it's just a resource that the courts have had to learn to do without.
Yes.
Do we have any questions from the colleagues on the virtual platform? No. Is there anyone on that platform at all? Yes. Okay. All right. Thank you, colleagues. Oh, well, that was quite a short interview.
Yes, thank you.
Justice Carol.
I can rush up and break my fast.
We've reached the end of our business with you today. I just want to thank you again for your patience and for listening to all the pleas that were sent your way to make yourself available for this position. I know how much you love being in the SA. So
thank you, DCJ.
Thank
you,
you.
Commissioners. Thank you very much.
Unless you have any questions for us?
No, I'm fine. Thank you.
Okay. You're excused. Thank you so much. Good afternoon, Ms. Cohen.
Good afternoon, DCJ.
How are you?
I'm well, thank you. How are you?
I'm fine. Did I say Ms. Cohen? Judge Cohen, sorry. Well, you were here not so long ago and I called you Ms. Cohen then, so my brain just got addled for a second there. Are you ready to start?
I'm ready to start, yes.
All right. You hold 3 academic qualifications, BA, LLB from UCT, and a BCL from Oxford University.
That's correct.
And I see that you started, when you finished your education, right in the midst of your studies, you worked for the Human Rights Committee.
Yes, that's correct.
What did you do there?
Well, the Human Rights Committee, it was a non-profit organization, so distinct from the Human Rights Commission. And at the time, it was monitoring the legislative processes that were ensuing in the new parliament. So I'd graduated in 1994, and it was my first job.
Mm-hmm.
And we were monitoring the new parliament and its efforts to really give to give expression to the new democracy. And we were monitoring the Constitutional Assembly process and making submissions to Parliament. And then we were also reporting on those activities into the public realm and trying to find ways to make people, to help people to understand the new legislative processes that had been embarked upon. And another feature of that, which was very exciting, is we initiated together with Black Sash and IDASA at the time, we initiated the Parliamentary Monitoring Group, which, as I understand it, has gone on and still serves a useful function today. So that was the work that we were doing.
Mm-hmm. Aren't you just lucky? That's not just an exciting job, but that's very important work. For one's first job, it's something. You went on to clerk for Chief Justice Chaskasen.
Yes, I think before I clerked, I did my BCL. So that was my first job. And then I went and did my BCL for 2 years. And then I came back and was offered a position with Justice Arthur Chaskalson, who was then the president of the Constitutional Court. And I came back and I served there for, I think it was for 1 year and 3 months. I think it was a 15-month period that I was able to serve there.
How did you find that experience?
Well, as I said at the time, it's the best job in the world.
Yeah. And you went on to join the bar?
I did.
Where you remained for 20 years?
Yes, I started in Cape Town. And then I moved to Johannesburg in 2010 when I took up a position at the Legal Resources Centre in its Constitutional Litigation Unit. But I continued as an advocate. And then I practiced until I was elevated to the bench.
I see that you also worked for the Department of Health at some stage.
I did, yes. I was asked to serve on the legal committee of the Medicines Control Council. One of the areas of my practice was administrative law. And in that role, I did a lot of work around access to healthcare. And I was asked to assist on the legal committee, which I did. I think it was for a year.
And then you started acting as a judge in 2018?
That's correct, yes.
For how long?
So I acted on and off from 2018. I think it was the 4th term in 2018 was when I was first asked to act for a 4-week stint. That was in the High Court. And then I continued, I think in the following year in 2019, other than finishing some of the cases I'd picked up, I only did 1 week the following year. And then in 2020 and 2021, I effectively served for 6 months of each year, predominantly in the Land Claims Court from that stage. But I also did service in the High Court, both on a High Court stint, but also the practice has been in the Land Claims Court that we serve there for a term, but we also must go and do service in the High Court. At this stage, we're doing 2 weeks a term.
Right. So for how long in all have you been at the Land Claims Court?
So-
Acting and permanent combined?
I think it's shy of 3 years. It'll be probably, no, we're probably getting on 3 years now. If you add in the time that I've been sitting permanently. I'm afraid I haven't done the exact calculation, so I can't
No,
give you an
that's all
exact
right.
figure. But I think that it's fair to say that I've now been serving at the Land Claims Court for a cumulative period of 3 years, but over 4 years.
I subject to correction by you, but I recall picking up from your bundle that you've penned 70 judgments, about 70 judgments so far.
Again, I haven't counted. I think it's actually more at this stage. I think in my list of judgments that I've supplied to the Commission, there are 84, and that's as at October or November when I submitted my my CV.
So there would be
There'll
more.
be, since then I've had a very busy term.
Quite prolific.
Yes.
Okay. All those on land claims court matters.
No, they both land claims and High Court. So because we do duty in the High Court every term, it's the 2 weeks duty. I also pick up High Court matters. So you'll see on the list of judgments that it's split between the Land Claims Court, the Land Court judgments and the High Court judgments.
But majority in the land claims court.
I actually think numerically the majority in the High Court, but that's not because of the complexity of the matters. That's because I'll be put, for example, on the urgent roll. So, I mean, I was the senior judge on the urgent roll a couple of weeks ago, and we had 44 matters on the roll between 2 judges. And I think I did about 7 or 8 judgments in a week. So they're quick, sometimes short. So I don't think that the numbers necessarily represent the volume. I think the complex matters have been more squarely the land court matters.
And not once have you been overturned on appeal?
That was true until
So far.
last week, Wednesday.
Oh.
I've just been overturned.
Welcome to the club.
Thank you.
All right. You have written outside of the legal field as well, not so?
Yes, I've written quite extensively. I think it usually has a legal flavor, but not technically on legal topics or analysis of law. So, but it's usually got a legal flavor. So the list of publications, which is in my CV, you'll see. Let me take you to it.
You've also written on what makes for a good judge.
I did. As I mentioned in my last interview, that was a very humbling experience.
In your 2 and some odd years at the Land Claims Court, have you been involved in any administrative work?
Yes, I have. I've been involved in
Can you tell us a
administrative
bit
work.
about that?
Yes, sure. I think perhaps this is an opportune time for me to contextualize the reasons, in fact, why I've made myself available for leadership at an early stage in my judicial career.
That would save us time, and
I think
whilst you do that, just tell us your vision for the court so long.
All right. Let me do that. As commissioners will know, the Land Claims Court has been struggling for a long time. One of the primary challenges that we've faced is that we haven't had permanent judges. So that's well known, as I understand it, to all commissioners. And so when I arrived at the Land Claims Court 2 years ago, I found myself in a position where I was one of the 2 first new seconded judges who were providing permanent support to that court. And so somewhat unusually, I found myself being asked frequently and tasked with what are essentially leadership functions over the past 2 years, which I've been providing under the leadership of our acting judge, President Mir. So I find myself in the somewhat unusual position that despite the fact that I've only been on the bench permanently for 2 years, I've been providing extensive leadership support. And in those circumstances, I considered it my duty to come to this commission and make myself available to continue providing the service. But fully mindful that this commission does have very experienced judges also making themselves available for this position. So I'm very aware of that, but I did consider it to be my duty to make myself available given the work that I've been doing providing leadership support. So against that background, perhaps I can just let me say this, it culminated ultimately in February this year in my being offered a appointment as the acting judge president of this court. The minister appointed me the acting judge president of this court in February this year. So I have had the opportunity, this was while our JP was on leave, our AJP was on leave. And so despite my seniority, I was in fact tasked with that. And I was very grateful for that opportunity to act. But if I could perhaps take commissioners to page 22, I think it's page 22 of my questionnaire, starting actually on page 21. I have listed there the tasks or the work that I've been asked to perform as one of these new judges. And it starts on page 21, paragraph 1.1, with being asked to assist with the appointment processes of the court staff. And at this stage, I've now been I've been the judge designated to appoint 3 members of staff. So I'm responsible for the shortlisting and appointment of the court manager, the researcher, and most recently, that's this year, the librarian. And then if you turn to page 22, you'll see then on paragraph 1.2, I list under various bullets the other work that I've been doing, providing leadership support. I would value an opportunity to speak to some of these projects. There's a historical cases project which looks at the backlog in the land claims court and what I hope to do with that. It looks at our restitution project. I've made submissions. I was part of the team of judges which was responsible for preparing the submissions to Parliament on the Land Court Bill. And most recently, whilst I was serving as the acting judge president of the court, I was responsible for preparing the submissions on the regulations that are currently being considered by the minister. And as commissioners may be aware, the power to make regulations under the Land Court Act is not yet in force. So that is a process that is still under discussion. And then I attended a meeting with the Minister of Agriculture and Land Reform to discuss some of the issues relating to the backlog. I've attended meetings with Legal Aid South Africa, so commissioners will be aware of the new process that's underway to provide legal aid to rural litigants. So I've been actively involved in engagement with Legal Aid South Africa about how to give life to the new project and the mutual challenges that we're facing. I've attended one of the Lamosa report back sessions with Acting Judge President Mir, and most recently the meeting with the Special Master. It's dealing with labour tenancy cases. I've done a review of our court performance statistics to assess some of the challenges that were revealed in one of the annual reports that I believe was the topic of some debate at the most recent Judiciary Day, which commissioners will probably recall. A facilitated involvement of land claims court.
Maybe for the sake of time, let me stop you there and ask you to tell us just a bit about those challenges. The commissioners were not at that heads of court meeting, so they don't know.
No, yes, thank you. The challenges that we are facing are multifold, and they are not easy to address. And while I deal with them, I'd like to first acknowledge what I regard to be exceptionally good leadership that we've had from our acting judge president, who has managed to lead a court in incredibly challenging circumstances over the last, I don't know how many years it's been, but it's been a long time. And in circumstances where there haven't been permanent judges, she's faced an uphill battle. And so what I'm saying about challenges must not be understood as casting any aspersions on what's been done. I think, in my view, the court is run extremely efficiently, and we are very lucky for the leadership that we've had. And we must learn a lot from how the court's been run. But against that background, if I can point to some, and some of these are challenges that reside not with the court, but reside with the Commission and with the Department of Land Affairs, and over which the judiciary doesn't have much control. But many of these challenges are also challenges over which the court does have control. So if I can focus on those over which we do have some control, because I think that's what we must step up to first and foremost. The first is the issue of the backlog, which is the backlog of restitution and labour tenancy claims. And that's a major problem. The backlog figures of which commissioners may be aware of figures that typically, which will refer primarily to the restitution backlog that sits with the commission. So the 30 years to finalise what's effectively, I think it's approximately 6,000 restitution cases at a cost of 170 billion rand. Those are the figures that the Commission has recently, I think, supplied to Parliament. Most of those cases are not with the court, and there's not much we can do until a case comes to us. But the truth of the matter is this: the many cases that are referred to the Land Claims Court are referred to the court by indigent rural litigants who don't have access to legal representation. So once the case gets referred to the court, it becomes incredibly difficult for those cases to be prosecuted to the point where they can be enrolled. If anyone were to come to the court and ask us for a court date, we can give you a court date very soon, and we will efficiently be able to finalize that matter, and our statistics are starting to show that. However, I would estimate, we don't currently have correct data, but I would estimate that we're talking about at least 1,500, possibly 2,000 cases that are sitting there, not being prosecuted, not due to any fault of the litigants involved, but because they do not have effective access to legal aid, and because of the challenges in the system more broadly. So I suppose the real question that then arises is, well, what can the courts do about that? Because it's not centrally the function of a judge to case manage to ensure that cases become trial ready. And the view that I take on that, as I see it, there is an important role for the judiciary. And I would say that there are at least two ways that we can assist and that we must assist. The first is through fully understanding the data, fully understanding what we're dealing with, what is the nature of the problem. So as I see it, we have a very high duty now to do a full analysis and audit of those cases that are sitting there and have not been finalized, and to understand why. And that entails a deep dive into those cases, which we are doing. I've initiated it. This is the Historical Cases Project, which I've initiated and which I'd very much like to see through. So that's the one issue. We need to analyze those cases, and I can talk more about that if Commission is interested. The other issue is case management. And as I expect most commissioners will also be aware, case management has become one of the main features of especially in the High Court space. And in the land claim courts, it's an absolutely fundamental tool. So it gives us the ability as judges, and we have inquisitorial powers, which are far greater powers to descend into the arena than a High Court judge has. But it does give us the ability, when a case is identified as ripe for case management, it gives us an ability to go in and proactively try and move these cases along. And this speaks to another project, which I can also elaborate upon if commissioners would like me to. So the backlog, I think, is a critical issue, and it's one that I am committed to working on, and I've already commenced a project on that. This is linked to delays. There are real problems with delays. A lot of those are beyond our control as judges, but again, it speaks to the issue of case management. The absence of permanency of judges has been a serious challenge. That's now, thankfully, and we're very grateful, hopefully soon to be fixed as a result of the commencement of the Land Court Act. So the introduction of the idea of permanency of land court judges is critical, and it's a very important initiative that's been taken by Parliament and the Executive, for which I think we must all take note of that. I think that another key challenge is that many rural litigants simply do not have access to lawyers. And we see this is one of the main reasons for delays in our court. So we see many cases getting postponed because there's for any number of reasons that I'm sure I don't have to elaborate on here, people just simply don't have lawyers, and so we can't move the case along. And that brings us to the discussion about the new legal aid system, which I think is an important conversation. And again, I can elaborate on what's happening there and what we've been doing to engage with the Legal Aid Board. I think it also brings into focus the need for us to try and activate more interest from practitioners to get involved in land work. It's about mainstreaming land work into the mainstream practices of commercial lawyers. So what I have in mind there is trying to, resources being an issue, we need to both work with the Legal Aid Board, but we also need to, I think, activate the support from the firms and from practitioners. Because as I see it, there are many practitioners who would love to practice in land law and would feel it's a service that people would want to give. And so I would like to find ways to try and work with the legal profession so that more lawyers can be made available to litigants. There's another aspect to that which speaks to, I think, our need to activate the civil society organizations that do work very positively in this space. And to that end, I have started a conversation with the CAUSA, the community advice officers, because I think they can provide a very important bridge between the courts and communities in a variety of ways. So these are some of the challenges. There are many others. I've got a long list. But I would say that those might be the main ones. Just to list the others without speaking to them, perhaps at this stage. We do have budgetary constraints. Those are real. Commissioners know about those. The staff have challenges. I've worked closely with the staff over the last 2 years in the roles that I've been playing. We need to address their challenges. We have challenges with our assessor pool, and we need to expand our assessor pool. We don't have enough people doing mediation. We don't have enough people doing arbitrations. We don't have enough researchers. And I've mentioned the issues around legal aid. So these are all topics that I'm passionate about and would like to speak about, but I don't want to speak too much.
Have you finished? Thank you. That's quite a list of things you've done. Just on the issue of case backlogs, what is this project? You say you've started to address that?
Yes, thank you.
Just briefly.
Thank you. So what we're doing really is it's twofold. It's a two-pronged strategy. The one is we are auditing every single case file that is in the court's archives. We've made sure that they are neatly in order and we can access the files, and we are auditing every single file. After auditing the files, we are ensuring that our court register, that the information is captured on the court register in a digitized fashion that's not only digital, we currently have a digital register as well, but that's fully analyzable so that you can understand, for example, how many labor tenancy cases came in from here to here that are not finalized and why. So the critical part of this is the why. So one does the deep dive, the audit, you find out why these cases are not being finalized with a view to trying to work out, well, how many cases need to be sent to legal aid for legal representation. And then we'll be in a position to say, here's the list, legal aid. We've got relationships with the new land unit to say, here are the cases which we believe steps need to be taken. They had a lawyer, there's no longer a lawyer, or so to identify the reasons. And come up with strategies to try and deal with it. And then the second strategy is through that same process to identify which cases, historical cases, going right back to 1996, which of those cases are ripe for case management, and then allocating those to judges. And yeah, so those are the two elements, analysing what we have and allocating for case management.
Have you been able to deliver the reserve judgments you list in your questionnaire?
Yes, all of the ones that are listed in my questionnaire have been delivered. I do currently have a few from this last term, but they're all on currently within the 3 months' time.
Okay. What is the racial and gender composition of the Land Claims Court?
It's we currently have it's let me just make a note. It's myself is a white woman. We've got a white man. Then we have our JP, who's Shanazmia, who's Indian. We have an African man.
Sure.
So we have our JP, and we have Judge Nube and Judge Flatella. So 3 black members and 2 white members. Yeah, that's of the seconded judges, who under the Land Court Act have now been made permanent. Yeah.
Okay, all right. That's it from me for now. AJP Mir?
I just have one quick question. The Land Claims Court is known to be as a permanent circuit court that takes justice to the people. One of the challenges we're facing at the moment, and I want you to tell us how you would try and alleviate that challenge, is that we have budgetary constraints, which might well mean that we're no longer able to take the court to the people because we don't have the money for travel. That's a big problem. Your views, how would you deal with that?
Thank you. Yes, it is a challenge. It's one of the challenges that have been identified and came to the fore during the currency of my serving as the AJP in February. That's when the budget landed on our desk, and we realized that we actually don't currently have a budget to go to do circuit court. So it's a very real issue. And there are discussions going on about that. But if one assumes that there's going to be no budget, no further budget, if I can answer making the assumption that we have no further budget, then we need to accept that judges can't travel to communities as matters stand now. That's a fact. What we're doing is we're working very carefully with our current budget to see how we can ensure that at least those people who are currently expecting us, litigants who are currently expecting us to go to communities, that we can and that we do. So we're looking at ways to deal with that. For what we're also doing is cutting back. So we're cutting back heavily on our on some of the expenditure that we can cut back on in order to achieve that if we can. But otherwise, I think what we're looking at is realistically what we need to do is embrace the technology and to see this as a form of an opportunity. And what that would look like is we are, as I understand it, we're coming up soon for the rollout of case lines, which will be an incredible value to our courts. One doesn't have to think hard about if we're national court, we've got a national footprint. We have people in rural areas for whom travel to Randburg or even travel to a city like Durban or in the Eastern Cape or Cape Town, it's hard to get to an urban center. But if you can access court materials through the digital format, I think you can enhance access to court in quite profound ways. So I think we need to see the case lines rollout as our opportunity to go digital for land work. And then I think we need to we need to think about ways to activate the electronic networks, both for court hearings, where it's appropriate, mindful obviously of the need to have open court as far as possible. But also in terms of ensuring that people can access courts, so spaces where communities can come to court in a rural area. And I do have experience of that specifically from practice. I was involved in restitution cases restitution cases where we had our clients, I was representing communities, would come to a space in a rural area and have access to live streamed court content. And so I think we're going to have to start working on that. And again, I would highlight the need for us to activate civil society and try and ensure that, for example, the community advice officers may be able to provide spaces for people to go to, but also law firms, rurally based law firms or in small towns, I think they would assist us as well, possibly churches. I think we have to go remote, is the short answer.
More questions, AJP? AJP, have you finished?
I am, thank you.
Thank you. I can just add on the issue of digitization that all the courts, except for the Gauteng division and the SCA, which has only partially implemented case lines, that all the courts, including the Constitutional Court, are waiting with huge excitement for the implementation of that resource. We're getting our training only this May, after all this time.
Well, it's a wonderful tool. I have, as a Gauteng judge, I've used it extensively, so I can vouch for its efficiency. It's a fantastic tool.
Yeah,
and I, on a daily basis, think about when I'm in the High Court, when I'm in the Land Claims Court, I wish we were on case lines. There are many, one can just imagine the circumstances where people can easily get their papers filed. And yet we land up waiting for possibly a month for papers just to arrive to our court, whereas they could be uploaded in a very short period of time. So the Case Lines initiative is superb.
Yeah, it will be a game changer. So JP Mlambo assures us. Commissioner Marumachai?
Thank you very much, DCJ. Good afternoon, Judge.
Good afternoon.
I was quite intrigued when I was preparing for these interviews of this court as to the exciting matters that you deal with, and the facts that you get to. And I had occasion to read one of your judgments. It is Similar versus De Villiers. It was delivered in 2022. I can just try to remind you of the facts. It's part of the bundle.
Yes, it's in the bundle.
Okay, can I just remind you of the fact? It was just an animal pounding case of a trust.
Yes.
Where animals were grazing on the land of the trust, and they impounded them, and there was an issue about releasing them and all those kind of things. And it is quite pleasing how you dealt with the issue. I just want to ask you something in relation to that, because it seems to me that the code that you're applying to, there are specific provisions, specific legislation that seems to be well known that these legislation can be applicable here, like ESTA, the PIA, the well-known ones. I'm not sure to what extent, like for instance, in a matter like this, you'll find that in a province, there might be a provincial legislation. Like for instance, in the Northwest, there is a Animal Impounding Act. And there is another national legislation that is called Animal Identification Act. It was just quite intriguing to see all these legislations coming out. I just want to know, when a farm is on a municipal area, and perhaps ESTA is applicable, and Section 7, you deal with it here, you rely on it. But there is another legislation which may say something that is quite different. Like, for instance, that might allow the municipality to take those animals, maybe from the grazing area or from the road, and to keep them. And to the extent to which there might be a conflict between a different legislation, which is not, and I understand the problem that you identify, that there are issues of lawyers coming in, and perhaps maybe if you have more lawyers coming in, they might assist in identifying some of these legislation. To the extent to which there might be a conflict between the well-known legislation and the ones that are hidden, which we don't know much about, how would you go about resolving that particular conflict to the extent to which it might be real?
Thank you. Well, it's a difficult question that you're asking, and as I sit here now, I was wishing that I'd pulled my statute out, because I think there's a provision that it gives the answer as to how to resolve that conflict. But I speak under correction, but I think that we have guidance from, certainly in Esther, I think we have guidance around the primacy of that legislation in the cattle dispute context. But I do speak under correction. I always prefer to have a look at the act before I say what it says.
No, it's not a test. Just a question that I was posing. You can just refer to. You don't have to be absolutely correct. But I wanted you to think about it in any event.
As I understand with Section 7 of Esther, I mean, we've had, this is one of many cattle grazing cases that have come before the court. And I see it as a critical issue that needs to be fully confronted within our case law. The pound issue, so what typically happens is that landowners are impounding cattle with recourse to the municipal pound laws, and there are pound laws across the country. A couple of the old ones have been declared unconstitutional. They're now quite old constitutional court judgments. So that those decisions also need to guide us. So one, we need to look at any they're usually very old pound laws that come before us, and we need to look at them through the lens of the constitutional court's decisions around when they're valid and when they're not valid. And then Section 7 is, as I understand it, the only provision that allows people to impound cattle without court order. And one of the main themes of the cases, including the Simelane case to which you've referred, is to ensure that the rule of law holds sway also in this area of law, which may not be well known to urban lawyers, but is of critical importance to rural people.
Thank you very much, Judge. Thank you very much, DCJ.
Commissioner Matolo Dlebu.
Thank you, Judge Cohen, and thank you, DCJ. You know, I'm aware that there will be training of legal practitioners sometimes in April between the legal aid and the land court, which is very commendable. And I know that a lot of legal practitioners are excited about that. But my interest is, how can we really, because CAUSA is, I'm very passionate about access to the services that CAUSA offers to the members of the public. How do we get them more involved in issues of land? And is there any possibility of having them trained to do that, so that at least they can actually...
Thank you, Commissioner. Can I just get clarity? Are you asking specifically about the advice officers? Well, first let me say I commenced that engagement quite recently, but I understand that there's a commitment from its executive director to work with the Land Claims Court. So that's a good start. My thinking, well, we need to explore it and we need to consult more broadly with stakeholders, because it's not, I don't think that there are obvious solutions about how to do it. But the way that I've been looking at it is that the advice officers will be particularly useful, I think, and important in the language that the director uses, bridging the gap between the court and communities. The suggestion was made that they'll be able to provide advice and assist people to understand the land court's processes and what to do with challenges and problems that they have, but they won't necessarily be able to provide the legal services. So a paralegal would be able to deal with some of the preliminary challenges and sort out some of the administrative hurdles, but ultimately would have to facilitate access to legal representation. So then the conversation goes, well, to whom? And the first port of call would obviously be the legal aid structures, which are now being strengthened in order to provide some equality of arms in these land disputes, which is a very good thing. But I think they also need to, I think, as I mentioned before, to access the broader legal services, whether it's on a pro bono basis or otherwise. And I think they will be well placed to do that. And it was suggested to me that they would be well placed to do that. So I think that's two ways. In terms of training, the judges, since I've been on the court, I've now on three occasions been asked to come and train, and the judges, as far as I'm aware, are all willing to go and provide training. Obviously, what we can do is limited because we can't, for example, explain what we will do with a particular set of facts, but we can give high-level training about our systems and our processes, and I think that's really important. As you mentioned, we're assisting with legal aid now. I previously assisted Pabasa and on cattle grazing in particular, and I've been asked to do other training as well. But there's no reason why we can't offer that training on a more widespread basis. And as I see it, there are many practitioners who are very strong in land law, who I believe would be willing to come and help as well. So I think we need to, it's part of what I see as the mainstreaming of land law. As I see it, land law should be right at the center of what we're doing in this country. As I see it, my understanding of practitioners' wishes is that many people want to do the work. They really want to get involved in this, but they don't know how. So we need to try and open that up.
Thank you. I think I'm encouraging you to engage counsel about that.
I give you my assurance.
Okay.
Commissioner, is there follow-up or general question?
No, Mr. Chair.
If it's not a follow-up, then...
I have to tell the truth. It's not a follow-up.
Okay. Then you'll have to wait your turn. Commissioner Klabo. Commissioner Klabo, it's your turn.
No, thank you very much, Mr. Chair. I will ask this question because I've asked it before. And the amendment to the Land Restitution Act created what is now known as new order claims. It means that now we have old order claims and the new order claims. I've come across new order claimants asking when will their claims be considered. And what do you think is holding the Commission from dealing with those claims?
The old order claims, which are, and so the new order claims.
The new order claims, yeah.
The new order claims are all interdicted claims under the Lamosa judgment of the Constitutional Court. So just to paint the broad picture, as I understand it, it's dealt with in the Dangazele judgment, which was recently heard by both AJP Mira and myself, where we were asked to uplift the interdict in respect of the betterment claims in the Eastern Cape. And that's still ongoing, that case. But the position is this, all the claims that were lodged until before 1998, so end of December 1998, those are the old order claims. Those are the only claims that the Commission is permitted at this stage to process under the Lamosa judgment of the Constitutional Court. And that will continue until the Land Claims Court uplifts that interdict. That's under Lamosa 2. So that interdict continues. So all of the new order claims, which are those that were lodged in 2014, and I don't have this stats to hand, but I think it's a lot. It's about 68,000. It's a lot. And that was only in a short period of time. And that includes, for example, all the betterment claims that we were dealing with in the Dangazele case. So the truth of the matter is that until we can uplift that interdict, none of those claims can get properly processed. The litigants are then limited under the terms of the Constitutional Court order to participate in cases in a very, very restricted manner. So those claimants are in a very, very difficult position because their claims are interdicted until the old order claims are effectively processed. And then we come back to the stats, which I referred to earlier, which is that the Commission is saying that it's going to take them on the current budget and the current systems, it's going to take 30 years and 167 odd brand to clear the 6,000 odd claims, old order claims. So we are looking at a very serious problem. And I can't put it any differently. And I can't give you an easy answer, but the Commission needs resources. I know that we have the Lamosa report back. So under the court order, they come to the court. Those have been handled by AJP Meer over the last few years. And as I mentioned at the beginning, I think all judges were asked to attend those, and I attended the last one. So I do have a sense of the challenges that the Commission is facing. We get a chance then to issue orders to try and facilitate the process. But I don't think I can give you an easy answer to how we can lift an interdict if the Commission is still sitting with those stats. I can't honestly say there's an easy answer.
No, thank you very much for that response. CJ, I have a second question. I just want to prick your mind on this land law, the development of jurisprudence in that respect. You see, in KZN, for example, there is 11 million hectares of land, and about a third of that is under a traditional leadership institution. And do you think that the jurisdiction of the land court extend to that land as well?
Yes.
The traditional institution, or it focuses mainly on land restitution, Section 25(7) and Section 25(6), matters.
That's a very difficult question, but the short answer is yes, it does. Our jurisdiction does extend. Both our existing jurisdiction but more pertinently, our new jurisdiction. So, just to deal quickly with the new jurisdiction, which the relevant part is not yet in force. So, as I sit here, I have no jurisdiction over the Ngonyama Trust. But that's in the legislation, and when the president commences that part of the law, the Land Court Act, then we will have jurisdiction over that act. So that's the new jurisdiction. Under the old jurisdiction, even in the context of, under our current jurisdiction, even in the context of restitution claims, the issue of traditional leadership will come to the fore in many ways. One of the cases I think I've referred to, it's reported on JOL, is the Maunisi case, where what was an issue was what is the effect of one of the proclamations and the forced removals that were done under Section 5 of the 1927 Act, which resulted in the forced amalgamations of traditional communities. And the court held that constitutes a dispossession for purposes of the Restitution Act, when communities were forcibly amalgamated. So you see there are many points we see on our court many points of intersection between traditional leadership and land restitution claims. They come up all the time.
And that was your decision?
It was.
Thank you very much.
It's not yet overturned on appeal.
Okay, thanks. Thank you very much, Decision.
Commissioner Dudu? I thought your hand was raised.
Yes, it's there. I was waiting for you to call my name so that I'm there. Thank you very much, DCJ. Good afternoon, Justice Cohen.
Good afternoon, Commissioner.
I just want you to allay my fear and concern. You were interviewed by this body in 2021, and the president appointed you in January 2022, which means you are 2 years as a judge. Now, you have applied for this position as the head of the land court, which is a new court. I remember when we were processing this act in Parliament, we were propelled by a burning desire to ensure that this new land court must do remarkable things in terms of addressing the backlog, the challenges, the disputes, and all of that. Do you think that you are ready to ascend to this particular position, given the fact that you are new? This court has got to address the historical injustices of land. There are issues, claims, especially around restitution and all of that. Do you think that you are ready? I'm saying this because some of the bodies here, including the GCB, raise concerns about your lack of leadership experience. Now, just thinking about this court and the magnitude, the volume of the work that it has got to deal with, appropriately given the backlog, do you think that you are ready, and do you think that you don't need a bit of experience before you can occupy a position of this nature? Just allay my fear on that.
Thank you, Commissioner. Well, let me just say, I think that there's merit in some of the comments that have been made. I think that to say to a judge, for a judge who's 2 years on the bench to make themselves available for leadership, well, it's not unprecedented. I am early in my judicial career to be doing that. So when the comments are made by the law, by it's Nadal and BLA, I think, and also the LSSA, the GCB, I think affirms their view that I'm sufficiently experienced, while noting that I'm only 2 years on the bench. But I think that there's merit in saying that a judge before leading would benefit from more experience than what I have. I can't quibble with that. I think there's truth in it. If you ask me, I mean, I commenced the interview explaining why I've nevertheless made myself available. And the reason is because I have been in this very unusual position where in my first 2 years on the bench, I've been tasked with many leadership functions that have been playing a supportive role to our judge presidents. So I've acquired, I think, quite an unusual amount of leadership experience. And as I sit here now, I genuinely believe that I know how the court works. I know the staff. I've developed relationships with the staff. I've appointed some of the staff, or I've been part of the appointment process with some of the staff. I've worked on the restitution projects.
No, it's okay, it's okay. Just the last one, DCJ. I take this from Justice Peter, who is here. He says, as a judge, one of the modicum experiences, the basic things that you need to show, especially in leadership, you need to be decisive, you need to be all-embracing, and you need to be really sober like a judge. Do you subscribe to that?
Sorry, you need to? I didn't hear the last one.
To be sober like a judge, like a real judge.
Well, I do believe, I mean, I did, as was mentioned earlier in the interview, I did in 2009, I wrote that monograph on the qualities that take to be a good judge. And on issues of temperament and on leadership and decisiveness, I do think I have those qualities. I think, yes, I think I have.
It's okay, it's okay. Thank you very much, DCJ.
Thanks, Commissioner Ludovu. And just to add to his concern, his and the other law bodies' concern about your lack of adequate experience, there's also another issue that this commission must consider, that you are actually competing with 3 other very highly experienced judges.
And I'm aware of that, and I may be arguing against myself by saying this, but I have to say I was pleased to see that when people made themselves available for leadership, that there were experienced judges making themselves available. And I think this commission is in a fortunate position where it can make a considered choice about who is best placed to lead the court. So these are my colleagues. I know them, I work with them, I have good relationships with them, and we hold each other in high regard. I think the Commission is in the fortunate position where it can make a considered choice about who's best placed to do it. And I'm very pleased you have a candidate. You've just interviewed a candidate before me who has extensive judicial experience. And I'm sure you'll give very serious consideration to that. I'm not here to quibble with that. I'm here to offer myself for service, to explain to you why it is that I find myself in this position where I believe I can do it, and to tell you what I've done, and to give you a sense of what I believe I can do for the court. But I will be on board with whatever decision this commission makes, and I will respect it.
Thanks, Judge Cohen. JP Mlambo.
Good afternoon, Judge Cohen.
Good afternoon, JP.
I've heard you mention problems, the challenges that the Land Court is facing, and the Commission seems to feature prominently in these problems. Now, you want to come in as the leader of that court. You have this state organ, if I may call it that way. That's a problem, or that's not doing what it's meant to be doing. And you know that land issues are very much at the heartbeat of South Africa. And South Africa is a big place. It's a national court that you want to lead. Taking account of the size of South Africa and the land issues that crop up everywhere in the country, what do you think you can do as the incoming leader to light the fireworks under the Commission's bums to start doing their work, to make sure that this backlog that we read about that's staying with the Commission and causing you problems is addressed?
Thank you, JP. The Commission, as I see it, is facing immense challenges, many of which are resource related. In the Lamosa feedback sessions, we hear the Commission explaining how it's attempted to streamline its business procedures and the initiatives that it's taking to ensure that its business is more efficient. And I certainly, from what I've seen, I have no reason to doubt that the staff of the Commission are doing the best that they can in also extremely difficult circumstances. But that doesn't mean that there's not more that we can all do, and we all need to lift our game, I think, all of us. And what I see, so what I've seen in that engagement and what I've tried to do is to find the problems to which we can make constructive suggestions, and to explain how it is that the work of the Commission is impeding finalization of cases. So by way of example, we have one of the problems we face is incorrect gazetting of land claims. So a case will come to us that really should be enrolled and everyone wants to go, and we're in case management, and it'll come to our attention that the land in question has not been properly gazetted. And so that's something that shouldn't happen. That's something that the Commission really should be able to, I think, early on in its processes, pick up, do a verification check to see if land has been properly gazetted. So what we do is we raise this. This is an issue that JP Meir raised recently in an engagement we had with the Commission. And we've indicated to the Commission, if this doesn't happen, we can't move the cases along. So that was one example where we try to identify a problem and then try and explain to them this needs to happen in a constructive way in order for us to really finalize these cases. So that's the one example. Another problem we've had is with research. The research reports, there's been discussion around that. There's been discussion around the identification of landowners and how to contact them. So the best we can do, I think, is to try and engage with them. And that we have we have the ordinary channels of engagement between organs of state available to us. But we also now have the Lamosa judgment, whereby the Commission has to report to us, and we have to oversee that. So we are tasked now under constitutional court order to actively engage with the commission. So that I think is our best tool. And we use it I think it's on a quarterly basis.
My second question, DCJ, is from a judge support point of view, how are the land court judges placed in terms of support around them, secretarial, research, access to tools of trade? And is there anything that you think you can do as an incoming head of that court?
Well, the short answer is no, we're not adequately supported. But the challenge that we face, I think, are the same challenges that many judges are facing across the judiciary. So in terms of researchers, that's one of the issues that I've been trying to focus on. Secretaries, we're blessed with fantastic secretaries, and I think at the moment we're doing all right. As we get new judges, we will need new secretarial support, and then we're going to run into the budgetary debates. But on research, that's one way we need to really focus our attention. As matters stand, we're sitting with one researcher to service all of the judges, and it's simply not enough. We can't do our work, and we certainly can't do the historical cases project properly if we don't have people able to assist us with research support. So all of these initiatives that I think we all want to deliver on, we need additional support. So what can we do about it? At the end of the day, I think that the ideal solution, which the entire judiciary needs, we all need the same solution, is that we all need more researchers. That's just a fact. And I think we need to work very hard to ensure that across the judiciary there is more research support available. And the ideal way forward is that those researchers are employed by the department, within the judicial structures, and are committed to the judiciary, employed through the judiciary, and work full time for us. That's what we should be aiming for. But until such time as we can do that, and I think we all know that we're facing particular budgetary challenges at the moment, we are going to have to find creative solutions to address this problem. So I've been working on that also over the past couple of years. We piggybacked, for example, on one of the projects, JP, you'll be aware of this, one of the Gauteng projects with interns, and we were able to get 2 interns that came across to the court that helped us with the historical cases project. So I've engaged, what that points to is the need to liaise with other JPs through the heads of court structure to try and ascertain if there are researchers who have an interest in land work, who would be able to come and work with us, perhaps even for short periods of time. And if there are, this initiative in Gauteng, I think, where we got interns was very helpful. But I'm not sure how sustainable it is in light of broader discussions in that regard. But I do think we need to try and unleash, at the end of the day, we're going to be looking at the moment at voluntary pro bono type assistance that we can get. It's probably the only way that I can see, as I sit here now, to try and do some of the work that we want to do. And again, I'm thinking about professionals. There are professionals who would want to offer some pro bono assistance, possibly to support our historical cases project. And I don't foresee a difficulty with that in terms of independence of the judiciary. So we need to explore voluntary assistance. I have had some discussions with the Chief Justice around implementing a project along the lines of the Constitutional Court's foreign intern program. So I've initiated that as well.
Thank you very much, Judge Cohen. Thanks, DCJ.
Thanks, JP. Commissioner Mngwetho.
Thank you, Deputy Chief Justice. Judge Cohen, when you applied first to be a judge of the Land Claims Court, I think I either nominated you or supported your nomination. I can't remember which one.
You nominated me.
Nominated, yeah, so that's even better. So, but I just want to say, I mean, I've been thoroughly impressed with the level of industry and the number of judgments and the scholarship in those judgments throughout your time in the Land Claims Court, and just what's the correct English word? Prodigious. It's like really been incredible. There are many judgments. They are thoroughly reasoned and they are well researched. So it's not me who's achieved that, it's you. But I'm proud that I signed that letter, nevertheless. The question I wanted to ask you is on the one judgment that did get overturned on appeal, which is the Mereki judgment. Now, it's an interesting debate because the Section 6 of ESTA, which you relied on, defines consent as the consent to reside and to use the land. So it's both, it's residing and using the land. Now, what you have, you have this family which resides on the land for years and they keep cattle on the land. And then they die and then their children continue living on the land. Then the question that arises is whether they also have the right, the children now have the right to keep the cattle that their parents were keeping on the same land. And you find in your judgment, which on a pure statutory interpretation, you find, well, I don't have an express document that says I hereby give you consent, but I can infer from the existing facts that this was a tacit consent. And I do so also by looking at the purposes behind ESTA. Now you then get the SCA that makes 2 points. One point is that you had no evidence to make a finding of either express or tacit consent. And in fact, they say you should have stopped the analysis once you found that there was no express consent. And you had no right to look at tacit consent. When you look at the judgments they cite in the footnote on this paragraph, it's all judgments about contract. It's not judgments about Section 6 of ESTA. And consent statutorily for purposes of residing on the land. So that's the first criticism. And then the second criticism is they say, well, you can't transfer the right to keep cattle because it is a personal right. It's a contractual right. Once that right to keep cattle, once the person who held that right either dies or lives, that right is not transferable to their children. Now, both of those elements of that SCA judgment, they seem to fundamentally conflict with ESTA and Section 6 because they are drawn from a completely different species of law, and they now conflict with what ESTA seeks to do, which is it's to regulate the rights of people without formal title over the land, who get into the land either because they have to work on the land or because they have been employed, and then they have to bring their own cattle along because that's the only way to sustain. But you, in any event, have an explicit statutory provision that says reside and use the land includes grazing. Now, I don't want you to defend your judgment, but I think I just want a broad analysis of the kind of constitutional approach that you bring into your adjudication, because I was excited when I read that judgment. I'd written another judgment when I was acting there called Sibanyoni, in which I said, actually, land is cattle and cattle is land. And I see now they have been separated again, and I'm very disappointed. Anyway, just give us an analysis of your constitutional anchored approach to your analysis, because most of your judgments actually are trying to give effect to this constitution. So beyond the rhetoric and trying to show how it can be done.
Thank you,
Before
Commissioner.
the candidate answers, Commissioner Nkoitobi, I thought we had agreed that there'd be no long preambles to questions. So I hope it was very interesting, by the way. But
No,
I hope it doesn't
this
happen
was
again.
context.
Long context, including your expression of being happy that you signed.
Very,
you
very
nominated
pleased.
her. Judge
I
Kabo,
apologize, DCJ.
Before she answers, DCJ, I don't know how far Commissioner Nkoitobi can be able to see, but he appears to have read my notes. But just so that when she answers, she would have covered me as well, because those were just the points that I was about to raise. But there is this other one, because I had an impression that in that Mereki judgment as well, you were grappling with an inadequacy of the remedies available to people who inherit the cattle by virtue of them being children of the person who was staying on the land. Now, and you somehow found that Esther does not give a direct remedy to those people. Now, did you somehow think that there is a correlation between the inheritance arising out of the occupation of the land with, did you find that there is a correlation between the right to graze the cattle with the right to inherit those cattle?
These questions are enormously difficult, but can I start after thanking Commissioner Ngukai-Toby for the nomination?
Can you repeat that for the
last
TCJ?
Look, it is my first time being overturned on appeal. It happened last week. And I just wanted to start by saying that I think that, you know, as I see it, that's the system working, and that judges in my position need to see this as a dialogue between the courts. So obviously I'm disappointed that that I was overturned, but I see this as an opportunity to engage with the High Courts. We don't often get feedback, and so it's quite important to read what's said. That's the spirit with which I'm approaching it. The issue of grazing, as I've mentioned, comes before us often. And it's something that has caused me a lot of anxiety as a judge, because I don't think that the law currently caters sufficiently for it. I'm very aware of the Sibanyoni judgment, and I've cited it, I've relied on it often in how the connection is drawn between cattle dispossession and land dispossession in our history. And that judgment in turn refers back to the Constitutional Court cases on pound law, the historical pound laws. So I saw this case as an important moment to grapple with some of the problems that we're facing. I've written many cattle judgments with different themes, some of them around the rule of law, but this was about really an attempt by landowners to terminate the rights of cattle held by children who had inherited the cattle. The position, just by way of background, the judgment dealt with two things. The first thing I found was that there was consent, tacit consent, and I used not only Section 6, which the Commissioner Ngukai-Toby's referred to, but also the presumption which Parliament, the protective presumption of proof, which Parliament has put in place, which, as I understood it, counters the common law approach, which is what one finds in the footnotes to which the Commissioner Ngukai-Toby has referred. And the way in which I've been overturned, as I understand it legally, is it's on a question of fact, but by applying a presumption at common law, where I understood, or at least one of my legs of my reasoning was to say that Parliament itself in Esther gave us, said that when dealing with consent, after you have lived openly for a year resided openly for a year on land, you are presumed to have consent. Now that operates directly in contrast to the common law presumptions when one deals with proof of tacit consent. And it's against that background that one has to think about the facts. So the SCA indicated that in its view, I didn't have the evidence to conclude that there was consent. But as I saw it, these are children who had, before the proceedings were instituted, been residing on the property for some 4.5 years. I think I assumed it was not an issue that they had inherited the cattle. That was not an issue, I think. At the end of the day, I'd have to go back, but I think that was the case. And so I saw this as a case where the onus, in fact, was on the owner, that having regard to the statutory overlay on the common law that Parliament has seen fit to impose, Parliament has, as I saw it, has effectively altered the common law in accordance with the Constitution in order to protect precisely to protect rural occupiers. And that's the interpretation that I gave. And I did give a generous interpretation, which I motivated in the judgment and which I understood to be in accordance with the Goedgelegen case. But I have been overturned, and there is a line of common law, there is a line of jurisprudence in the SCA at the moment which binds me and which I apply, which holds that cattle holdings are personal in nature. It's a contractual right. It's not a statutorily conferred right. So I'm bound by those authorities. We have to apply them in our court. And in this case, I saw it as an opportunity to really say, well, that doesn't mean that you don't have any protections under ESTER. The Constitution requires us to look at tenure security in a certain way. That history, the history of cattle dispossession, is intimately linked with the history of land dispossession. And I interpreted ESTER in a way that was protected. I gave a generous interpretation that I thought served its remedial purposes.
No, thank you, Mr. Chair. I absolutely have nothing else to say. I mean, I do want to say one more thing, Judge Cohen.
Is it a question, Commissioner?
No, it's not a question at all.
Only questions allowed.
Yeah, it's just another compliment, but I'll keep it for later.
Okay, you can pay the compliment now that you've already taken time on this.
No, I was just going to say, Judge Cohen, I mean, I hear your reticence about it's too early to make yourself available for the position. But the fact is you are doing the work and there's no one else doing the work at the moment. And it's a difficult work, you're not being paid for it. And you're trying to assist the acting judge president in a difficult court to do important work. And that's something that I think counts in your favor. And so I don't think you should be as reticent about coming here too soon, because not many people are actually in your position where they are on the saddle as we speak.
Well, I'm happy to serve. I'm here offering myself for service. That's what I'm doing.
Can I make a follow-up compliment? It's really about your high court judgments, Judge Khan. I find them incredibly clear and well written and concise, and I've cited them, and just to commend you on them. Your expertise does go beyond land. So thank you,
Commissioner.
I don't know what's going to happen going forward now that you've set this dangerous precedent. Commissioner Singh?
Thank you very much, Deputy Chief Justice. I think Commissioner Dodovu and yourself asked the question that I was going to ask on experience compared to some of the other candidates we have. But I just want to follow on Commissioner Torby, in that, he says to you that, well, you may have limited experience, but you've done a lot of work, which we could see you've done a lot of work. But perhaps the acting JP can answer that question of whether others were given an opportunity to work with her as closely as you did. It'll be left to the DCJ to see who answers that question. Thank you.
All judges of the court are given equal opportunities to participate, and some do and some don't. So it's not as if, certain people are selected. We're a court that acts on consensus. We have meetings regularly with judges, and some take initiative, others don't.
Any further questions, Commissioner Singh?
Yeah, well, I don't think the question has been answered adequately. Perhaps later on we could ask the JP, who are those that don't take the initiative, when we are deliberating. So that will we'll be more informed. I think that will be a better way to handle it. Thank you.
Commissioner Mangena, you already had your turn.
I'm adequately covered.
Okay, thank you. I see no further hands in the room. Any questions from the virtual platform?
No, thank you, Deputy Chief Justice.
Thank you. All right, Judge Cohen.
Thank you.
This is the end of your interview. Thank you so much for the hard work you've put in that court. Let me add my own compliment. And thanks for making yourself available.
I enjoy doing it. Thank you.
Good evening, Judge May.
Good afternoon, DCJ.
It is evening. It's dark outside.
Yes, it is.
How are you?
I'm well, thank you, DCJ.
Good. Are you ready to start?
Yes, I'm ready to start.
Thank
Thank
you.
you. Good afternoon, good evening, Commissioners.
You have 3 degrees under your belt, a BA, an LLB, and an LLM. Right?
Yes, I do.
Mm-hmm.
The BA is from UCT, LLB is from UCT, and the LLM is from UWC.
Mm-hmm. You did the first 2 at UCT?
Yes,
And the other one at the Western Cape?
yes.
Okay. And I see that your thesis aligned with some of the work you do now as a judicial officer,
Yes.
being a Hague network judge, but we'll get to that.
Yes.
Not many people, well, not many judges I know for a fact have this kind of expertise on the bench. You started your legal career in 1996 as a public defender at Legal Aid.
I did.
And then I assume that you did articles because it says here professional assistant.
So my articles, I did a year of as
Did your time as public defender count towards that?
towards my articles, and I did the evening legal school, and that counted for the remainder. And then I did, I qualified, I was admitted as an attorney, and then I was a professional assistant with Y. Brime and Associates.
But you didn't stay long in that job. You joined the Department of Justice as a family advocate.
Yes, I did.
And you were there for some time.
Yes.
And then went on to become, you started acting as a magistrate. That was in 2002.
Yes. So my dissertation coincided with the time that I was a family advocate, because that would also be in my area of interest with Hague abductions.
Yes. All right. Then you were permanently appointed as a magistrate in 2003 and worked your way through there, became a senior magistrate in 2019.
Yes.
But then, wait, I'm just trying to follow the chronology here. You were a senior magistrate in 2019.
Yes, I was.
But you had acted in the interim.
Yes. So whilst I was a magistrate,
acted as a judge, that is.
Yes, I was appointed as an acting judge in the Land Claims Court in 2009 for a period of approximately 17 months. And then I went back to my position as a magistrate. And I had acting stints in between.
Sorry?
I had acting stints in different courts in between.
That they've been in 2011 in the Western Cape, 2013 in the Johannesburg High Court, 2015 in the Free State High Court, back to the Gauteng Division in 2017. And you stayed there until your permanent appointment, finally in 2020.
Yes.
All right, I got that sorted out. Okay, and since your appointment as a High Court judge, you have worked at the LCC, or you started later?
So
I thought you were immediately seconded to that court.
no. I worked as an acting judge in the Land Claims Court, as it was then, in 2021 from April until July.
bringing your acting stint there to what, 20 months?
No, just 3 months.
All right. Have you, we've already mentioned your involvement with the Hague network work.
Yes.
When did you become involved in that aspect of judicial duties?
Sorry, Lisa Jack, can you?
When did you become a Hague network judge? When were you nominated to that position?
So I've been involved in that for the past year.
Or just for the
Yes,
past year?
I've attended conferences since the time that I was a family advocate, and I've attended the family law conferences in that regard as a family advocate and as whilst I was an advocate and as an attorney, and now recently as well. So I've had that interest and I've maintained that interest as well. And I've resumed that interest. So I've maintained that interest consistently in terms of being a network judge, in terms of being interested in children's rights, and in terms of being interested in vulnerable persons as well as land court issues.
All right. I see that you've written a number of judgments, some of them reported.
Yes.
Any of them written at the Land Claims Court?
So the first one was the Bapi Ring judgment, and the Farias judgment. And then prior to that, there was a further judgment.
I see that at least the ones you've mentioned, you produced during your earlier acting stint
Yes.
in the early 2000s. Have you written any since you were appointed as a
Yes.
permanent judge?
Yes. So I've written 4 judgments in the last stint. In April to July, there were 5 judgments that were written during that period.
Are those the ones you've listed as being reserved when you completed your...
No. Those reserved judgments have all been handed down. But the judgments in the Land Claims Court that were from April to July, those were handed down some time back.
Yeah. No, you just have not listed, well, as far as I can see, you've not listed a single judgment you've written since your permanent appointment in the Land Claims Court. That's what I was trying to clarify with you.
Oh, okay. So the judgments that I've written in the Land Claims Court are the Sibanyoni judgment, where I dealt with the calculation of cattle. It was a follow-on from a determination of Acting Judge Nkontobi. That was the determination of the... Okay, that was the determination of the value of cattle. Let me just get that, and I will tell you what it is now.
It's fine if you can find it, Judge Mim.
You can proceed and I'll give it to you shortly, DJ.
Sorry?
I'll give it to you shortly.
Okay.
We can proceed. So the judgments that I have written are the Petition Naransamy versus Ajay Vasaman, Eno and others.
I'm sorry, I'm hard of hearing. I'm struggling to hear you.
Okay.
Would you bring
So
the
it's-
mic closer?
There were 4. The Sibanyoni versus Holthausen and others. LCC 143 of 2015. Bhavisha Naransamy versus Ajay Vasaman, N.O. and others. The third one was the Papalar Borwa Bahaselwani versus Majeje Traditional Authority. And the fourth one was the Zimandi and 129 others versus the Director General of the Department of Rural Development and Land Reform and others. If I can go through those 4 judgments, DCJ. As I indicated, the Sibanyoni versus Holthausen, I determined the value of cattle that had been impounded, and it required the determination given the value over time. I determined that the applicant's expert was the expert to follow, and I awarded a sum having regard to the applicant's expert's determination. In the Bhavisha Naransamy matter, that was a matter where it came on review from the Magistrates Court, and the magistrate had evicted the occupier, and I'd set aside that eviction on the basis that certain procedural aspects had not been complied with, and the probation officer's report was problematic. The Palaborwa traditional or authority matter, just refresh my memory on that one. Okay, this was a dispute regarding the finalization of land claims between 2 communities. I determined that the dispute was not urgent, and in this particular matter, whilst the issue of cost is normally not determined by the court, I had granted a cost order, as both parties in the matter had successive land claims that had been granted, and both parties still had land claims pending and were both quite successful with previous land claims, and the litigation in this matter could have been resolved amicably. That was the position in that matter. And then the Zimandi matter, this was also a review of the settlement of a land claim. This one is a matter that, after the decision was taken, the applicants brought an application for leave to appeal, which I dismissed. But in this matter, the applicants were given grants in terms of the settlement land acquisition grants. They had purchased the land and through a trust. What had happened was that the trust had gone into difficulties. There was a liquidation application in the North Gauteng High Court. It wasn't defended, and the final liquidation was granted. Subsequent to that, there was a further claim to the same land. And when that claim was lodged, the beneficiaries who were part of the land distribution program sought to bring a claim to the same land. I'd found that they hadn't brought the review timeously, that they hadn't acquired the farm because the trust had acquired the farm, so they weren't beneficiaries in terms of that. And I had dismissed the I found that I dismissed the application, and I ordered that each party pay the cost because both parties, the applicant was pursuing a land right, and it was a constitutional aspect. With regard to what they were pursuing, I was of the view that given that they were legally represented, the issues that they were pursuing was something that was, even if they thought that they were adequately represented the first time, there were still parties who were, they were people of straw, and pursuing the constitutional right with regard to land, it wasn't appropriate to make an order with regard to costs. With regard to the appeal, I had dismissed the application for leave to appeal, and I haven't heard anything with regard to this matter further.
Okay. And these judgments you say you wrote during your recent stint at the court? Okay.
This was in October 21.
Okay. Have you played any leadership role in any of the courts in which you've sat, either as a magistrate or a judge?
So, for the period of February to December 2019 as a senior magistrate. During that period, as a senior magistrate, I had supervision over 13 judicial officers, and during that period, I was responsible for the allocation of judicial officers to a particular court. There were 4 domestic violence courts, 4 children's courts, 1 court that dealt with administration of estates, and 3 maintenance courts. And then there was 1 court that dealt with the criminal aspect in terms of the breach of domestic violence protection orders. And apart from the allocation of judicial officers to particular courts, I would also deal with the quality control of the proceedings. So once a matter was finalized, I'd have to peruse the proceedings to determine whether there was a procedural aspect in order to refer it to the High Court if there wasn't an appeal in the matter, or to deal with it in the weekly meetings to bring certain aspects to judicial officers' attention where it wasn't necessarily a matter to refer to for procedural review, but just to address issues of quality control. I'd also deal with training on a weekly basis, and then there were stakeholder meetings with different departments. So with domestic violence, children's court, and maintenance courts, we'd have stakeholder meetings with the prosecutors, Department of Social Services, the Family Advocate's Office, the SAPS, and Home Affairs, to work out how we could ensure the smooth running of the courts and how to deal with ensuring that the administration of justice ran smoothly. In addition to that, so I said we'd do training on a weekly basis. And then I'd also do reviews with the individual judicial officers to ensure that they were rotating within the different sections and to work out rotation plans so that they weren't stagnating in one particular section, but that they would work out a rotation period over a period of 2 years to ensure that they were gaining experience in different sections, and to ensure that they enlisted to attend training at the Judicial Education Institute, to ensure that wherever they felt that they required support, they would enroll for the particular training timeously so that we could make arrangements to ensure that there were replacements in the particular courts.
You acted as a judge president in the Land Claims Court?
No, I didn't.
Where did one of the law bodies say that you did? I think it's Nadel, so they're mistaken. I looked for it in your CV and I couldn't find it.
Nadel initially confused me with acting Judge President Mead, and then I brought it to their attention that there was an error. So, yes, they revised that.
A fair enough mistake to make.
Yes.
All right. Well, you have applied to lead this court. Are there any challenges that you've identified that would need you to address them? Any improvements that you would wish to implement in the running of the court? Just tell us briefly what your view of that court is and what you have in mind for it, if you are appointed.
Thank you, DCJ. So from the time that I've been in that court, I started when Judge President Bam was there, and my recollection, and I understand that Acting Judge President Mead has continued that tradition. It's been consultative, so I think that trend continues. There's consultation with stakeholders, and I think that what I think would assist during the time that I acted in 2021, it was necessary to deal with matters virtually, and I think that has taught us that that can continue, and I think that is a necessary step that will see us going forward. Now, I think that still continues to happen, and I think to the extent that the court still needs to be taken to the people, and to the extent that we want to make the court accessible. My view is that this is a court that lends itself to having case lines introduced. I recall us having files delivered and transferred to and fro to the courts and to judges, and I think that the digitization of this court is imperative. So having case lines rolled out, I think, is so necessary, and it would just facilitate the work. And then I think
Okay,
that...
sorry, before you move on, because I'm likely to forget, you mentioned the need for the court to go out to the
Yes.
people.
So let me first start with case lines, because once we have case lines, I think that it just makes it accessible for all legal practitioners everywhere. That's the first aspect. And then in terms of accessibility, the one experience that I had during the COVID period was that there were parties that needed to attend court but could not attend court, so we had it virtually, and they attended at one of the mining companies' offices. And I think that is one of the ways in which the courts can be rolled out in terms of ensuring that matters can be dealt with, not necessarily where the court needs to go out, but where matters can be dealt with online. Where I've had an experience in terms of making the court accessible, in the High Court we've talked about there may be a need to have proceedings made virtual in the same way that these proceedings are live. In the same fashion, court proceedings could be streamed live. So this could be done either in that it is dealt with where it is broadcast to a particular venue, or it is broadcast generally. So if it's a particular venue, that would be where a particular community is impoverished and doesn't have access to resources. But where it is general and there are resources, it could be broadcast, live stream, and people generally would have access. And the fact that it is live stream, it doesn't preclude, it doesn't necessarily mean that only a particular community has access. Any member of the public ought to have access to those proceedings because it is a court of public record. So the fact that it's live streamed means that everybody can have access at any stage. And I think that is important. So that is an aspect that I think is so necessary and would assist greatly, and takes the aspect of the way we conduct our courts forward in a particular fashion. The consultation with stakeholders, I think, would also just facilitate, in the way that I've consulted with stakeholders during my time in the district courts. I think the same kind of consultation and the way there was consultation when I was at the land claims court with Judge Bam, I think that also lends itself to addressing problems and ironing problems out. So I think consultation is necessary and that addresses issues. The challenge that...
Before you move on, can I just take you back to access to the court?
Yes.
Because I know I'm going to forget.
Yes.
The previous, I hear what you say about live streaming and about digitization, and I think we all agree with you about the benefits of that mechanism. But the previous candidate highlighted the importance of the court's ability to conduct circuit courts, to go out to communities and conduct proceedings there. And she lamented the fact that because of the current budgetary constraints, the court is not able or maybe hamstrung in that project going forward. Now, I wanted to find out from you if you agree with that observation, and if you do, what measures you would put in place to ensure that this valuable resource to our people is not lost.
I think the Minister has just indicated earlier this year that there are budgetary constraints. So in terms of that, and given that this issue of land is so fundamental, I think that in order to resolve this issue, it's important to ensure that these issues are dealt with, it's accessible, and people can see that it is being addressed. And for that reason, it's necessary to ensure that case lines is rolled out. It's necessary that people have access to the proceedings, whether it is in person or virtually, and that people are accessing proceedings virtually allows for people to realize that they can access proceedings. So I think it is necessary. I think going out to areas in certain, you've got to feel for the particular matters. And in some instances, it may be necessary to go to a particular area depending on a particular matter. It may just be that that particular community requires it. But in other instances, and you can get the feel for that once you've done the case management, and there may be an agreement that the matter is dealt with virtually and that it be live streamed and that there's sufficient access. And I think that can be dealt with on a case-by-case basis. And in that way, cost can be managed. But also, you can deal with addressing a particular community's needs while addressing budgetary constraints. So you're dealing with both aspects. I think it's important in some instances for communities to be able to have that actual contact with the court.
All right, thank you. I'm sorry I interrupted the flow of your presentation. You were still telling us about the improvements you think are necessary to implement in the court.
Yes.
So just carry on. What are the challenges, if any, have you identified?
Okay. So I spoke about having meetings with the stakeholders and addressing issues. I also think that in my experience, there was one researcher. So for one researcher was just overwhelmed with 4 judges requesting or making requests for assistance. So I think that also is an aspect that needs to be addressed. And I think that's the same challenge that we have in the High Court. But I think with this particular court, the issue needs to be addressed particularly because we want to have these issues addressed expeditiously. So I think that is an aspect that is also important, that the court is adequately resourced in order to fulfill the objectives. The other aspect is in terms of addressing all of the matters. I don't think that the current number of judges can deal with the number of matters. So my sense is that mediation ought to play a big role. And when I think about it, historically there were senior practitioners that dealt with matters, and I think that those practitioners ought to be drawn in to do a lot more training and to transfer skills to younger practitioners, whether it's in terms of skills building and in terms of mediation, so that there is that transfer of skills. I think that a lot more needs to be built on in terms of mediation and alternate dispute resolution. And I think that on an ad hoc basis, there needs to be more appointment of acting judges. And I think that the acting judge president has done that on occasion to address the issue of cases that needed to be attended to on an ongoing basis. And I think that that is something that will continue into the future.
Is there anything else you'd like to add?
And I think I've addressed most of the aspects that.
Okay. One law body, I think it's the Law Society, has expressed some misgivings about you ascending to this role at this stage. They think that you might benefit from an acting stint in a leadership role in this court. Would you like to comment on that observation?
I've considered the submissions made by the LSSA as well as another organization. I think it is BLA. I think that the submissions are something that can be considered. I think that when one has regard to the opportunities that are given for women historically, I don't know that women are treated in the same way that men are treated. One doesn't say, well, a man needs to be given an opportunity to act before he's appointed, and I don't know why there's a different standard for men and for women, and why the standard has been introduced now for women. When we transitioned, and it's been a number of years now, we are not a new democracy. It has been a long time that it has taken, and I think that we need to reflect on why we are still saying that we need to give women an opportunity to be trained, and why have those opportunities not arisen as yet? that is a question that we need to reflect on. And yes, when one has regard to the number of years that I've acted as a judge and the number of years that I've been a judicial officer, and one looks at the institutional barriers that one has to overcome, this just seems to be one more. And yes, there are candidates, but my sense is that when the first appointments were made and when my male counterparts were appointed, was there ever a condition that they act in the position first? And I don't know on whether that is a fair and a reasonable distinction that is made. So I consider that, but I think that there is an opportunity, and I think it must be considered in light of what I've submitted and have regard to the history where we've seen women being kept in acting positions for a very long time and not having been appointed.
Well, two other candidates vying for the same post are women. One now sits at the SCA, has long experience in the Land Claims Court, and acted as a deputy judge president for 6 months in the High Court. The other one, appointed to the court not so long ago, but she has written seminal judgments in that court and is actually doing the job of judge president in that court as we speak. Now, why would this commission overlook those candidates?
I'm not saying that the commission must overlook those candidates. I just think that all the candidates need to be considered.
Mm-hmm. Mm-hmm. All right.
One needs to look contextually at the candidates, the circumstances. I won't have the same social equity that one particular candidate has, and I wouldn't have the same opportunity that another candidate has. But yes, I have had exposure, and I think that all the candidates must be considered, and it's up to the JSA to decide.
Fair enough. Just for the sake of completeness, because I've raised this with your with the other candidates, you have done a lot of work in the community, particularly in the Women Judges Association, the SAC IWJ, and
Yes.
in Nadel as well. And you mentor young people.
Yes.
Mm-hmm.
Yes, I have. So in Nodal, initially, I was on the management and executive committee, and that was really a mentoring of the leaders in Nodal for me as a young woman before I joined the judiciary. So that was a learning experience for me, and that I bring to SAC IAWJ. And then my longest period has been with SAC IAWJ, and I've served in various positions as the secretary, as vice president programs, and back again as a provincial coordinator. And yes, mentorship is an important aspect, and it is, at the moment, there is a program focusing on mentorship of students as well as mentorship on a wider scale of judicial officers and women in the legal profession generally, that is running with the LSSA and UJ and SALA. So yes, that is an aspect that needs to be addressed in terms of leadership, building leadership of women in the judiciary, women in the legal profession.
Thanks, Judge Mayor. I'll now hand over to the acting judge president of the Land Claims Court to put questions to you if she has any.
Good evening, Judge Mia.
Judge Mia.
Can I just ask you, I have one question for you. Barring your involvement in the IAWJ and your mentoring role, which you've just spoken to us about, can you tell us about, point to specific activities you've engaged in as a judge, which stand you in good stead for the leadership position you have applied for?
So it would be my period as a senior magistrate.
I'm talking about as a judge, since you were appointed as a judge.
So I think by virtue of being a judge, one cultivates the opportunity to be a leader, generally in dealing with the role. So yes, I think that does cultivate leadership skills.
No further questions.
Thanks, AJP. Commissioner Marumake?
Thank you very much, DCJ. Good evening, Judge.
Good evening, Commissioner Marumake.
I want to talk to you about a judgment that you just referred to us now, Sibanyoni versus Holt Hazen. That's the one that you just told us that you delivered at the Land Claims Court. You remember that judgment that was dealing with those 6 cattle?
Yes.
Yes. In paragraph 2 of that judgment, you state the issues that must be determined. But I want to take you to paragraph 9, where now you are dealing with experts. I just want to understand, in the context of this judgment, based on the issues that you said they ought, were issues that ought to have been determined in the judgment, as to in what exactly were the 2 experts that you were dealing with expected to give evidence on? That's the first. Secondly, how did you determine that these 2 experts, for both the applicant and the respondent, were experts? And just to give you some guidance as well for the question I'm asking, when you look at the applicant's expert, you are saying that this person has experience in agriculture and livestock production, and that he went to in his primary and secondary, he studied agriculture, then he became a lecturer and a principal. But it seems to me when you go down, you're talking about now diseases, foot and mouth disease. It is not clear to me as to in what exactly was this person an expert on, and was this person, because what follows next is determination of the cattle as to how much they weigh and how much they cost. So I'm quite, after I not read it in depth, I just browsed it through now, and I just want to be fair to you, just to, because you don't even, it doesn't seem to me that you set out the test for an opinion evidence and how you go to an expert and all those. So I'm quite confused as to how you came to a decision that this person was qualified to assist you, but most importantly, assist you in what? That's what I'm concerned about. But if you don't remember the facts, it's fine.
Now, I recall the facts. So, as I said, the previous determination in this matter was that there were 6 cattle and the value of the cattle were to be determined. The sum of compensation for the 6 cattle were to be determined. And the second aspect was that the parties, this had been agreed, that the parties would file reports in that regard. So the applicant filed an expert witness and then the respondent filed an expert witness. The applicant's expert witness summary was filed, and the respondent didn't file an expert summary witness, a summary statement. There was an objection when the matter appeared before me, and that is why I addressed that particular issue in terms of the background, and I compared the background of the 2 experts. The applicant's expert, I gave his background in terms of why I believed he was an expert and why he was able to tell me about the cattle. So when you are determining the value of the cattle, you need to know what type of cattle it is. And because these cattle were impounded, there was an assumption that they wouldn't be cattle of value according to the pound master or the auctioneer. So the auctioneer was called as an expert. The auctioneer was a legal practitioner who had been running an auctioneer's business for
But
some
that is
time.
for the respondent, right?
For the respondent.
Yes. I was more concerned, I mean, that can be a question on its own. I was more concerned on the applicant's expert, yes.
So the applicant's expert was trained in agriculture in terms of raising cattle, in terms of dealing with, so one of the aspects was if the cattle had disease, then there wouldn't be value. But if there wasn't disease in that particular area, it wouldn't affect the value of the cattle. So the suggestion that that would reduce the value of the cattle because it belonged to a tenant, that was introduced as an argument. And the applicant's expert was able, because he had knowledge in the area, and he traveled around in that area because he worked for the department and he was required to visit farms in the area. He had knowledge about whether there was disease in the area in that particular year, and he was able to indicate that there wasn't disease, and that is why he believed that the cattle were not tainted or they were quality cattle.
Okay. No, so sorry, can I just follow up on this? Yes. I sympathize with that, but I think my concern is I don't feel like it's being addressed. Let me ask you a direct question.
Yes.
What is a test that you use to determine that a particular individual, because opinion evidence, I mean, it goes like this, it's either expert or lay,
Qualification.
and there can be something in between where somebody, like maybe a traditional healer in a village that did not study anything, but has, through experience has gained expertise and all those kind of things. So, because I just want to understand, what is then the test that you use to say this person is an expert and is qualified to guide me to come to a particular determination or understand the facts better? What is the actual test for because it doesn't seem like you are stating it. And I will leave it there, DCJ.
Okay, let me just have regard to this. I addressed it in terms of saying that the expert witness must have knowledge.
I'm sorry, Judge
about
Mia,
the
you're
particular-
speaking away from the
Oh, sorry.
mic.
I addressed it in terms of the expert must have knowledge about a particular aspect that he or she is testifying about. This particular witness did have knowledge and had qualifications, had studied on that particular area, and had experience in terms of practical experience after having studied in that particular area. So it was practical knowledge as well as experiential knowledge. So it was theoretical, practical, and experiential knowledge.
I'll leave it there, Judge Maya. Thank you very much. Thank you very much, DCJ.
Thanks, Commissioner Marumachai. Are there any questions for this candidate from the virtual platform?
No, thank you, Deputy Chief Justice.
Thank you. Judge Me, we don't have any further questions for you. Do you want to ask us anything?
No, I'm good. Thank you, DCJ.
All right, thanks. Oh,
Thank
I
you,
forgot to
Commissioners.
apologize to you earlier for keeping you waiting.
No problem.
Please forgive us, and thank you so much for making yourself available for this vacancy.
Thank you,
You're
DCJ and
excused.
Commissioners. Yes, please.
Good evening, Judge Nobe.
Good evening, DCJ.
Are you well?
I'm very well. I'm very well.
Are you comfortable?
Thank you. Yes, I'm comfortable.
All right. Oh, let me first apologize for keeping you waiting for so long and interviewing you at this ungodly hour. I know I've been subjected to this torture of being interviewed at night. I know it's unpleasant, but please bear with us. I promise we'll be gentle with you just to make up for that.
No, it's understandable.
You hold a number of academic qualifications, BUris, LLB, LLM, and a diploma, which you've abbreviated, but it looks like a diploma in environmental law.
It is, yes, it is. It's Diploma in Environmental Law, which was actually changed into Masters.
Yes.
Yes.
And you did the diploma and the master's at the University of Natal,
Yes.
having acquired the first two at the University of Zululand.
Yes.
Your journey in the legal field started in 1982 already, when you joined the Department of Justice as a court interpreter.
Yes, in 1982. Yes, started as a court interpreter in 1982, only appointed as a magistrate in 1986.
But you had worked, you became a prosecutor in
Yes,
between
in between, I became a prosecutor.
for
yeah.
2 years. Then you rose to regional magistrate, but did not stay long there. You were there for a year.
Yes, I think it 2014, 2015. Yes, 2014, I was appointed in
Yes.
2014 as a regional magistrate.
And you started acting as a judge in 2016 until your permanent appointment in late 2021.
Yes, in actual fact, I started acting as a judge at the Land Claims Court in 2006 during the time of Judge Palm. But it was on and off. 2006, I acted 2007, 2008, 2009. But in 2016, then I acted continuously until I was appointed.
Okay, your questionnaire is not very clear on this, so I was going to deal with your acting stints in silos. So you say since 2006,
Yes,
you've acted in the Land Claims Court.
yes.
Now, until your permanent appointment, for how long had you acted in that particular court? No, not in the High Court now.
Until my permanent appointment, I acted since 2016. Then I acted continuously for 5 years until I was appointed.
And you have written judgments in that court.
Yes.
How many? Can you remember? Is it a lot?
A lot of them. I'd need a trolley to bring them here.
Any of them taken on appeal successfully, unsuccessfully?
Yes, at least there were two which were taken on appeal, where my judgments were upset. At least two, but about 5 were confirmed.
So your truckload remains almost intact.
Yes. I'd say
Okay.
so.
Have you played any leadership role in any of these courts? Magistracy, in the Land Claims Court, or in the High Court?
Yeah, with me, I would say that I come from the era where the magistrate, as the head of office, was actually in charge of almost everything. When we were doing agency functions, we were doing home affairs work, we were doing revenue work, paymaster general's work, we were registering cars, we were doing almost everything. We were paying pensions, we were paying wages for health workers, almost everything. And we were supervising all the clerks at the office, we were supervising all the prosecutors at the office, almost everything we were doing there. We were writing reports on all of them, on all members of staff. And then I also became the second in charge. I became a second in charge for about 2 years. Then I became the head of office. The head of office, I think it was for about 7 years. And I was in charge of the area cluster. I was the area cluster head, in charge of about 7 magistrates who were under me. I was writing reports on them. I was checking their work. I was doing training inspections on their work. And I went down to Durban in 2000. I worked with the chief magistrate, Mr. Mabaso, and we were doing case flow management with him. And he made me to write the reports, case flow management reports,
we would collect reports from all the other area clusters, and then I would write the single report based on the reports which I received from the other area clusters. And whether I was the area cluster head or sub-cluster head for Mlazi, I continued with that function of writing reports on them and doing all the administration, judicial administration, as well as other type of administrative work.
Have you played any role of such responsibility in the Land Claims Court?
At the Land Claims Court, I have not acted at the Land Claims Court. Well, I think we all know that this is the type of work which you cannot just volunteer to do. It is the prerogative of the JP to appoint a person to act. You can't volunteer to act. But yes, with the experience of the acting experience or the experience being the head of the court, which I have, I think I have enough experience in leadership position.
All right. Are there any challenges that you have identified in the manner in which the court is run, or in any area that you think might require improvement to beef that court up? In other words, I just want you to tell us just briefly what your view of the state of that court is,
Yes,
and your vision for it.
Yeah, no. I think that the first thing which must be done there is to sell the court. That is the first step, is to sell the court to the public. We must sell the court to the people, because many people do not know the court. They do not know what work is done there. And many people, more especially people from the rural areas, do not know how to access it. They don't know how to find, where to find it. So I think the first thing now, or the first problem, or the first thing which must be done, is to sell the court, either in cooperation with the Department of Justice or in cooperation with the Department of Land Affairs, in the sense that we must start maybe advertising it in the form of maybe can be pamphlets which can be distributed. I think many of us will remember at the time when land reform legislation came into operation, when we started working with land reform legislation, the Department of Land Affairs used to publish certain pamphlets and where things were explained, who is the occupier, labor tenants, and all those things were explained in those pamphlets. I think now we need to revive that system. We need to revive that thing and let the people be aware of the court and what the court can do for them, because this is their court. That is the first thing. I think the second thing is to strive by all means to let people access the court. Justice to the people. We must take justice to the people, not people to justice. But we have problems then of money. Many departments do not have money. But I think we must try to minimize where we can minimize and try to meet the people where we can meet the people. I think there's no way in which we can avoid going to the people. Despite the fact that we do not have sufficient money, but there is no way we can avoid going to the people so that people can see the court coming to them. Insofar as traveling is concerned, maybe traveling expenses, if you have got a relative that side, you may arrange with a relative to stay with the relative so that you minimize the cost. Or we can just come up with something and to see how we can assist the people to access the court. Well, I think in terms of the Land Act now, the minister will be able to appoint a certain place where, in terms of section 24, a certain place where we can hold the court so that the court can be closer to the people. But the problem will be the budget. But as I've said, if we are actually willing to go to the people, you can't imagine the excitement people have when they see the court coming to them. When we go out for inspection in the far-flung areas, you can't imagine the excitement they have when they see that the judge is here, when they take you to sugarcane fields, when they point their graves or they point their relatives' graves in the sugarcane fields, when they blow their trumpets, driving their cars into the sugarcane fields, pointing at their graves and pointing at the remains of their homesteads there. You can see these people are actually excited that the court is here now. So today we are getting back our land. So I think that is the function that is something which we must try to do. And also we must try and instill confidence. We must try and instill confidence in the members of the public that the court is actually working for them. I was doing an inspection in local somewhere there in the northern Zululand. And when I asked this old lady, so how did you leave this place now? How did you leave this place? Because she was showing me the homestead where they were staying. How did you leave this place now? And she said, no, we were chased away by the whites. They came here with dogs. We were bathing here. They came with dogs and they called us, come. Go over the mountains and stay with other baboons. Now you see that if there's still that mentality in their minds, now if they see a judge coming to them, they think now, today, the land is coming back. That is why they start blowing their trumpets and carry their shields when they go to show you these things, the remains of their homesteads and all these things. So I think that is the vision I have. First of all, is to sell the court. Having sold the court, must make sure that we take justice to the people, not that people must go to justice. And thirdly, we must instill confidence in the people that actually this court is working for them and that it is going to assist them to get back their land, which they believe was stolen by white people.
Anything else you want to add? Have you finished?
No, I'll stop there. I think that is the most important thing which we must do for this court.
Thank you, Judge Nobe. I'm going to hand over to...
I'm sorry.
There's more.
I'm
Carry
sorry.
on.
I'm sorry.
This is your moment to...
Yes, I have also realized that sometimes we work with the magistrates. We work with the magistrates. We do their reviews. We look at their matters. We review their matters, and sometimes in our judgment we criticize them. But there's never been a time when we tried to empower the magistrates. We have empowered the other stakeholders. We have empowered the attorneys who appear before us. We train them, but there's never been an occasion when we organized maybe a workshop for magistrates where we could tell them how to do things and where we could tell them where they go wrong. I think that is another thing which we must try and achieve when we are going to work for this court. Thank you.
Thank you, Judge Nobe. AJP Mir, do you have questions for this candidate?
Yes, I have two questions. How would you achieve your vision of taking the court to the people, given the budgetary constraints which we face?
Yes, as I have said, I think we have relatives everywhere. We have relatives everywhere,
We can try and get accommodation wherever we can get accommodation. If I have a brother in Zululand, I can arrange with my brother to sleep at his house and avoid paying for the hotel.
No.
If I need transport, we have cars. We can drive our cars and go there and make sure that we are visible to the people. We must try something. So we can't just sit back because we say there are no funds, but we must try and do something.
Judge Ngube, but that doesn't cover our airfare costs, which you know are considerable when we have to go there as well. I'm talking about the very real challenges we face. It's not just a judge traveling and staying at a relative's house. There also, we travel with staff. We have to arrange venues, sometimes which have to be paid for when magistrates' courts are not available. So I'm really want you to engage me in how your vision would operate, taking into consideration the very real challenges we face with regard to budget.
Yeah, no, I think in case of venues, in a venue, we must make use of the magistrate's court because we don't pay at the magistrate's court, we don't pay for the venue. So we have a venue at the magistrate's court. We have arranged a venue. The acting JP will remember that we have arranged a venue at Camperdown, which we can use free of charge. Those are the venues we can use. More especially the magistrate's court, yes. I can only say the magistrate's court are the venues which you can use free of charge, which you cannot be charged for using them.
Thank you for that. Do you have any thoughts on how to deal with the bottlenecks caused by the Commission not being able to process particularly the old order claims?
I think there we must engage the Commission. We must have meetings with the Commission and ask the Commission to come out clearly and tell us what are the problems which they are facing and see if we cannot assist them in a way in order to solve those problems. I looked at the report, the latest report, which they compiled in January 2024. Well, I think there's a certain element of exaggeration. There's a certain element of exaggeration because if they say for them to finalize those claims, they will need 30 years and they need 172 billion rand. No, I think that is an exaggeration because that report is based on 6 months basis. 6 months basis, and 6 months basis, they were able, according to the report which they filed, in 6 months' time, they were able to finalize 163 matters. At the present moment, they say they are remaining with 6,139 matters. Now, for 6,139 matters, why is it going to take 30 years? Why is it going to take 172 billion rand? I don't believe it. There's an element of exaggeration, and I think if we can engage them and ask them to tell us their problems, we will be able to assist them to resolve these claims sooner than 30 years, which they project.
Thank you. No more questions from me.
Commissioners, on the virtual platform, do you have any questions for this candidate?
No, thank you, Deputy Chief Justice.
Oh, thank
Nothing
you.
to say.
Commissioner Dodov, I'm sorry, I didn't see your hand.
Yes, I understand that. It is very late, this is. Good evening, Justice.
Good evening, sir.
I can see that you ooze with confidence, like you did when we interviewed you in 2001. And just looking at your profile that you started as a prosecutor in 1983.
Yes.
This is the year that our Minister of Justice was born. And I just looked at my back. I'm sure no one of them was born by that time when we became the prosecutor. It's been a long journey.
Yeah, it's a long time.
Now, when we
Commissioner
interviewed
Dodo,
you,
may we please have questions
yes,
for the candidate?
I'm just rekindling the spirit. When we interviewed you 3 years ago, you were very firm about issues of sustainable development and environment that must be integrated and encapsulated within the land issues themselves. What has been your experience since you were appointed as a judge to date in relation to those particular issues? What are your practical experiences? And taking this forward, what do you think can be your contribution in resolving the disputes or adjudicating the disputes that are before you as a judge?
Yeah, it's a pity that this environmental law field is a field which I think is a field which I could say people do not take it seriously. I don't know why, but the environment is very important. It is even entrenched in the Constitution in terms of Section 24. But it would appear that people do not take it seriously. In terms of sustainable development, we are looking mostly, we are looking at the people themselves to try and bring the cases forward. We don't normally get these cases. Since I started as a judge, there've never been an environmental case which has been brought before me. But as I said last time, we rely on the people to take the matter forward, to report environmental degradation to the police and open criminal cases, because there are criminal acts which are perpetrated by people. For instance, in the mining fields, we find that the mining company will come there and do the mining, and they leave everything open. They leave the holes there, which can injure people, and they do not rehabilitate the land.
No, it's okay. It's okay. You answered me because you're saying that you've not dealt with such issues since you were appointed. Thank you very much, decision.
Commissioner Club?
Yes, thank you very much, DCJ. Good afternoon, good evening, Judge.
Good evening.
Thank you. I've come across land disputes in the area of Amakhosi, traditional areas, that are neither land restitution nor ESTA related. And I'm sure you are aware of such cases. And I come from the province where about a third of the hectares are under Ingonyama Trust, for example. How do you see the jurisdiction of the land court extending to those areas?
Well, in terms of the Land Court Act, we have jurisdiction to decide any issue which arises from the application of that act, the Ingonyama Trust Act. So I think with that extended jurisdiction, maybe we can go back, as I've said that when I started talking, that we are from the era. We are from that era where we were even in charge of Amakhosi. In our offices, we had a land dispute office. We engaged with Amakhosi. We attended their meetings.
We advised them of what to do. We were able to engage them when there were disputes between different tribes. We were able to engage them. Now, I think this court must actually go that route also. If there is a dispute arising from there, this court must be able to resolve those problems. When they are brought before us, of course, we can't go out and assist them unless they are brought before us. But I think with that experience, we can be able to solve any problem which arises from faction fights. For instance, there were faction fights those days, so we had to go out and negotiate with Amakhosi, negotiate with the Zinduna, and I'm sure all disputes will be able to be resolved if you sit down with them. They are very patient people and they are very listening people. And if you sit down and talk Zulu to them, we say so, and talk Zulu to them, or talk to them and tell them to come up with the problems and try to solve the problems, there's nothing which can defeat us in that area. Thank you, Judge. Thank you, DCJ.
Commissioner Moimang?
Thank you, Chief Justice. Good evening, Judge Ncube.
Good evening, sir.
Just going back to the point that you raised about the exaggerated billions of rands that are estimated to be able to address the backlog. I just want to get a sense from you, given the recently passed expropriation bill, which makes provision in terms of Section 12(3) for the expropriation with nil compensation, and also saying that that could also be just and equitable, can be just and equitable to expropriate for nil compensation, take into account other factors, but more than that, amongst them is the the issue around the market value of the land, which is equivalent to or less than the present value of direct state investment or subsidy in the acquisition and beneficial of the land. So I want to check as to whether, from your understanding, can that be an answer to the concerns that has delayed and also contributed to the backlog in terms of land redistribution and land restitution? Thank you.
You know, the issue of expropriation with nil compensation, I think it is a big problem. To me, it poses a problem in the sense that I can't see any landowner or any farmer who will say, I'm abandoning the land. Because the bill says nil compensation or expropriation with nil compensation can be in respect of the land which has been abandoned. Now, I don't think farmers, knowing that there is such an act of parliament in place, will ever abandon the land. Secondly, nil compensation is for the land which is kept just to appreciate the value which we are not going to use for commercial purposes, and knowing the farmers, and the farmers knowing that there is such an act of parliament, I don't think they will ever just keep the land and do nothing with it. Those are the difficulties I have with this nil compensation, expropriation with nil compensation, because they read the bill. When the act comes into operation, they will know about the act, they get legal advice, and they know when their land can be expropriated without compensation. They know the circumstances under which the land will be expropriated without compensation, and they will try to avoid those situations. So to answer that question directly, I don't think it will be an answer to the problems we have.
David, let me just read to you what section 12.3 says. It says, it may be just and equitable for nil compensation to be paid where land is expropriated in the public interest, having regard to all relevant circumstances.
Yes.
That is an expressed intention of the legislature. If it is in the public interest and for public purposes.
Yes.
What is difficult in that?
Yes, but now
Thank you.
what I'm saying is that it also says the circumstances under which expropriation can take place, expropriation with nil compensation. So now I was narrating the circumstances, which the bill says those are the circumstances under which the land can be expropriated without compensation. Now I'm saying I don't see a situation where the farmer, because they mentioned the land which has been abandoned, or the land which is kept for purposes of appreciation and not for commercial purposes, and the other grounds which they mentioned under which the land can be expropriated without compensation.
Thank you, Justice
Ngube.
Thank you, Chief Justice.
I'm sorry. Okay. So I was saying the farmers will always avoid those instances where the land can be expropriated without compensation.
Thank you. My apology, Judge Ngube, for the interruption. Thank you, Chief Justice.
Thank you very much.
Judge Nobe, there are no further questions for you. That means we've reached the end of this interview. Is there anything you would like to find out from us?
No, there's nothing.
Okay.
Thank you very much.
Okay. Thank you so much for making yourself available for this position. You're excused.
Thank you.
All right.